And we're live. Good morning, everyone. Uh, State of Florida versus Curtis Reeves, the popcorn shooter. Um, yeah, so let's see how this goes. Just started. We're not starting up for another couple more minutes. So this is from day three. We haven't nothing live yet, so just hang tight. Uh, there's nothing there, so yeah, just it's okay. We're gonna get through this. Waiting for it to start, and yeah, we'll see what's going on. Good morning, everybody. Can everybody hear me okay? Yes, good morning, Eric. How you doing? All right. I'm gonna try something real quick and see if the audio plays because I'm using StreamYard for the first time. I think this might go a little better in Streamlab. Can everybody hear me okay? Or hear this okay?
For no reason. In other words, I went in and ratted him out. He was going to put it away. I wasn't going, it's right. And he turns around in his seat and let's get some music. And he says something about he was answering.
Sorry, I just went over and
You got it.
tried to go snipe people away from the long crime stream.
And he said something about he was. I don't know, if it was any of your fucking business, I was texting my daughter or something like that, and you stay the hell out of my face. I think that's when he said that. And his wife was holding back.
Good morning, Critter. Hope you are doing
I
well.
sat down, and I think I got the bag of popcorn from my wife, and suddenly he jumps up and he turns around and he stands in his seat, which was
all right.
so damn fast. And
Well, I'm not sure what's going on. It should pop up because I thought it'd be covered from here. A little frustrating. I mean, I don't want to give Long Crime the pleasure of having their thing up on the corner of the screen just because of the way they've been treating people like shit lately. You know. So let's see. It hasn't started yet. I know it doesn't start till 8:30. So yeah, if it doesn't pop up, I will do what I have to do. Good morning, Gabby. Hope you're doing well. Especially given how things were last time we were streaming. Yeah, guys, we're just waiting. Trial is not supposed to start till 8:30 ish. It's gonna be a little while. I'm looking on a long crime stream. They've got the feed up and nothing's happening, and I'm surprised it's not showing dead space on this one. So I'll try to look for another stream maybe that might be a little more accurate. I was told like there's 10 Tampa Bay. Let's see here. So yeah, hey, how's everybody been doing? I've been a little busy, but it's good to see all you guys again. So yeah, I've had a. It's actually been kind of crazy lately. It's just been stuff going on every day. Things are pretty much back to normal where I'm at. I know somebody had actually sent me an email about how things were with courts and COVID around where I'm at, and it depends where you're at. In one county, they suspended all their trials until the end of February, so starting in March. Um, but everywhere else, it's been pretty normal. Some courts are making you wear a mask here and there, but at this point, everything's kind of calmed down. So let's see here. Ah, um, oh come on, this is not working the way I want it to. Sorry guys, I'm trying to get this going. Let's see here. Come on. I don't care about COVID being a constant crisis now. So, oh, I think we're ready. I think we're ready. Here we go. Here we go, sports fans. He looks like he's gonna sell me a fucking coffin with that kind of suit. Jesus. Like, I mean, you've had 8 years to prepare. I would have bought at least a week and a half's worth of suits. I mean, recycle them. The tie matches his jacket and everything, but that's some grandpa clothes right there. I don't know about you guys. I know some of you guys are probably grandparents, but well, if you're upset, I don't really care. I'm just saying that doesn't look good. Could have worn something better today. Yes, Gabby, he's stuck in his ways, like not using the phone during previews. Gotta watch those previews, honey. We'll know what to go see next. I did want to tell you guys, just so a heads up, looking forward to tonight. Yeah, I am looking forward to that. Um, Probably be about an hour or so, maybe a little longer. Um, I got to get ready for some things. I got a trial starting on Tuesday. I got to get ready for. Um, yeah, actually, like a legit no shit trial. Uh, Due to COVID, it's probably going to be the first one I've had in a year now. So that'll be fun. Um, so I'm not going to probably be doing a whole lot of work. I might get out a little video this week on the weekend, but that's probably going to be it. Yeah, I'll be working. I will do the stream next Thursday, but we maybe talk about my trial and how it went. But for right now, just want to give you guys a heads up. I've got that, and I've been working on a pretty big appeal for a guy convicted of manslaughter. So that's why you haven't heard from me as much as initially when I got started. Oh, my trial, is it going to be televised or streamed? Uh it's a guy for like 2.5 ounces of meth that he allegedly possessed. No, it's not going to be. And even if it was, I he's my client. I don't feel it. Even if it were to be televised, I don't know if I'd tell you guys. I don't know how I'd feel about that personally. No, this wouldn't be televised. This courthouse is generally open. In fact, I'll tip my hand this way. This was one of the judges in Ohio who, when all the COVID rules had come out from Governor DeWine back during 2020, this is like one of the handful of judges who said, LOL, nope, and shot everything down and revoked a lot of things in the county that I'm going to be in. So you can actually come to this courthouse. It's one of the few courthouses where it's been like no mask the entire time, and all the judges have been like no mask the entire time. So I'll just leave it at that. I don't feel it's my job to put his laundry out in the world any more than it is. This one's, you know what? It's not the strongest case in the world, but he's got a lot of, he's got a better shot than most people do. Um, so I don't blame him for wanting to go to trial on this. I think their evidence is kind of weak, but it's still a roll the dice at the end of the day. I mean, he's looking at up to 3 years in prison if we lose. And Matthew, I promise we'll talk about it afterwards. So, you guys, throw some questions in. Um, Gabby, if I end up getting that's the hard part is taking you guys along on things because, number one, I have a client, and I told you guys at the end of the day, I do this and I think it's fun to do and I enjoy it, but I can't. My real job is being an attorney, um, despite what some of my clients may think and what some people I interact with think. That really is my job, is to be an attorney. So I have to be careful with that. Confidence is, but more importantly, I think there's an ethical duty to make sure your client doesn't become a spectacle, um, for your own gain. You know, hint, hint, be Ivory Lamar. But I do think, I could be tipping my hand on defense strategies. A prosecutor could watch what I'm doing, and they might find out what's going on. I might disclose something I don't intend to disclose. So I would have to be very careful about that. And I don't, once again, for my client, I don't think that's fair. Everybody needs to know his business. I mean, yeah, sure, everybody locally might know it, but does the world need to know yet? No, because he's still innocent. And I don't, I try to be considerate of people, even if they're not my client in that regard. I think you guys might figure that out about me if you haven't yet. I try to err on the side of caution when it comes to some things. And for people, if I get Kyle Rittenhouse and things go crazy, yeah, that might be a little different. Oh, Gabby, I wasn't trying to be defensive. I just thought it was, some people might be asking, and I just wanted to lay it out. Also, this is dead space right now and dead air. I got to fill it with something. Gabby, I don't think it was killed because of popcorn. That's kind of the oversimplification. It wasn't because of popcorn. It's because he was in fear of his life, so he used deadly force. I think there's been a lot of great. I've been watching. I stream Law and Crime when I'm working or driving. The cross examination has been great. It appears he got struck on the side of the head. There's a big red mark. So what
Good
was
morning.
it?
We need to address anything before we get started?
So it sounds like
All right.
Curtis may have
Good.
used force because he got
I like
hit in
to
the
hear
head, not because of popcorn.
And Mr. Proctor's here?
He's outside.
Okay. Good. Hey.
Ready for the jurors?
Yeah.
Jurors in the courtroom, Your Honor.
Critter, that video would not be enhanceable. That was from 2014, and those cameras were probably 10 years old. That potato image is the best we're gonna get, especially with night. Oh yeah, Donna, these lawyers have been absolutely awful. It's a clunky trial.
Thank you, Deputy. Good morning, ladies and gentlemen. Were you all able to abide by my instructions during the recess?
His wife can't wait for him to go to
Excellent,
prison.
Thanks. Well, we'll get started. State,
I bet they've used that every time they've had an argument the
You
past
gonna
8
call
years
Mr. Proctor? Back?
over anything.
Sure.
You know, Curtis, I hope you go to prison over this.
All right, thank you.
I wonder if Marbles guy's going to talk this time. Well, sir, can you tell us what's going on right now? And I hate to make fun of him because I'm a fat guy with gray hair, but
Oh, yeah.
you know,
And,
I know it's
he-
something that
I'll
could drive me
remind him that
crazy.
he's still under oath. Yeah. You go ahead. Mm-hmm. He has. Morning. You're. I'll remind
gotta
you
close
that
the
you're
door.
still
Hold on,
under
guys.
oath. Oh, sorry. Thanks, Terry. Go ahead, Mr. Escobar.
Thank you, Your Honor. Good morning, Mr. Proctor.
Good morning, sir.
This will be good, though.
Mr.
Cross examination's been
Proctor,
good so
we
far.
left off with your last statement where you told this jury that you had probable cause based on a totality of circumstances to arrest Mr. Reeves. Remember that?
Yes, sir. Something to that effect. Yes, sir.
Okay. And so you would agree with me that that process requires the application of facts that you have learned in the investigation
Yes, sir.
from witnesses and from the evidence,
That's correct.
and applying the law in this case.
Yes, sir.
And so what is the law on justifiable use of deadly force, Mr. Proctor?
Objection.
Yes.
He's asking for him to make a legal conclusion or legal facts, and I don't believe that at this point, that's an objection I'd make. Now, as a defense attorney, I'm still asking that question. Maybe you'll get away with it, maybe you won't. But I do think that as a defense attorney, yeah, he should be able to articulate what occurred that he thought it was necessary to arrest Curtis Reeves at that time. Gabby, yeah, a lot of things are exposed. A lot of these witnesses from the state have been awful. This goes back to the whole Evangelina Clearman thing when she testified about her husband and she wouldn't give a straight answer and she was trying to church it up and lie and kind of hide the truth about what happened. I think I mentioned it in one of my videos. If you're ever on trial or you're ever a witness, if you're ever on trial, that's a different story. But if you're ever a witness in a case and you have to testify, don't try to, test a lie or shape things. Like if you know something happened, just say it. Because as you can show, I mean, we've seen so far, the defense attorneys have gotten these witnesses to admit, well, yeah, that's not what I said earlier. Yeah, clearly you're correct. And previously, they were like, oh, I'm really damn sure what happened. And now they're like, yeah, I know that didn't happen that way. Well, either it looks like you're an idiot or you're a liar. And neither one of those are good if you're trying to get a jury to believe you. So I do think that the defense has been doing a pretty good job so far. Is it going to be enough to save the day? I don't know. As of right now, though, I'm leaning towards not guilty just because it's on the state to prove, and I don't think they've done a good job proving it so far. Especially with the one officer, and he talked about, the red marks, the whole issue of like, oh, was he touching his eyelid or the side of his head? And that officer kind of got caught making shit up. I mean, he knew there was a deposition. He knew he took it, and he knew what he said. And he wasn't, he lied, I would argue. But yes, 10 minutes in, there's already sidebar. That happens. I mean, they take a lot of time in a sidebar, and that's up to a judge. Some judges are very short and sweet with their sidebars, like Judge Borowski would have flown through this differently. Some judges might be a little more different about it, but that's the neat part about these trials going on all over the place. You guys get to see how it is. Do I think this judge kind of did theirs a little bit? Sure, from my experiences, but once again, that's how she runs her courtroom, and I think a judge should be allowed to run their courtroom how they wish and how they desire, as long as it's consistent and within the rules that their Supreme Court sets forth. Um, but yes, this is a trial 8 years in the making. Everybody knows what's going to be asked. Everybody's had time to prepare. This has been really. Think about if you had a presentation for your job you had to give, and you knew exactly what it was going to be about, and you had 8 years to get it ready. I mean, you would have ran this a million times. You would be polished and ready to go. This has been pretty clunky. I've been very disappointed. I mean, I would say the Kyle Rittenhouse trial ran a lot more smoothly than this did. Um, given what's going on, this has not been. I've not been impressed. But I will say the defense has done a better job than the state so far. Cheryl, why did it take 8 years? So Curtis Reeves had a stand your ground hearing where the judge had to determine whether or not he was going to be immunized and dismissed from the case. Well, the judge found him not to have been able to utilize stand your ground. So in Florida and in many states, you can appeal that decision, and you should appeal that, because if you move on, you waive the right to come back to it. So he had the right to appeal. Well, appeals take time. I mean, an appeal itself can take up to a year, even if it's quick. So you have the appeal. All right. Well, it took like 2 years to get an appeal going. And in the meantime, the state of Florida changed the law. So that throws a wrench into the appeal, and they have to discuss that. And then the appeals court denied him. Well, then he appealed and saying, well, I should be able to do it now again. Well, that ended up taking a while. That got appealed. So you're adding on time at this point. Add into the fact that while that's going on, the rest of the murder trial has to be prepared for. Well, and then remember, from basically February of 2020 onwards, COVID happened. That shut everything down. I mean, trial courts are just now getting back to full running speed in some situations. So even in Florida, I'm sure that judge can dictate how she wants to do things. There are probably concerns for Curtis Reeves. He's an older guy. And also it takes a while. Murder trials are not quick. Kyle Rittenhouse's was very quick, but that was a very different situation. But 2-3 years getting ready for one is normal. So throw in some appeals, throw in a thing that basically shuts down courthouses across the country. You can get to 8 years very quickly. Did he break his hip? I mean, he could have. If he did, that's a long time to recover from. And given as old as he is, that could have killed him. That would have been very dangerous. Sandy, did they want to win? It's what I will tell you is, when you're in court, and it's something I've learned since I've been an attorney and I've been to law school, and I'm the first person in my family that I know of that's an attorney, even the extended family. So, Uncle Joe Jack down in Arkansas, I don't think any of his family's an attorney either. But when you use words mean things. When you say X, Y, and Z, it doesn't necessarily what that means under the law. So if it means a specific thing under the law and you're not saying it correctly, I'll make it look like you're incorrect. If I can look like you're lying, even better. That's all part of the game. It's wordsmithing. Also, if witness uses the words always or never, those are dangerous words, because you're telling me something always happens, or you're telling me something never happens. That's are you sure? How sure are you? And if I can show it happened, well, then you're wrong. Is it wrong because you're incorrect, or is it wrong because you're lying? So, and Sandy, that's their job, is to get up there and be aggressive. They're advocating. Their job is to say, these guys don't have anything. They ain't got shit to convict this guy. They ain't got nothing on him. So you may not like that, but that's kind of the business end of this. You know, I will say that the other part about watching a trial, everybody gets to see how the sausage is made, and is it pleasant? I mean, define pleasant in your own terms, but yeah, this is how it goes.
Now, Detective, from the very beginning, you weren't supposed to be assigned to this case, correct?
That's correct.
In fact, it was Detective Soto that was supposed to initially be assigned to this case,
Yes, sir.
and he was on the other end of the county.
That's correct.
And because of the time that it was going to take in order for Detective Soto to come, you were assigned to this case, correct?
That is correct, sir.
And you would agree, would you not, Detective, that you were only assigned as a homicide detective in one prior case dealing with self-defense
That's correct, sir.
prior to the Mr. Reeves's investigation?
Yes, sir.
Is that correct?
Yes, sir.
And
If you
would
guys won't
agree
play
as
nice, I'll
well
turn this
that,
car around.
You had
I'm
never
not
taken a
joking.
course dealing with the issue of self-defense and homicide.
Not a formal course, no, sir.
And you were really only somewhat familiar with the law of self-defense.
Yes, sir, that would be correct.
Now, Detective Aaron Smith was going to be the crime scene detective. Is that correct?
That's correct, sir.
Okay. And the crime scene detective is in charge of the crime scene.
That's correct.
That's a very important function, is it not?
No shit,
Yes,
he's
sir.
a crime scene
And the
detective.
reason that it's an important function is because in our system of justice, when you're out there, you're supposed to preserve all of the evidence, correct?
That is correct.
You're supposed to preserve the evidence for the prosecution, correct?
Yes, sir.
You're supposed to preserve the evidence for the defense,
That is correct.
and you're supposed to preserve the evidence for the community.
Yes, sir.
Because when an incident like this is investigated, you don't call the public defender's office and say, hey, come on over and join us so that we can likewise investigate the case, right?
That's correct, sir.
Okay.
That's an interesting point.
And you certainly don't call a private attorney like me, right?
No, sir.
Okay.
Very good point.
Now, Detective Aaron Smith was quite new in the homicide section of major crimes, correct?
That is correct, sir.
In fact, maybe weeks or days before, he was a detective investigating missing persons.
I believe he had been in that unit a month, 2 months in the unit.
A murder's kind of like a
But
missing
before
person.
that, he was investigating missing persons.
Yes, sir, which is was under the umbrella of major crime.
Okay. And so when he came into that particular unit, he was going to be shadowing you.
He had shadowed me, yes, sir.
Is that correct?
That's correct.
So if it was a month, he was shadowing you for a month.
Yes, sir.
And you knew, did you not, that Detective Smith had not even been to the homicide investigative course by that time?
I'm not aware if he had been or not, sir.
Now, when you first got there, and I'm going to give you a pad. May I approach your honor?
That's
So
fine,
because
sir. I
I-
have my own pen.
You got your pen? Okay. Just because if you need to jot down some notes, that'd be good. What time did you get there to the Cobb Theater?
According to my notes, sir, I arrived on scene at 2:15.
At 2:15, and what is that in military time?
14:15.
14:15. Okay, why don't you jot that down if we can?
Yes, sir.
Okay, and so you get there to the Cobb Theater scene. You don't know yet whether you're going to be assigned the case or not, correct?
That's correct.
And so you're kind of waiting around.
I see every single one.
I'm very sorry. Someone's put me in video. I'm very sorry.
you were waiting around.
Waiting around.
Yeah, you got there. You didn't know if you were going to be assigned yet. It took some time for that decision to be made.
Not really, sir. I met Sergeant or Acting Sergeant Harris and Major Corbin. As I was getting out of my vehicle, I saw them standing there. I pulled up next to them. We got out and we were talking about the incident.
Okay, and were you talking about the fact that Soto was on the other end of the county?
That's what I believe Sergeant Harris told me.
Okay, and so at some point in time in that conversation, a decision was made to assign you to this case.
That's correct.
Okay, and so do you know what time that was?
I do my first interview with Alan Hamilton at 1427.
Okay, so let's jot that down. 1427 is your first contact with Alan Hamilton, correct?
That's correct.
Okay, and so you didn't do anything between the time you arrived and your first contact with Alan Hamilton, other than speaking to the sergeant,
I received a briefing from them as to what occurred,
the sergeant.
and Major Corbin.
Okay, and so by this time you realized it, and where were you when that conversation took place?
With Harris and Corbin
Yes, sir.
in the parking lot.
You were in the parking lot. Is that where a command center had been set up?
Not at that time, sir, no.
Okay, well, did a command center get set up?
I don't remember, sir, that. I don't remember. I think they might have had a mobile command center there as I was leaving. I'm not for sure.
As you were leaving for the day?
Yes, sir. I was in and out, and that's one of the things I was not paying attention to.
Okay. So certainly you knew that there was a large force of police officers, correct?
Yes, sir.
And you knew the minute that you were assigned this case that it was now your responsibility to make sure that this case was investigated
Yes, sir.
properly.
Yes, sir.
And you had the awesome responsibility of making sure that the evidence was going to be preserved, that witnesses were going to be adequately interviewed, correct?
Yes, sir.
And that those interviews were going to be properly memorialized.
Yes, sir.
Okay. And so let me ask you a question. Before going to your first interview, which was a mere, 12 seconds after you arrived? Excuse me, 12 minutes after you arrived? You arrived at 14:15, Alan Hamilton, 14:27. I'm not great in math. That's why I became a lawyer.
12 minutes. Yes, sir.
12 minutes. Okay. And so within 12 minutes from you arriving, you are now going to be interviewing Alan Hamilton. And that took place where?
In the theater, I believe it was in the party room.
Okay. So you had to have some time, since you were talking in the parking lot with the sergeant. There was some walking time to get over to that theater, correct?
Just a couple of minutes. Yes, sir.
And then
I got to run the trash out, guys. I'll be right back.
Okay.
I forgot.
now, in order to do that, you had to walk through the lobby.
That's correct.
And you, as you walk through the lobby, you could see a bunch of people, patrons, lay people, congregating, correct?
The lobby was, they had a lot of people in the lobby.
And those people were not police officers, these were lay people, patrons of the theater.
There was some law enforcement in that group.
Okay, but the majority was lay people, right? Witnesses.
There were a lot of people, sir. There again, I didn't get a count on them or anything, but there were a lot of people in that lobby.
In those 12 minutes, did you go to the officers that were there in the lobby and tell them, hey, officers, this can't be. We got to separate these witnesses? Did you tell them that?
I know, sir.
Did you tell those officers, hey, officers, please, you need to tell these individuals not to talk to each other?
No, sir, I didn't tell them that.
You are quite familiar, are you not, with the issue of contamination, correct? Witness contamination.
Yes, sir, I am.
In fact, that was taught to you as early as your time in the academy, when you first became a police officer, right?
Yes, sir.
And what they taught you was clearly that you got to separate witnesses. Because if you don't, the information that's exchanged contaminates, right?
Yes, sir.
And not only does it contaminate, it may be wrong, correct?
That's correct.
And not only can it be wrong, but the person that's hearing it actually believes then themselves that they own it now. Correct?
That could be, yes, sir.
In fact, they start believing it and actually think that they're seeing it.
Objection, speculation.
Sustain.
So, in order to get to Theater 11, is that where you were?
No, sir.
What theater did you interview Mr. Hamilton?
In the party room.
Party room. And where's that at?
It's right inside the entrance
To the right or left?
to the right.
To the right. Okay, and so in order to get into that party room, you can see Theater 10, right? You can see the Theater 10 sign?
Yes, sir.
Okay. And you knew at the time that you were assigned this case that the incident had occurred in Theater 10.
That's correct.
And you passed Theater 10 and you didn't go into Theater 10.
No, sir.
Well, you knew that there were officers in Theater 10, correct?
Yes, sir.
You weren't going to do anything to contaminate the scene if you had gone into Theater 10, right?
That's correct, sir.
You knew the incident had occurred there, right?
Yes, sir.
You didn't know what evidence existed or didn't exist in Theater 10.
At that particular time, no, sir, I did not. I knew there was a popcorn and a cell phone.
Oh, so before you went into the party room, you're telling me and this jury that you knew that there was popcorn and a cell phone where?
On the aisle.
On the aisle. Did you know the measurements of that aisle?
No, sir, I do not.
Did you know the measurements of the seat?
No, sir.
Did you know the measurements from seat 9 to the seat right in front of row 9?
No, sir.
Did you know at that point in time what the lighting conditions were at the time the previews were playing?
Other than it was being dark, no, sir.
Did you know what previews were playing and how loud they were?
No, sir, I did not.
Now, previous to this particular incident, it had been at least a year before you had been to the theater itself. And I'm talking about the complex, correct?
That's correct, sir.
And in fact, you don't even remember, as you were there, you don't even remember that you had ever been in Theater 10.
Sir, I remember going into one of the theaters. I don't remember which theater number it was, but I remember being at that complex, and I thought it to be Theater 10 with the bistro.
You remember, page 52, demo, lines 16 through 18. Do you remember?
Judge, I'd ask for the date.
My apologies, Judge. I should have said the date. March 27th, 2015. You would agree, you remember the depot that you and I had on that date, correct?
I remember giving you a depo, yes, sir.
Okay, and you remember being placed under oath?
I do.
And you remember me asking you a series of questions
Yes, sir.
about this incident?
Yes, sir.
And you would think certainly that your mind was clear, or certainly you had a better recollection of the events back in 2015 rather than 2022.
Yes, sir.
You remember the following questions. Have you ever been in Theater 10? Answer. I've been to the Cobb Theater. I don't remember what theater I've been in. Were you telling the truth back in 2015 when I asked you that question?
Could we
Sorry, guys, I'm
I've
back.
never read that depo, even though at the end of the deposition, I asked to read before it was published.
Uh-huh.
And I've never had the opportunity to read that
Did
deposition.
you call the court reporter as you were supposed to?
Judge object, can we approach?
Yes.
That's interesting. I don't know why they wouldn't have let him see his deposition before. That's there's nothing wrong with making sure this person testifies accurately, but yeah. That was a very good answer. I just came in on the end of that. But yeah, if you know you gave a deposition, and you may have to defer to that. And I don't think he's making a bad choice there. Um, so Gabby, it looks like why are they focusing on the investigation itself? Yeah, Eric's correct. It shows bias. It shows that maybe they didn't cover their bases, kind of like with Theodore Edgecombe, except in this case, I think there's a little more weight to it. What didn't they do right? Why are they only focused on him? I think that's important. The guys who were coming in there to say, look, that right there, that's the bad man. Well, you should be allowed to question, well, are you sure it's the bad man? Were you doing your job right? It sounds like you may have screwed things up. So I think that's a valid way of looking at it. And sometimes if that's all you got, that's all you got. I wouldn't say in this case for him, that's all they have. But for a prosecution witness, especially an investigator,
Now,
there's only so much you can attack.
so you go into this party room, correct?
That's correct.
And Detective Smith, was he there already?
I believe so, yes, sir.
Okay, and so he was going to go into the crime scene.
That's correct.
However, you don't know, at least you didn't know in 2013, whether Detective Smith had ever been assigned as the lead crime scene detective in a homicide.
That's correct, sir.
So I'm sure that caused you to at least think, I've got to be careful. Because if he's never been assigned as the lead detective to a crime scene, he may need some guidance, right?
Sergeant Harris was there.
Well,
Yeah.
did you tell Sergeant Harris, please make sure that you go and speak to Detective Smith to make sure that he's got a real handle on this?
This crime scene was relatively, it was an in-depth crime scene, for lack of a better purpose,
How did you know? You weren't in there.
because I had been told that of the evidence inside. There was popcorn on the floor. There was a cell phone, a spent casing, those kinds of things. But it was not an in-depth crime scene. I had complete confidence in Detective Smith. I had complete confidence in my team to process the scene correctly. They had been trained in that. They knew their job. And I had complete confidence in them. I did not go into the theater to see those items on the floor before I did my interviews.
Okay. So now, before going in to do this interview with Corporal Hamilton, is that correct?
Yes, sir.
Okay. Corporal at the time.
Yes, sir.
You knew nothing about Curtis Reeves, correct?
I knew that he was an ex-Tampa police officer,
That's it.
that he was an older gentleman, and that he had been detained for shooting Mr. Olds.
You certainly didn't know about any extensive training that he may have had as an officer with the Tampa Police Department.
No, sir.
And you certainly didn't know that at one point in time, he was the commander. Actually, he started the SWAT team at TPD, right?
No, sir. He told me that, well, he didn't tell me about starting the SWAT team in with Tampa, but he told me that during his interview.
Well, no, that's further down. We're talking right now.
He's an
right
elite
before you go
operator,
into
the popcorn operator.
that little room to interview Corporal Hamilton. You didn't know anything concerning his extensive training that he had.
There again, sir, he had just shot a man. It didn't matter if he was law enforcement, if it didn't matter who he was. He had just shot somebody. And at that time, that did not weigh on me as far as needing that information. I wanted to gather everything that I could to present to the court. And at that time, I didn't feel the need to go into his background.
Okay, well, we're going to get into that in just a little while. And so now you go into this room with Corporal Hamilton, is that correct?
That's correct.
Okay, and what you told the jury during direct examination is that you go into this room and Corporal Hamilton was supposed to be an eyewitness, right?
That's correct.
Okay, and you knew he was a police officer, right?
That's correct.
And so you go into this particular room with Corporal Hamilton, and you decide that you're going to talk to him about this incident, but you're not going to turn on your tape.
At the start of the interview, that's correct, sir.
Well, it was about what? You spoke to him about 5 minutes off tape?
Yes, sir.
And so for 5 minutes, you're talking to him about this particular incident, and you told the ladies and gentlemen of the jury yesterday that you did that because you wanted to know what he was going to say.
I wanted to know if he was going to be able to communicate it to me in such a way that I would be able to understand it.
Well, who cares? You turn the tape on, you let him communicate whatever he wants to communicate, and now we
Judge, I
know.
object, he's being argumentative with the witness.
Overruled.
Detective, you turn on the tape recorder.
Yes,
You get it from the very beginning. If he's not making sense, then we know that maybe he's excited about what happened or he's concerned about what happened, but we get all of his words, right? There's nothing wrong with that.
Yes, sir.
You would agree with that. You want to get sometimes, many times, the emotions of the individual, correct?
At times, yes, sir.
And the uncertainties of individuals, correct?
Yes, sir.
Or sometimes the precise information from the individual, correct?
Precise information, yes, sir.
And so that's all captured by a recording.
Yes, sir.
And if you don't record all that, it goes out the window. Right?
Yes, sir.
And your responsibility in this case was not only to the prosecution, but your responsibility in this case was to preserve everything for this community and for the defense.
That's correct.
And you chose not to do that. Now, what you did was you got some kind of checklist. I believe you told the jury yesterday that you just, jotted down what he said, and then you were just going to go down that list, right? That's what you did.
It's not a checklist. I was taking notes as to what he told me.
And then you, in that interview that's recorded, you just go down and ask those questions that he already answered.
That's correct.
But you don't know how he answered them, what his emotions were, what his recollection really was, nothing.
The tape stands for itself, sir.
Well, that's the tape after the first 5 minutes.
Yes, sir.
Now, let me ask you this question. Did you have in front of you, before you started that interview, did you have a voluntary statement form that he had filled out, signed, and dated? I believe it's on page 2 of the report.
Yes, sir, I do.
And you had it in that room, correct?
Yes, sir, I believe I did.
And so you were aware, you read it, right?
I did.
Okay, and so you were aware that Mr. Hamilton had indicated that Mr. Olson was coming over the back of his seat, yelling at Mr. Reeves.
If I could review the written
Oh,
statement.
absolutely. Your Honor, may I approach?
You may.
I'm going to hand you what's been marked as Defense Exhibit Number 21.
Eric, you're supposed to kind of like do it as a conversation, look and talk and look and talk. That may not be his style. He may not be good at
So your
that. So it's
question-
probably a
Can
little
you
more.
Reword the, or do the.
He just
question
stares at
for
the
me?
jury.
So you were aware when you read that statement, right? Let me have it back and I want to do it verbatim so that we don't have any mistakes. You are aware that I observed a white male stand up to my right, lean over the back of his seat, and begin to yell something to the effect.
Yes.
Okay, and that's a valid objection. He read the report and refreshed his recollection. The attorney then can't necessarily just start reading from it. He can ask them, "Hey, did you say this?" "Yes." "Did you say that?" "Yes." But just going verbatim like that, almost as though the attorney's giving testimony. Hi, Road Dog. Um, yeah, is it safe here? I mean, I'm not going to steal your wallet if that's what you're asking. Um, uh, yeah, Eric, I understand it seems odd. It doesn't help. We don't have a picture from that part of the courtroom looking out so you can kind of tell where people are looking. But yeah, I think he's just, yeah, it doesn't look good. It looks weird. And for the jury, it's going to look weird when he's answering questions like this. Yes, yes, I exactly did that. Here's what I did the whole time. Looks really bad, but not everybody's good at testifying. It's even if you've been doing it a lot, some people suck at their job, parts of their jobs, and for this detective, it's being in court. He kind of sucks at. Well, Eric, it's phrasing it as a question, but also it's the officer's that guy's statement. You can ask him about the statement, and he has to talk about it. Um, and I think these guys are a little antagonistic at each other at this point too. That's not helping things. They're being a little catty. GD, I don't like the defense lawyers. You might not like them, but they're doing a decent job so
Statement
far.
that you had,
Yes, sir.
what were you aware of at that point from Mr. Hamilton?
That he had witnessed the shooting.
Well, and what had he witnessed? I'll put that in front of you so you can refresh your recollection if you need to.
We're gonna object, this is hearsay, Mr. Hamilton already testified, just going through the previous testimony with the different witnesses and.
He can refresh his memory with it, but
That's not hearsay. He can
So
refresh
what-
his
you can
recollection.
Look down if you like.
Yes, sir.
Okay. And so what did you know?
That he was at the Cobb Theater, that the movie had began. He observed a white male.
Your Honor, I think.
yeah. All right. I'm going to overrule.
Go ahead.
He stood up. The white male stood up, and according to the statement, he leaned over the back of the seat and began to yell something. "I'm trying to text my fucking daughter, if you don't mind."
Okay.
And then he observed him throw
Your Honor, I
a.
think.
Okay.
But I can have it move more if you want.
No,
Okay.
that was
Okay.
what we talked about.
Okay, so you had that before you even started questioning Corporal Hamilton, correct?
Yes, sir, I believe so.
And you would agree with me, may I approach you on?
You may.
You would agree with me that defense exhibit number 21, take a look at it, is written very neatly. Correct?
Yes, sir.
Okay. And so I think that on direct examination yesterday, you acknowledged that, hey, we really should be turning these recorders on from the very beginning, right?
Yes, sir. It did not, however, change his statement.
Okay. Now, you interviewed Corporal Hamilton with his wife present.
No, sir, I did not.
So his wife was not present when you interviewed Corporal Hamilton.
That is correct.
You're telling this jury then that the only time that Corporal Hamilton and his wife were present is when you were interviewing her.
That's correct.
Okay. Now, your interview of Corporal Hamilton was 5 minutes off tape, correct?
About that, yes, sir.
And 6 minutes on tape.
About that, yes, sir.
Okay, so let's put down now, we've got the time that you came in, 14:50, the time that you started Hamilton's interview, 14:27,
Yes, sir.
and the time that you ended that interview, which was
2:38, 14:38.
14:38. Okay, 2:38.
Yes, sir.
Now, after that particular interview, you go to interview the wife, is that correct, Mrs. Hamilton?
Yes, sir.
Okay, and did you interview her in that same room?
I did.
And you still had not bothered to go back into the crime scene or not even back, you hadn't gone, period, to the crime scene to go see anything in there?
That's correct.
And when you interviewed her, you likewise started that interview without turning the tape on.
Yes, sir.
And your reason for doing that was because of what?
I wanted to make sure that she could communicate in such a way that I could understand it.
Well, you would agree again with me that if you had that tape on from the very beginning, we would know possibly her emotional state.
Yes, sir.
We would know whether she was sure or not
Yes,
of
sir.
what she was telling you,
Yes, sir.
whether she was undecided about certain events.
Yes, sir.
And we weren't able to capture that because it wasn't recorded.
That's correct, sir.
Okay, and so after that initial interview, how long was that initial non-recorded interview?
Uh, 2:43 is when I started.
And you left the other one at 14:38, so at best 5 minutes if my math calculations are correct.
Yes, sir.
Okay. So 5 minutes possibly off tape and on tape.
I've got it here that it was, the taped interview was from 14:52 to 14:57.
14:52.
Yeah, 2:52 to 2:57.
Okay. So now, you get her statement in the same manner that you got the recorded statement, in the same manner that you got Mr. Hamilton's. Is that correct?
Yes, sir.
Okay. You had jotted down your notes and then you go through those notes, correct?
That's correct.
Okay. Now, clearly, in this particular interview, you had Corporal Hamilton there listening to what his wife was saying.
Yes, sir.
And you agree with me that violates protocol at the Pasco Sheriff's Office, right?
Yes, sir, possibly.
Okay. Now, when you went to go get Miss Hamilton in order to do this interview, where was she?
Out in the lobby, I believe.
And was she out in the lobby with a group of patrons that had gone to the theater to view the theater?
I'm sorry, sir?
Yeah, out in the lobby,
Right.
concession area. Was she in that group of individuals that had been in the theater during the time of this incident?
There again, sir, she was out in the lobby. I don't recall where she was at. She was near that party room. I remember there being windows, I believe, around that party room. And I sat looking out the window, and I did my interviews with them facing the wall, is how I recall it, sir.
But my question's in the lobby area. She was in the lobby.
Hey, if you guys can hear me, I am sorry. We just lost power for a second. I'm getting the stream back up. Share ad screen. So, can everybody hear me all right? Everything back? Yeah, the Halliburton weather machine's working overtime today out where I'm at. 2 weeks ago, 2 feet of snow, and
Sorry,
today it
Detective,
was
I know
50.
I do it constantly here on my table.
Yes,
I'm
sir.
like, my funny bone is ready to pop out.
I can understand, yes, sir.
Okay. So Detective, that's aggressive, right?
I guess it's in the way you would perceive it. We hear cussing and yelling all the time. That could be considered, I guess, aggressive if you wanted to term it that way.
And especially when you're leaning over the back of your chair and you're within, what, a foot, 2 foot of Mr. Reeves, that's aggressive.
There again, sir, that would be, it could be considered to be aggressive.
And you would agree, would you not, that when you're loud towards someone else, it has an impact on that person?
Objection, speculation.
Sustained.
It's 701.
What does that mean?
Approach.
The evidence.
Oh, I know what that-
Yeah, these guys are starting to get antagonistic, and the attorney rattled off a rule of evidence. 701 is the rule of evidence they're talking about. I don't know what Florida's rule of evidence is. Here, let me see. It should be the same because almost everybody mirrored theirs off the federal government's. Yeah, and it's just opinion testimony by a lay witness, and the detective's kind of giving his opinion testimony. So what are we talking about here, Little Miss? The prosecution's done with their case. I think I heard that. Defense isn't putting on a case, so rather than sequester the jury, the judge gave them the week off. Are you talking about in the serial killer case, I assume? Eric, yeah, this is a lot of sidebars. Sometimes that does, like I said, even with the Judge Borowski type, you may run into that issue. He's going to very much try to limit them, but there's going to be times when that becomes an issue. But do I think this trial could be handled and organized and run a little better? Sure. There's Jeff Bezos in his purple tie.
Detective, you would agree that at that point in time, you had this information from Corporal Hamilton?
Yes, Eric, it's a sidebar and a trial
At that
broke
point in
out.
time, you didn't know the distance between Mr. Olson and Mr. Reeves while he was being aggressive, right? You didn't know what the distance was.
No, sir. I did not know the measurements.
And you didn't ask Corporal Hamilton, can you tell me, was it a foot? Was it 2 feet that you were seeing? You didn't ask that, Corporal Hamilton.
No, sir, I did not.
And that last interview with Angela Hamilton on tape was 5 minutes.
That's correct, sir.
Okay, so let's. What time did you end with Angela Hamilton? Let's go there. Started at 14:43, ended at 14:57.
That's correct.
Okay. Correct me if I'm wrong. You arrived at 14:15. You started
Objection, Judge. Asked and answered.
trying to get the timeline, Your Honor.
All right, I'm going to overrule.
Yeah, it's kind of shitty.
I'll let
You
you
derailed him.
tell
He's
us.
got to
You
start
got
back
there
up.
At
14:15. When did you first start Alan Hamilton?
227.
So 1427, and you ended with Alan Hamilton
At 1438.
at 1438. You started with Angela Hamilton, 1443, correct? That's why I gave you the pad so we could,
Thank you, sir. I forgot.
okay.
I'm not accustomed to doing it this way. At 1443, 243, and I concluded that at 257.
1457, correct?
Yes, sir.
Military time.
Oh, we're going to use military. 1457, sir.
Okay. Now, from there, you do what?
I got a hold of Detective Koenig, and we went out and interviewed Mr. Reeves.
Okay, so you left the party room,
Yes,
right? You didn't go into Theater 10, which was a crime scene.
that's correct.
And so how did you get to the location where Mr. Reeves was at? Did you go through another theater? Did you go all the way around the building?
We walked to the back of the theater and entered the parking lot. I had obtained my vehicle, and that's where we did the interview, was in my vehicle in the
So
parking
you
lot.
went onto the parking lot, got in your vehicle and drove it around to the back.
That's correct.
Is that correct?
Yes, sir.
Okay. Now, your purpose of doing this now was you wanted to interview Mr. Reeves.
That's correct.
And we've been fortunate enough to hear the interview of Mr. Reeves yesterday in this case, and you were present, right?
That's correct.
Okay. Now, certainly, when you first got to the point of interviewing Mr. Reeves, you now had this information, this voluntary statement that Corporal Hamilton had given to you concerning the aggression that he had witnessed, correct?
Objection to the characterization of the question.
He testified was aggressive,
Overruled.
correct?
Yes, sir.
Okay, and you certainly were interested, were you not, in what effect that aggression would have had on Mr. Reeves?
Yes, sir.
Because your job at that point was to assess whether or not Mr. Reeves's evaluation of the circumstances was reasonable, right?
Your Honor, I'm going to object.
Approach.
Jesus Christ. Who asked it? Could a jury be swayed by these sidebars? Well, yeah, they're gonna look. You give a jury an instruction, don't think about this. They're gonna think about it. They're gonna ask what the hell's going on in their heads at some point. Could this be a grounds for a mistrial? No, it's not really an appealable issue either, because an appeals court's gonna say, wait, if we're having sidebars, we're discussing this and trying to sort it out. That's good. Now, what they're talking about at those sidebars, if it's on the record and the stenographer's out there typing away or it's being recorded, that could be an issue for an appeal. But right now, just having sidebars, if you're calling them as well, you don't really get to claim, well, we had too many, because you're part of the problem. Little Miss, this is Alan Proctor. He is the lead detective for this whole thing. So he's giving testimony right now. Well, Little Miss, we don't know what they're about. I mean, I have ideas what this is about, but remember, those guys up there know this trial better than anybody. So there actually might be legitimate reasons they're bringing this stuff up, trying to protect the record, other things like that.
So now, you were going to interview Mr. Reeves, not only with yourself, but you were going to interview Mr. Reeves with another detective present. Is that correct?
That's correct.
And in this particular interview that you had with Mr. Reeves, you didn't have a pre-interview non-recorded, right?
That's correct.
You applied a different procedure for Mr. Reeves in this particular case. You recorded from the very beginning.
Yes, sir.
Okay. Now, That was done in the front seat of your car.
That's correct.
Is that correct?
Yes, sir.
Okay. And is there a reason that it was done in the front seat of your car and not in the party room as the other witnesses?
Convenience. Yeah, he was handcuffed, detained. I didn't want to parade him back into the theater.
Well, you brought him into Theater 11 shortly after your interview, right?
Yes, sir, but we pulled as close as I could to that door to allow him to exit the vehicle to get into the Theater 11.
And that wasn't difficult.
Sir,
That wasn't difficult.
I ran over a curb, so I was able to get up to it. Yes, sir.
Okay. Now, your interview of Mr. Reeves, you turned on the recorder, right?
Yes, sir.
And you started asking him questions, correct?
Yes, sir.
And we heard that Mr. Reeves told you that he was scared of Mr. Olson, correct?
Yes, sir. The tape. Yes, sir.
Okay, so let's talk about that. When you first started your interview of Mr. Reeves, you didn't even know the age of Mr. Olson, correct?
I knew that he was in his 40s.
Well, that's because Mr. Reeves told you. I'm saying before the interview of Mr. Reeves, you didn't know Mr. Olson's age.
There again, sir, I believe that I might have been furnished that information as to the fact that he was in his 40s by Major Corbin and Detective Harris. I knew that he was not a older man, the victim. I now recall that they told me that he was a middle-aged man and might even have told me that he was in his 40s.
And did you know how tall he was?
No, sir.
And did you know how much he weighed?
No, sir.
Okay. And so you start interviewing Mr. Reeves. That interview of Mr. Reeves takes about 30 minutes, correct?
Goes on at 15:10, 3:10, and
Stops at 3:40.
just double check.
I've got it here if you need it.
I've got it here. That's right, 3:40.
Okay. So about 30 minutes, right?
Yes, sir.
Okay. You indicated to the ladies and gentlemen of the jury that you already knew, supposedly, that there was a phone in front of seat 9 in the theater, correct?
Yes, sir.
But you didn't know that seat 9 was the seat that Mr. Reeves was seated at, correct?
At the time that I'm interviewing Mr. Reeves,
Yes, sir.
I knew that he was on the back row. I knew that his wife was immediately to the right. I knew that Mr. Hamilton and his wife were 4 or 5 seats over to the left, and that the victim and his wife were in front of him.
4 or 5 seats. You think the Hamiltons were 4 or 5 seats to the left? What
Yeah.
about 7 to 9 seats to the left?
7 to 9. At the time that I did the interview,
Yeah.
I wasn't aware. I knew there were witnesses on that row.
Well, you just said that you were aware that the Hamiltons were, I think you said 5 to 6 seats. It's really 7 to 9, right?
Those seats that the Hamiltons are in are not numbered on this map that I have. During my interview with them, they told me that they were 4 or 5 seats over to the left.
To the left. Okay.
According to Mr. Hamilton, he was to the north. The shooter was to the north of him, which would have been to the left.
And I'm sure that Mr. Hamilton told you as well that he was only able to see a silhouette because of the darkness in there.
I don't remember if that's the terminology that he used, but he did tell me that it was dark.
And that he couldn't actually see any facial features of Mr. Olson because it was dark.
Are you telling me that's who said, do that again, counselor, please?
Alan Hamilton.
Yes, sir.
Now,
Hold on. Could you redo that question? I'm not for
Sure,
sure.
sure.
Okay.
Alan Hamilton told you that it was so dark that he couldn't see the facial features of Mr. Olson.
Your Honor, I'm going to object.
Sustained. Sustained.
Yeah, that's actually a good objection.
Now, you knew, however, when you were interviewing Mr. Reeves, that there was a phone on the floor, correct?
Yes, sir.
Did you know whose phone it was?
No, sir.
Or did you ask anybody? By this time, I would imagine you had Detective Smith already in the crime scene, right?
Yes, sir.
Or did you ask Detective Smith, hey, can you tell me what seat that phone is in front of? Did you ask him that? Smith.
No, sir.
So you didn't know who the phone belonged to and you didn't know what seat it was in front of.
No, sir.
But you knew that it was in the back row, which we call row A, right?
Yes, sir.
Okay. And you realized that it was somewhere in the center of that row. Or did you even know that?
I knew that it was in the center of that row, around
Okay.
the center of that row. Yes, sir.
And Mr. Reeves tells you that Mr. Olson hit him in the head, either with a fist or a phone.
Or something. Yes, sir.
A fist or a phone or something.
Yes, sir.
And so that must have triggered immediately a ringing of the bell. Wow. Mr. Reeves is saying he was hit with a phone.
Your Honor, I object to the gratuitous comments being made by counsel.
All right. Overruled.
That rang a bell, right? Because you knew that there was a phone there in that row.
Yes, sir.
And if Mr. Reeves is telling you that, hey, I think I may have been hit with either a fist or a phone, that phone becomes paramount in this investigation, right?
It's important. Yes, sir.
Very important. Would you agree?
It's important, sir. Yes, sir.
Is it not very important?
Everything's important, sir.
But this is really important, right?
It's important.
And the reason that it is important is because there may be some evidence, some physical evidence on that phone, right?
Yes, sir.
And that physical evidence could link that phone, or at least the DNA on that phone, to Mr. Reeves. Right?
Yes, sir.
And if in fact it does, now you've got a piece of evidence to try to recreate what happened, right?
Yes, sir.
Because that's what you're trying to do in these investigations. You're trying to recreate what actually happened in that theater, right?
Yes, sir.
Okay. So Mr. Reeves also tells you in that interview, not only that he was hit with a phone, but he tells you that that phone was in between his legs immediately after the shot. He realized, oh, there's the phone right between my legs after the shot took place, right?
Yes, sir.
And clearly you knew that because Alan Hamilton was the person that told you that the phone was on the floor,
That's correct, sir.
in between Mr. Reeves' legs.
Yes, sir.
And Reeves told you that it was a dark theater.
Yes, sir.
And you would agree the darker the theater, the more it affects people's ability to see.
Objection, speculation.
That's a 701.
Overruled.
You would agree the darker the theater, the more it affects people being able to see, right?
Yes, sir.
He also told you that it was extremely loud in that theater because of the previews, correct?
I don't know if he uses that terminology. He says that it was loud.
Okay, and you didn't doubt that, right? Previews are loud.
They can be, yes, sir.
And had you known by this time what the previews were,
I know, sir.
you didn't know that there were Action, RoboCop, Terminator.
Objection, facts not in evidence.
I'm asking if you knew.
Yeah, it's an example, not an
Oh.
actual thing.
Overruled.
Did you know?
No, sir.
You hadn't asked anyone there in management with the theater, hey, listen, tell me what the lighting settings were during the previews and what those previews were?
No, sir.
In fact, you never did that, did you? In your entire investigation there at the scene that night, you never even did that.
No, sir.
Now, when you realized that there was that phone on the floor, did you contact Detective Smith and say, hey, we've got to be very, very careful with that phone? We got to make sure we preserve it for DNA evidence, because Mr. Reeves just told me that he thinks he may have been hit with that phone. Did you tell Detective Smith, who was the crime scene detective, to do that?
No, sir. That was part of his training, forensic techs, his training on how to handle possible DNA evidence.
So you left it to him that you didn't know whether he had ever been assigned as a crime scene detective on a case.
He had been assigned as a crime scene detective on a case, probably not on a homicide. However, he knew the proper procedure for handling DNA evidence.
How do you know?
He's very sharp. He knows how to work a scene. I've been with him before. He knows his job.
So grabbing the phone off the floor and turning it off the day of the incident, and then coming back a few days later and taking the phone from the evidence room and turning it off.
Jack, there's been no evidence of that.
Sustained.
Mr. Reeves told you that in addition to being hit on the phone with the phone, that Mr. Olson was cursing violently at him, right?
I don't know if he uses the terminology violently, but he was cursing.
And that certainly was being corroborated by your previous interview of Corporal Hamilton.
Yes, sir.
Did you ask Mr. Reeves, how close was Mr. Olson to you when he was leaning over that chair and yelling profanities?
No, sir.
You didn't ask him that.
No, sir.
I think you already testified that you didn't ask Mr. Reeves in that interview what his training was in identifying danger. Correct?
No, sir, I did not. But as I've previously testified, he could have been an ex-police officer, but in this particular case, that had no bearing on this investigation.
So you're telling this jury then that his prior training, no matter how extensive, had no bearing in this case?
So as I testified yesterday, we are all human and we all have the capability of making mistakes.
No, listen to my question. You just told this jury that his prior training and expertise has absolutely no place in a case like this. That's what you just told the jury.
During my investigation, it had no bearing in my investigation.
And so you didn't consider it.
I did not.
Now, Mr. Reeves told you that he was so frightened that he was trying to create distance by leaning sideways and back on his chair, correct?
I recall him telling me that he leans back in his chair.
And that was to create distance, correct?
That's correct.
You've been a police officer long enough to know that that's one of the skills when someone's about to attack you that you want to do, correct?
Your Honor, I object. 402.
Oh,
Correct? It's one of the things that you're supposed to do. That is a technique, create distance.
In some situations, yes, sir, you want to do that.
You certainly don't want to get closer to the person that's about to attack you. That's a big no-no, right?
There again, sir, it depends on the situation that you're in.
Oh, so you think it's okay if someone's attacking you just to get closer to them?
There again, sir, every situation is different.
Well, this situation, you think it was reasonable then for Mr. Reeves to get
John,
closer?
I object.
Sustained.
Mr. Reeves told you that Mr. Olson told him that he was going to kick his ass.
There again, sir,
How many sidebars did I miss? I'm
not
sorry.
sure if
Client
that was
called.
the terminology or not that he used.
We just heard it yesterday.
There again, sir, I don't recall that. Let me look. Do you have the page number there?
I can give you the whole transcript.
I've got the transcript.
Okay, well
I
then,
was just hoping that maybe you would have the page number.
Digging through his murder book. The sad thing is, Eric, you're probably correct. Eric, I'm not sure what they objected to, but it's that maybe he's reading from things.
Pardon me, Your Honor. I'm trying to locate it real quick.
Not a problem.
Truth, you're probably right. I mean, he does strike me as a Karen, but even Karens have the right to self-defense, and Karens have the right to be dicks, who then have the right to self-defense. So, well, Gabby, who knows how he would testify? But yes, if they play his statements, that eliminates the need for him to testify because he gave his statement, and that is the most accurate and purest statement he's got. Especially given 8 years later, I wouldn't trust my memory that well. Well, Little Miss, that's, you know what? It's
That's
a fact,
right.
not
He
an
does
evidence,
say
but
that,
for us to know, I think it's helpful to know. We're shaping it
Many
based on
say
what
no,
we
and
have.
this is Mr. Reeves. I think that he was talking about texting his daughter. If it was any of my, there's fucking there 3 or 4 times. This ain't my fucking business, or I'll kick your ass. Whatever he's saying, he was threatening. I'm going to be candid to you. I don't remember exactly.
so that's what he was telling you, right?
Yes, sir.
And you believed that Mr. Reeves was forthcoming to you, right?
Objection.
Sorry,
Your Honor.
sir.
We can punch refill.
Yes.
I don't know, guys. Sorry, I was trying to squeeze all of it in while the detective was looking at his murder book. But yeah, I would rather have them play that. I mean, they have to. It shows him saying, I was in fear of my life. I had problems. You know, Jackie, and somebody else brought this up earlier. Yeah, if you're at a movie theater, it's a fucking movie. Go somewhere else. Ask for your money back. I guarantee if you ask him right now, hey, would you want to have this thing sitting over your head for 8 years, where if you lose, you will die in prison? I'm betting he'd be like, yeah, I'd rather go somewhere else. I'm sure that Olson, if you asked him, Chad Olson, he'd be like, you know what? Yeah, I'd rather just sat down and ignored that guy. Sure, some Karen's complaining and whining about you using the phone. You know what you do? If you're at a theater, say you could do like a couple things. Oh, I'm sorry. Turn it off. You can say, go fuck yourself. That's nice. Go back to playing on your phone. You could also just ignore him. I'm using my phone while the trailers are going. You don't stand up. You don't have to come up there and jiggle your dick to say, I'm the bigger badass on the block. You know, Curtis Reeves decided to turn around and he jiggled his balls too. It was completely unnecessary. It's just like my video about the Chad Reed and Kyle Caruth shooting. That was 100% unnecessary. You know, this goes back to the whole Clearman thing. Is this stuff worth dying for? Is it worth getting into a situation where you get physical with somebody over a cell phone in a fucking movie? No, it's completely stupid. There was no point. This didn't have to happen. But these guys pushed. They should have just left it alone. And they didn't. And now we're here, which means we get to look at it, but I think I brought this up and I keep harping on this point. Is any of this worth going to prison over? No. So use some of these lessons. Use these guys, use their fuck ups, use their screw ups. I mean, even if they get acquitted, I'm sure this took a couple years off his life sitting here worrying about it for 8 years on end. Use it in your daily life. Part of, survival is avoiding unnecessary conflict. And this was completely unnecessary. He's such a hothead. It sounds like they were both hotheads. Assholes collided. Sidebar salad, yeah. Yeah, there are a ton of these, but well, Jackie, yes, if you want to move, but you also don't sound like an asshole. So, once again, remember you're dealing with people who act differently than a lot of people would. Truth Cures, am I watching? You watch any hearings? Do you mean in this case, or do I watch hearing? Well, I stream hearings in general. Is that what you're asking? I'm not too sure. Also, I'm not sure. It looks like it's been a couple of minutes. I don't know if the chat's frozen or something. Miss Olson looks like a Karen herself. Yeah, she does, but the fact that she got caught up in all this nonsense didn't really look good to her, in my opinion. Truth Cures, some of these hearings were a couple of years ago, so no, I've not had a chance to really watch the hearings. I followed it. I mean, this went on while I was in law
Now
school,
let's
so
talk
I was
about
reading up on
that
it.
phone a little bit more.
Sir?
Let's talk about that phone a little bit more.
Okay,
You didn't know the weight of the phone at that point in time, correct?
that's correct.
But you would agree that if that phone was being thrown at someone else, it's being used not as a phone, but as a weapon.
It could be, yes, sir.
It's a phone,
And
not
you
a
would agree
radio
that
from
that phone could
Vietnam.
Cause great bodily harm.
It could, yes, sir.
It could cause death.
It'd be difficult, but I guess anything is possible, sir.
It'd be difficult. No. Tell me why you think it would be difficult.
Judge objects.
He opened the door on it, Judge.
Judge, can we approach, please?
And here we go again. God, these guys are making me have to talk a lot. This is rough. No, miss, hearings are not evidence, but if you say, for example, if there's a hearing and you have to make testimony, that is something that you're kind of locked into because now that's on the record somewhere. So, at times hearings can become evidence. So, a suppression hearing, if the police officer testifies about how something went during a traffic stop, that's now part of the record. And if you put the officer up there and he says something completely different, as the defense attorney, I'm going to bring up, hey, the last time through you said something. So, evidence can really be anything. Yeah, even Karens do lose people. Yeah.
To suggest that you can't cause death with a phone.
I have no medical training, sir.
That's a good
Other than
answer.
first aid.
Yeah. In fact, not only a phone, hands can kill.
Yes, sir.
And you would agree that if a phone is thrown at somebody and it hits them in the head, not necessarily going to cause an open wound, right?
It might not. Yes, sir.
There's a lot of factors that you have to consider, right?
That's correct, sir.
Did you all ever weigh this phone?
Yes, sir.
Was that after we weighed it?
I believe so, sir.
And you found this phone to weigh as much as a cue ball. Correct? Cue ball, like a billiards cue ball?
I'm not familiar with the weight of a cue ball, sir.
Well, if I had thrown a cue ball at you, it could cause great bodily harm, right?
Yes, sir.
It could cause death. Correct?
Possibly, yes, sir.
Okay. Now, of importance was, in this case, Mr. Reeves' disabilities, right? What was his medical condition, his physical condition? You never asked him that. Right?
No, sir. He volunteered it.
He had to tell you that he had arthritis, bad back, correct?
Yes, sir.
A whole slew of ailments that he was telling you he was experiencing at the time of this incident.
Yes, sir.
Did you ask him for particulars of that?
No, sir, I did not.
Meaning, Mr. Reeves, tell me what, you've got arthritis in your hand. Tell me what that does to you. You never asked him that.
No, sir, I did not.
Mr. Reeves, you've got arthritis in your shoulders and in your spinal column. Tell me what that does to you. Never asked him that.
No, sir.
Mr. Reeves, do you have difficulty getting up off a chair? What do you have to do in order to get up off of a chair, Mr. Reeves? Never asked him that.
And he never told me that. No, sir.
My question is, did you ask him that?
Oh, no, sir.
Did you ask him, Mr. Reeves, you've got these shoes that you have to kind of pull some strings there. Are you wearing those shoes for a reason? Didn't ask him that.
No, sir.
Did you ask him how heavy he was?
I did.
Did you tell him, did you ask him, hey, was that your normal
Give me
weight while
1
you
minute,
were
guys. I'll be back.
a law enforcement officer?
No, sir, but he told me he'd gained some weight.
Did you ask him if that was his weight while he was the head of security for Bush Entertainment?
No, sir.
Did you ask him if he had deteriorated during the last few years?
No, sir.
You asked him what his limitations were.
No, sir.
But he told you he was a physical wreck, right?
Yes, sir.
That was important in your investigation, was it not?
As we've talked, yes, sir, everything's important.
Well, but that in particular was important, was it not?
It was important, sir.
But you didn't ask any follow-up questions at all.
No, sir, he appeared to be healthy.
Oh, is that back to your medical degree?
Judge, objection, Judge.
Sustained.
Is that because you now have the qualifications to be able to assess someone's condition by visual sight?
I can observe someone. He's able to walk around. He's not under, doesn't need a cane, doesn't need any of that stuff to get around.
So you're okay if you don't need a cane and you can walk?
Well, he didn't appear to be physically disabled.
Do you think that individuals in their 70s can perform just as easily as someone in their 30s or 40s?
There again, that depends, sir.
And that's why we have to ask those questions, right?
Yes, sir.
Did you consider Mr. Reeves's age?
Yes, sir. I knew he was 71.
Okay. And did you ask him, hey, why did you retire from Bush Entertainment? Such a great position as head of security. Why did you do that, Mr. Reeves? You ask him that?
No, sir.
Pretty good job, right?
I don't like Busch Gardens.
Head of security for Busch Gardens.
I don't like Busch Gardens.
Oh, you don't like Busch Gardens.
No, sir.
Okay. And then let's talk about this eye. Mr. Reeves had told you that he had been hit somewhere in the eye area, correct? The head.
Yes, sir.
And he told you that he was experiencing some difficulty at the time of your interview. Correct?
With his eye. Yes, sir.
With his eye. Now, by this time, had you interviewed Mrs. Reeves? Not yet, right?
No, sir.
That was after the first interview of Mr. Reeves.
Yes, sir. He requested or told me that I needed to speak to her.
Okay. Now, Mr. Reeves also told you something very important. And that is immediately after he fired the weapon, he placed that gun on his lap, took his hands away, right?
He said that he put the gun on his leg and that I don't recall him saying that he moved his hands back.
Well, what did Corporal Hamilton tell you then when he came up and took the gun from Mr. Reeves's knee? That Mr. Reeves's hands weren't anywhere near the knee, right?
I don't recall him telling me that, sir.
Well, what's the issue with it?
I don't recall. I knew the gun was on his leg. I don't know if he had his hand on top of the gun. I recall Mr. Hamilton telling me that he walked over and took the gun from him, that he had it
On his knee.
on his knee.
Okay. And so you would agree, and I'm sure you've been trained in this as well, you would agree that in a situation where you're in a darkened area, you're in a theater, there's been a shooting, you certainly don't want to be displaying that weapon out to the entire group because someone else may have a gun and start shooting, correct?
That would be a very pertinent thing to do, not to display it.
So Mr. Reeves, immediately after the firing the shot, was in training protocol, putting that gun immediately on his knee outside.
Yes, sir. Common sense.
Well, it's common sense and training, correct?
Yes, sir.
Immediately after the shot took place, correct?
Yes, sir.
And you're taught as a police officer that the minute that you stop the threat, you don't keep shooting, right?
That's correct.
One shot in this case, and only one. Correct?
Yes, sir.
Okay. Training protocol. He's following that training.
Yes, sir.
You finished that interview with Mr. Reeves. And let's talk about the time, because I want to make sure we've got this time sequence nice and tight. What time did you finish with Mr. Reeves? 3:40. I thought you wrote it down on that piece of paper there.
I finished at 3:40.
At 3:40.
Yes, sir.
Okay, and so now you are going into what investigative mode? What are you doing now? After you finish that, you go to Mrs. Reeves, correct?
That's correct.
Okay, so let's talk. What time do you start Mrs. Reeves?
One moment, sir.
I'm sorry.
I started that interview at 16:25.
Also known as 4:25, right?
Yes, sir.
16:25. And you finished that interview at 16:38.
That's correct.
How many minutes is that?
That's 30.
I hope it's not 30.
No, 30, 45 minutes. Oh, you talking about for Miss Reeves? I apologize, sir.
Yes, that's okay.
That's 13 minutes.
You had a 13-minute interview with Mrs. Reeves.
That's correct.
And this one you recorded immediately. No pre-recording by you.
That's correct.
And she was a witness, not a suspect.
That's correct.
And so you didn't violate the protocol of the sheriff's office.
That's correct.
And Mrs. Reeves likewise told you that she was scared.
Objection, Judge, to hearsay.
Sustained.
Okay. You spoke to Mrs. Reeves for 13 minutes, right?
Yes, sir.
Okay. And so after that 13-minute interview with Mrs. Reeves, you decide to go back and interview Curtis again, right? So let's try to take the scenario if I can. Alan, Angela, right?
Yes, sir.
Curtis,
Yes, sir.
Mrs. Reeves,
Yes, sir.
now back to Curtis, right?
Yes, sir.
Okay. And so when you go back to Curtis, what time was that? I've got it right here if that makes it easier.
1643.
1643. 1643, right? Which would have been what?
443.
443. And then you finished that at 1648.
That's correct.
Is that correct?
That's correct.
Okay. Let's talk about between 1643 and your last interview with Mrs. Reeves. You finished Mrs. Reeves' interview at 1638. Is that correct?
That's correct, sir.
And you started Mr. Reeves's second interview at 1643.
According to my notes, yes, sir.
Is that correct?
Yes, sir.
How many minutes is that?
5.
5 minutes. Okay. And so in between that period of time, after you interviewed Mrs. Reeves for the second time, your testimony is that you go to the command center.
We have a meeting. It's not really a center, but command center, but we have a meeting out in front of the theater.
Okay, so you have to, let's see if I can get this correctly. You were interviewing Mrs. Reeves in the same room?
I believe so, sir.
Okay, and so you have to leave that room, have to leave the theater. You got to go through the doors
Right.
and go out into the parking lot where you had your makeshift command center, right?
That meeting occurs right there outside the front of the theater, right there in front of the box office.
Okay, and would you tell the ladies and gentlemen of the jury again the purpose of that meeting?
To discuss the case, the information that patrol deputy or detectives had received from their witnesses, their interviews.
To discuss the case. So that's a very important meeting, is it not?
Yes, sir.
Because you're trying to get information from all the various sources of witnesses that are being interviewed, correct?
Yes, sir.
And these witnesses are being given voluntary statements for them to write down what, in their opinion, they saw. Right?
Yes, sir.
And so that's a lot to look over, right?
Yes, sir.
And so it must have taken you probably, what, a minute to get from the room that you were interviewing Mrs. Reeves to that meeting up front?
Possibly, yes, sir.
So that leaves us 4 minutes. And so now it must have taken you at least 3 minutes to go from the meeting to go back to Mr. Reeves, right?
I'm not for sure, sir, how long it would have taken.
Well, he was in the back, right?
Yes,
In a
sir.
car. And the meeting was out front of the theater.
Yes, sir.
But it'd take you at least 3 minutes to get there, right?
There again, sir, I don't know. It would have
So you
taken,
must have had a 1 minute meeting with your group outside the theater because those are the numbers, right?
yes, sir.
a 1-minute meeting you had to discuss all of the evidence that allegedly had been uncovered at that point, right? 1 minute.
I tend to believe, sir, it was longer than that.
Well, the numbers don't add up, right?
That's correct.
And so tell me who you spoke to outside the Cobb Theater for a minute that gave you enough information for you to go back and tell Mr. Reeves that you were going to charge him with second-degree murder.
We had stood there and talked. The detectives, command staff was there. Sergeant or Captain Eckley, Major Corbin, the sheriff, Detective Harris, Sergeant Sessa, and they had said that no one had seen a punch being thrown and that no one had seen the suspect coming over the chair.
Oh, you must have told him, wait a minute, I spoke to Mr. Hamilton. He says, yeah, that, Olson was leaning over the chair and he was yelling and he was cursing. I'm sure you told Captain Sessa that.
Your Honor, I object to the characterization of the question. Leaning over and coming over are two very different things.
Sustained.
What did you tell Captain Sessa about your interview with Mr. Hamilton?
Sergeant Sessa.
Sergeant, sorry.
I think we didn't go into in depth. We didn't go in depth. We simply wanted to know if anybody had seen a punch being thrown or anything being thrown at the victim, or at the suspect. We wanted to determine if anybody thought that the shooting was justifiable.
Well, in a minute, that's hard to do, right?
There again, sir, my times could be off.
Well, times are important, aren't they?
They are.
They're critical. They're part of the evidence, right?
That's correct.
And in a homicide case, especially, we can't afford to not be correct, right?
It's very important, sir.
And so nobody saw a punch being thrown. Nobody saw a phone. That was like the deciding factor for you, right?
Being thrown.
The being thrown.
Yes, sir.
And so darkened theater, correct?
Yes, sir.
You don't know how dark it was because you weren't in there to see it for yourself.
That's correct, sir.
You hadn't gone back into the crime scene and said to the manager, please turn the lighting to the lighting that was present during the previews so that I can sit in this chair that Mr. Reeves was sitting and I could experience what he was experiencing. You never did that
No, sir.
before you had that meeting with, I guess it's the brass of the sheriff's office, right?
That's correct, sir.
You never went to the manager and told the manager, hey, by the way, I also want you, in addition to put the lights down, I want you to put those previews on. Because I want to sit in that chair and I want to experience whether the loudness of the previews
Your Honor, I object.
had any effect.
If you approach her, it's just an improper form of questioning.
I'll overrule.
You never did that, did you?
No, sir, I did not.
And did you tell the brass there at the Pasco Sheriff's Office, say, by the way, I haven't even gone into the crime scene? Did you tell them that?
No, sir. We were aware of.
Well, you may have been aware. You didn't tell them that you had not been in that crime scene. Is that correct?
That's correct.
Detective, the first time that you went into that crime scene was at 5:32 in the afternoon.
If I may.
You may, please. You want me to try to hide it for you really quickly?
Yes, sir, because I don't seem to have it noted here. You have the crime scene log?
I think I do. at my fingertips.
Thank you, sir.
May I approach?
You may.
It's in the first page, Detective, very top.
There you go. Yeah, I apologize, sir. 1732. That's
Thank you.
correct.
May I have it back?
Yes, sir.
Now, let's talk about that very important process of the case, because your job's not over, right?
No, sir.
You may have told Mr. Reeves and charged Mr. Reeves at that point with second-degree murder. Let's talk about the number. Was it 2 hours, and in 2 hours and 16 minutes from your arrival, you're charging Mr. Reeves with second-degree murder? In 2 hours and 15 minutes, 16 minutes. That's why I became a lawyer. Math is. Tell me if I'm right.
About that, yes, sir.
Okay. So now your job's not over, is it?
No, sir.
Your job now, you're going at 5:32 for the first time into this, and let me call it an incident scene, because that's what it is, correct?
Objection. I mean, the phrase is improper.
It's an incident scene where the incident happened. Correct?
Overruled.
It's only a crime scene if someone's at fault. Would you not agree?
I consider it to be a crime scene.
You consider it to be a crime scene. Okay, so we'll call it a crime scene. So now you go into the crime scene and Detective Smith is there, correct?
Yes, sir.
And you have some forensic people there as well, right?
That's correct.
You already know about the phone.
Yes, sir.
Is that correct?
Yes, sir.
But you still don't know what seat Mr. Reeves was actually in.
Pointed out that seat at that time.
Well, we're going to get to that.
Okay.
Okay. And so when you go in there, you don't know what seat Mr. Reeves was in.
I knew there was on the back row. I knew there was in the center, but the actual numbered seat, I did not know.
Okay. And so when you go in there, do you see the phone? Do you see the phone at 5:32 in the position of that aisle?
I'm not for sure, sir, if I saw it there or if it was pinned with a pin marker.
Meaning that there could have been a pin marker there, but the phone may not have been there.
That's correct.
And so I'm sure that at some point in time in your investigation post-entry of the crime scene, that you discovered that the phone had a black case, correct?
Yes, sir.
And so if, excuse me a second. Your Honor. If I am throwing a dark object in a darkened theater, you may not be able to see it, right?
That would make sense. Yes, sir.
That makes a lot of sense, doesn't it?
It would be difficult. It would be possible that that could happen.
name of Amy Parrish, who has had extensive training in being able to capture photographs in darkened areas. She's got some expertise in that. Let's get her to do that here. Did you do that with Detective Smith?
No, sir, not that day.
Not that day.
No, sir.
Why not that day?
I didn't think of it, sir, at the time.
You didn't think of it.
No, sir.
And was that because you had only had one case in the past dealing with self-defense, Detective? Is that the reason why you didn't do these things? Difficult question, isn't it?
I tried my best to do the very best job that I could as far as the investigation.
Detective, I don't doubt that you tried to do your best. That wasn't the question.
Right.
The question is, do you think that the reason that you didn't do these things is because at that point in time, you did not have the experience in dealing with a self-defense case?
I had limited experience with that. Yes, sir. That could be a possibility.
Possibilities are dangerous in our criminal justice system. You would agree.
Yes, sir.
45.
We can't afford to make mistakes, can we, Detective?
45.
No, sir.
Because you have a man's life in your hands as well.
You're right, at this point, I would-
Sustained.
Tomorrow. Today I'm like right there. Tomorrow.
If you have much more time for.
We do have quite a
Great.
bit.
All right, let's take a 10-minute recess, please. Instructions during the break. Thank you.
All right, boards and recess for 10 minutes.
Bear in illness. Hopefully that helps. So somebody asked, what's the difference between the stand your ground issue and the self-defense? You always have the right to self-defense. The stand your ground issue is a way to avoid going to trial if it's clear you acted in self-defense. It allows the judge to make a determination right away at the beginning of a case saying, you know what, it's clear they acted in self-defense. We don't have to go any further. Case closed. Have a nice day. In this case, it's not clear that. I mean, it's a little murky. You know, as I said before, there's that spectrum of, good and bad, and then there's that spot in the middle, and this is one of those ones that's somewhere in the middle. I think it's a little closer to the bad side, but yeah, as far as a black and white shoot, this is a really gray one. So I hope that makes some sense. Now, some other states call stand your ground not duty to retreat, and that's fine. They can call it that, but in Florida, he had the right to have a hearing to try to short circuit the whole case, and it didn't work. Yeah, they've done really good. Gabby, they should definitely recross. They should just point out, like, all the million things he could have asked. He could have asked him a million more questions. You've got to go back and let this guy get rehabilitated because it does not look good if you just leave that one alone, especially your investigator, your lead guy. Yeah, you can't just let him walk off the field with unanswered questions. Eric, it's not going to be that fun. I mean, yeah, the attorney is making some points of like, oh, he didn't do this right or that right. Yeah, but there hasn't been a really big bombshell or anything big. They're almost to the point where they're saying like, you didn't put an Oxford comma here. Don't you agree that when you're listing things out, you should have an Oxford comma? Or you spelled received wrong. Detective, did you know it was I before E except after C? So you're not really, they're poking little holes in the boat, but it's not fatal. The other witnesses, the witnesses that were there at the scene that they really got to go after, those are the big ones, I think. So this is somewhat helpful, but it's not. It's not. This isn't critical right now. Yeah, they've done really good, but once again, attacking him only gets you so far. Well, they mentioned that yesterday. Like, oh, you take evidence and you put it in your desk. That's a big deal. I mean, you go all the way back to OJ's case, and one of the detectives grabbed a piece of bloody something, and oh yeah, I put it in a bag and took it home that night. And they asked him, "Have you ever done that in the 30 years you've been a detective?" And he said, "No." Those are all important. Those are all things you have to worry about. Good morning, Shannon. Um, but Eric, does the jury see it that way? I don't know what the jury sees. There are 6 people there we know nothing about and what they're thinking. So they could be looking into it. They might not be looking into it. Um, but yeah, this is plodding along. This is really slow. I can tell you this much: the trial I have next week will not be this slow. So, and his evidence handling wasn't good. I mean, it wasn't subpar. I mean, like I said, these are not the bombshells. It. I like to characterize it as like a bombshell full of mouse farts. Like, yeah, this, sure, maybe it was a bombshell, but what was inside of it? It was a dud. Yeah, Little Miss, I have a trial starting next week on Tuesday. It is a possession of methamphetamine case. Uh, no, it's not televised, and even if it was, I don't think I would televise it or tell you guys about it. Part of me is worried if I completely fuck it up. I don't want that to happen either, but I don't believe it's televised. Exactly, Gabby. The video was the biggest thing out of this guy's testimony, because he interviewed the defendant, and that was what they wanted to get in. That was a big thing. She could be a good old gal, but good lord, she needs to control her fucking courtroom. This is just, yeah. I'm not impressed. But I mean, this also could easily be this. Sometimes these big cases get out of control, and there's only so much you can do. Only 24 people. Geez, I thought I was like a rock star with the Edgecombe thing. Now it's like nobody wants to see these dudes getting shot over Lone Survivor. Oh, I also think Long Crime got mad. I was trying to solicit my channel over there, but maybe I'll try it again. In this case, from a sorry, I had to do that. Oh well. So, what do you guys think so far? How do you guys think the case is looking? Who do you like? Who do you think's got a good point so far? Who do you think has a rough time of it? I gotta try to figure out how to. I'm using StreamYard today, so I gotta figure out how to do a poll. Uh so let's see here. This trial's not as interesting, very slow. Cheryl, if this trial was chugging along at a normal speed, I think it'd be a lot more interesting. But yeah, it really it makes it hard to be invested in it when you're having to sit here and just be part of the drag. Um, I'm sure for the people involved in it right now, this is like the Super Bowl for them. This is probably they'll remember this trial forever. But yeah, for me and you, this is really boring. All right, I'm gonna have to put the poll on YouTube because I can't figure out how to do it here. I are not smart. At least not very smart. All right, guys, I put it up. Tell me what you're thinking. So, Gabby, they're not reaching. That's their job is to come up there and start throwing smoke and causing problems. That's the job. Um, that's just the nature of the business. It's it's my job to throw mines out in the road and hope they run over them. B.I. Real Lamar was entertaining. Yeah, he was. His personality was better, but you can have the great courtroom personality, but you got to have the skills. And it also, once you're an older attorney, it's older attorneys have a different style, and Curtis's defense attorneys are older guys, and that's that's how a lot of older attorneys are. They're a little more, they're kind of laid back, they're kind of slow, but they're a little more clinical. They have some decent bedside manner. I will include a too early to tell next time. I apologize. Oh, yeah, the cops don't like talking to defense attorneys usually. And I guarantee this detective has been up there for a while. I guarantee he's like, this is, are you fucking kidding me? I'm, yeah, I don't blame him. The defendant would have training in de-escalation, and expected to use it. I mean, you can be in training, but he's not operating as a cop. He's operating as a normal guy. So it's not the rules of a police officer using force anymore. It's Curtis Reeves as some schmo running around using deadly force. So, you know, I wish he would have. I wish he would have said, "Fuck it, I'll go sit somewhere else." But he didn't have to. Two men raised in toxic masculinity, and then neither knew how to mind their own business or back down from a fight. Yeah, nobody won. I mean, even if he's acquitted, who wins? Nobody does. Only popcorn was thrown was shooting the proper response. We don't know for sure. I think it's clear with some of the witnesses so far. We don't necessarily know for sure what's happened. Um, and even if there's popcorn just being thrown, if he had a reasonable fear of his life, being at risk or being at risk for severe bodily harm, he would have the right to use force, even if he was mistaken, but it was still reasonable, objectively reasonable. So, it's not as clear cut, and that's the problem when it's either what's in this gray area. Yeah, they should have just moved. Imagine that if they would have moved, if he was shut off his phone, or if he would have ignored him and kept playing on his phone. Once again, like I said, was this worth it? Couldn't see the video very well. Well, the video's not very good anyway. It's just happened to be one of those times where the camera's not right above you and happening to record everything. Also, to be fair, like if this happened today in 2020 and these guys start jawing off at each other, there probably would have been a couple of cell phones out recording it. So, it does matter that this is almost a decade old. Oh, that detective didn't crumble. He held his own. It's just there's only so much you can do when they point out if you haven't done X, Y, or Z, but he's not in a position to. He's got to answer yes or no. But no, that was far from a devastating cross-examination. I wouldn't be trying to say that it was. I'm sorry, guys. I got a phone call I got to take. Yeah, Shannon, he wouldn't look at the defense attorney, but he was focused on looking at the jury. That's just he needs to work on his courtroom skills. So that has nothing to do with him avoiding the attorney. It just he's not good at testifying, and
Hey, Stephen.
I think he should really work on that going forward because yes, it looks bad.
Hang on one sec.
Do you think the prosecution calls sidebars during these breaks? Yes. I need to go to the bathroom. Your Honor, can we have a sidebar about that?
That new camera.
Uh-oh. Talking about a camera. I don't know if that's good or bad.
All right. Are we ready to proceed? Okay, Tina.
All right, here we go.
Jurors in the courtroom, Your Honor.
Thank you, Deputy. Thank you, ladies and gentlemen. Were you all able to abide by my instructions during the recess? All righty. Mr. Escobar, go ahead.
Thank you, Your Honor.
Mr. Proctor, you're still under oath.
Thank you, ma'am.
Detective, I'll keep calling you detective, I'm sorry, Mr. Proctor.
That's fine, sir.
Before going back into that theater, or before going into the theater for the first time, anybody give you the name of Joanna Turner?
Not by name, sir.
Well, what did they give you if they didn't give it to you by name?
After the meeting, or after I went into the theater, there was a meeting of,
We're not there yet. I'm saying
Okay.
before you went into the theater
yes, sir.
at 5:32 in the afternoon,
Yes, sir.
did the name Joanna Turner, was that given to you?
No, sir.
Despite the fact that you had the meeting with supposedly all of the brass and discussing all of the interviews and all of the voluntary forms and all of that. Right?
Yes, sir.
And certainly nobody gave you a voluntary form there at that meeting with the brass that had the name Joanna Turner for you to read.
No, sir.
In fact, you didn't read a single voluntary statement that had been given by any witness prior to going into the theater at 5:32.
The Hamiltons.
Well, that was because you interviewed them, right?
Right.
No, I'm talking about from the brass at the meeting.
No, sir. I didn't read any written statements.
Okay. So now you go into the theater, and even though it was 2013, we are at an age where surveillance cameras are pretty common, right?
Yes, sir.
It didn't have to be 2022 for that to happen, right?
That's correct, sir.
In 2013, surveillance cameras were pretty popular.
Wasn't it 2014, Mr.?
Excuse me, 2014.
Yes, sir.
Am I correct?
They were popular. Yes, sir.
They'd been popular for quite some time.
Sir?
They'd been popular for quite some time.
Yes, sir.
And so when you went into that theater, you immediately realized that there were cameras in that theater, correct?
Yes, sir.
And so as you walked into the general theater, you looked up, there was one to your right, and there was another one to your left, right?
And Theater 10?
Yeah.
Yes, sir.
Okay. And so when you looked up and saw those cameras, you realized with all the years of law enforcement experience that you had that video surveillance is important, right?
Yes, sir.
And when you see cameras, you're going to go and watch that film as quickly as you can
Yes, sir.
because you don't want that film to be destroyed, right?
That's correct.
And that film can have incredible opportunities in your investigation, correct?
Yes, sir.
And so you didn't do that. You didn't go to management at the cop theater and say, Mr. Manager, I'd like to be able to see whatever is on that film. You didn't do that.
No, sir, I did not.
And you would agree with me that you later found out that you didn't even have to go to the IT room upstairs in order to view that video, correct? You could have done it from the manager's desk.
I wasn't aware of that, sir.
You weren't.
No, sir.
It's because you never asked anybody, right?
No, sir. I'm not computer savvy. I'm definitely not video savvy. We had those people with the sheriff's office there to
Cybercrime.
Thank you, sir. We had cyber crimes there to obtain all of that.
So if you're not computer savvy and you've got the battalion of cybercrime there, you had Busson, correct?
Yes, sir.
You had Lindsay, correct?
Yes, sir.
You had Pepinella, correct?
Yes, sir. I'm not for sure who all was there the day of.
Those guys are really good, aren't they?
They are.
They're highly trained, correct?
They are.
They're highly trained to preserve evidence, correct?
They are.
In fact, that's why they were there. Correct?
To obtain the video, yes, sir.
Well, not only to obtain it correctly,
That's correct.
and to make sure that nobody, even the cop theater, could destroy it, correct?
That would be correct, sir.
Because when you're doing an investigation, you can't trust anybody else. You got to put that trust only in the people that are employed by the Pasco Sheriff's Office, correct?
We'd like to have it that way, yes, sir.
And that's why they were there.
Yes, sir.
And so did you go over to Detective Busson and say, Detective Busson, I see that we've got some video here. I need you to go and I need you to preserve that evidence, period.
They told me that it was being preserved.
That's not my question.
Yes, sir.
Did you go to Detective Busson, who is an expert in cybercrime, and say, Detective Busson, you're here for this purpose. I want you to go and preserve that video evidence?
No, sir, I did not tell him that.
Well, why not?
He knows his job. That's that's what he does.
Well, unless Detective Smith tells him, I don't want you to do it. I'm going to handle it myself. Right?
Judge, I'm going to object. Calls for speculation on the part of this witness.
Sustained.
You would agree that Detective Smith was the crime scene detective, right?
Yes, sir.
And he had to make sure, like you, that things were going to be properly preserved because he is the crime scene detective.
That's correct, sir.
And in 2013,
14.
but in 2013, the year before, when he was in missing persons, you didn't know anything about Detective Smith as far as his capabilities in cybercrime. He wasn't in cybercrime, right?
I knew that he knew how to obtain video. He had assisted me before in robberies where he had obtained the video for me.
They
in other
worked
cases.
robberies.
So he had obtained the video. Do you know what type of background he had in order to be able to do that?
No, sir. I knew that I didn't know I didn't know all of his training, but I knew that he was very capable of obtaining the video.
But you would agree that obtaining the video doesn't mean that you tell the cop theater, hey, listen, do whatever you all want to do with the video and then give me a copy later on. That's not what you expected.
And I don't think that's what occurred.
My question is, that's not what you expected, right?
No, sir.
Okay, so you pretty much didn't have even a conversation with Smith about the video because you assumed that he was going to do something.
I remember the conversation occurring that the cop theater was not able to produce the video the day of the incident.
Oh, wait a minute. The cop theater was not able to produce the video, but you had cybercrime there that could extract the hard drives in the proper way and preserve the video, right? You agree with that?
There again, sir, that's above my my knowledge. I don't.
Well, you could have spoken to Busson and say, hey, Busson, I guess someone in the cop theater is saying that they're not going to turn over the videos. What can we do here? Did you have that conversation with Busson?
I did not.
You knew at that moment that the cop theater had a liability interest of their own, right?
That would be a possibility, yes, sir.
And you certainly didn't want the cop theater to be doing anything with that video, did you?
No, sir, I did not.
Did you know that at the very moment that you had walked in to that theater 10, that the cop theater was remotely looking at the video? Did you know that?
No, sir, I did not.
So the cop theater can look at the video remotely. You're there. You can't look at the video.
It was my understanding, sir, that we could not view the video that day.
Well, was it your understanding that Detective Smith told Busson, hey, get out of here, I'm handling this?
Judge, I'm going to object. It calls for speculation.
No, there's no speculation about that.
Sustained. There is.
Judge Busson is going to be testifying for me.
Okay.
Okay, so what else do you do in that crime scene? Other than talk to Detective Smith for a few minutes and leave?
I also, Detective Smith gave me a rundown as to where the evidence that they had collected, the evidence they were in the process of collecting, where the victim and his wife and the suspect and his wife were sitting.
Okay, did he give you the measurements?
No, sir.
Did he give you the measurements of the seats?
No, sir.
You knew that the seats had arms, correct?
Sir?
You knew the seats had arms, right?
Yes, sir.
And did those arms move up and down?
I'm not aware, sir.
And so you left the Cobb Theater without obtaining that video, those hard drives that day, right?
That's correct, sir.
And in fact, you had posted, had you not, officers there at the Cobb Theater to not allow anybody to come in to the Cobb Theater, right?
Theater 10, yes, sir.
And you became aware that the Cobb Theater sent an IT person from Mulberry to seize the actual hard drives that very night, correct?
I wasn't aware of that, sir.
You're not aware of that today?
I wasn't aware of that.
This is the first time you heard of it.
I was not.
Council's testifying, facts not evidence.
I'm not testifying, I'm asking if this is the first time he's heard that.
I know, but where's the facts coming from you?
Oh, it's Mr. Sillis.
I'm gonna overrule.
The first time that you have heard that a Mr. Sillis, an IT person from Mulberry, came over that night, penetrated security there at the Cobb Theater and seized the videos is today?
That's correct, sir.
So I guess Detective Smith never shared that with you.
I wasn't aware of it, sir. He could have, but I don't remember that conversation occurring.
Well, if that had occurred, you'd be disappointed.
I wasn't aware of it, sir.
Were you disappointed now that you heard that today?
I'm disappointed that I didn't know it before. I'm sitting here in front of a jury.
Well, are you disappointed that someone seized multitude of hard drives right under your nose?
I'm disappointed that I didn't know that.
Now, Detective,
Yes, sir.
you didn't know that the hard drives from the Cobb Theater, especially all the hard drives dealing with Theater 10, lobby, and what have you, you didn't know that those hard drives had been seized and flown to Alabama?
No, sir.
Well, you didn't go to Alabama to go and retrieve those hard drives?
I did.
Well, where did you think those hard drives had come from? Thin air?
No, sir.
I would rephrase you. Where
Thank
did you
you.
think those hard drives came from?
I was not aware that the hard drives were in Wesley Chapel.
You didn't believe that the hard drives that you were getting from Alabama were the ones that were taken from the Wesley Chapel Cobb Theater?
Yes, sir. I thought the ones from Alabama are the ones from Wesley Chapel. I understand that now, but at the time, I thought that the hard drives were being remotely, that the feed was remotely to that location.
So are you telling me that when you went to Alabama, you thought that the hard drives that you were picking up were not the actual hard drives? You thought that there were some kind of copies that were done for you at the pleasure of the Cobb Theater?
No, sir. That's what I'm saying. I'm not video savvy. I don't understand all that working. And I did not realize that the hard drives, I didn't realize that they were even in Wesley Chapel.
You didn't realize that the hard drives were in Wesley Chapel because you never went into the IT room to take a look at the surveillance equipment, correct?
That's correct.
You didn't know the make and model of the system, correct?
No, sir, but I had people there that did.
You didn't know the make and model of each hard drive?
No, sir.
You didn't know which hard drive belonged to which camera, correct?
That's correct.
You didn't know if you had multiple hard drives that were supplied by any particular camera.
That's correct.
You didn't know anything about that system.
Absolutely correct.
And so at some point in time, much days later, right? You and Smith decide, I think we better go to Alabama.
Your Honor, will we briefly approach?
Yes.
All right, guys. Yeah, this is I think they're coming up with a good tactic about keeping track of what was there video wise and evidence wise. Ask him. You don't know what type of hard drive it was. It'll get a little ridiculous, but
Back to those hard drives.
Yes, sir.
You went all the way to Alabama days later, right?
That's correct.
And you went with Detective Smith
That's correct.
to go and retrieve those particular hard drives that had been in the cop theater on the very moment of this incident.
That's correct, sir.
And you didn't go to just cop theater management. You had to go to a lawyer's office for the cop theater to go and retrieve those hard drives.
That's correct, sir.
And when you got the box or the luggage that the hard drives were in, it had a lock on it, right?
That's correct.
And so there at the lawyer's office, you didn't say, hey, lawyer, open this box so that we can see what's in it and we can inventory it and we can take photos before I am taking it back. Right? You didn't do any of that.
No, sir.
You left the box locked, not knowing what was in the box.
That's correct, sir.
And certainly you had done nothing prior to going to Alabama to go and check and see what system they had there at the cop theater so that you could correlate as to whether, okay, this hard drive goes here, this hard drive goes here, and this. You didn't do any of that.
No, sir.
And so now you're getting this box with, you don't even know how many hard drives were in there, right?
I don't, sir.
And so you get this box that was locked and you take it with you and you got to come all, did you fly or you drove?
We drove.
You drove. You drove all the way back to Pasco County. And certainly when you got to Pasco County and you got to the evidence room, certainly you opened that box and said, okay, let's inventory it before it goes into evidence.
I did not.
Well, that's the proper protocol, right?
No, sir.
Oh, it's not. So you can just get a box that has nothing that you know of. I mean, it could have had 3 kilos of cocaine and you would have known it, right?
I'm sorry, do that again.
Jeff, is that a
That
question
box-
or a statement?
That box could have had anything in it and you would have never known it.
I was told that the box contained,
Well, I
The hard
realize you
drives.
were told that by
yes, sir.
some lawyer that was representing the interests of Cop Theater, right?
Yes, sir.
But my question is that you did not know before you entered that box into evidence what was in that box. For all you know, it could have been anything. Right?
Yes, sir. I was told that it was the hard drives.
Okay. And so now you put that in evidence, right?
Yes, sir.
And the person that you call on in order to image, to copy those hard drives is the person that was at the Cop Theater the night of January the 13th of 2014, Mr. Busson, right?
I don't know who copies those, sir.
Well, Do you know that he was the one that copied those for you?
He's part of that team.
So it stayed in evidence. Tell me, stayed in evidence for a week without knowing what was in there?
Sir, I don't know.
How about a month?
I don't know, sir.
How about 3 months?
Let the witness answer, please.
My apologies.
Sir, I'm not aware how long the box remained in evidence. Cyber crimes, the state attorney's office, they were handling all of that aspect of it. We had CDs of the incident, the shooting, and I don't know how long the box remained in property and evidence.
And those CDs that you had were given to you days after the incident
A couple of days later, that's correct.
from somebody there with Cobb Theater, right?
Detective Smith obtained those.
Okay, do you know how? Do you know if he got it from a competent source, like a IT person, a computer engineer, a cybercrime expert?
I don't know who he obtained those from.
You don't. Okay. And so then at some point in time, though that box, were you responsible for also taking that box out and taking it to some gentleman in Orlando?
No, sir.
That wasn't you. That was Detective Smith.
Yes, sir. I went to Alabama to get it, and I brought it back with Detective Smith. We put it into evidence, and that was it. I simply accompanied him there for the long drive.
Detective, you would agree that you were not happy having to go to Alabama to get a vital piece of evidence that should have been preserved right here in Pasco County, right?
I do that again, sir. I'm sorry.
Yes, I'll tell you again. You were not happy over the fact that you had to go to Alabama to pick up a vital piece of evidence in this case when it should have been done right here by your cybercrime unit in Pasco County.
There again, sir, I'm not aware of how cyber crimes, how to obtain that. We were that's the way it occurred. I didn't know that the DVRs were even in Wesley Chapel. There again, cyber crimes is the one that handles that. My happiness, I wanted to obtain the video.
Let me ask you this question.
My happiness has no bearing on the trip to Alabama.
Well, let me ask you a question. You certainly interviewed John Sillis, who was the IT person that came in the middle of the night and took the hard drive. You did that, right?
I did not.
Or did you direct someone to do that? Did you direct some of your detectives, hey, this John Sillis, we need to talk to him? Did you direct anybody to do that?
Sir, as I've testified to earlier, I did not know that the video had been removed. The hard drives.
I have no further questions.
Thank you. Redirect,
May I have a moment, please,
you
Judge?
may. Is that your pen, Mr. Escobar?
Oh, thank you, Your Honor. These are hard to, they don't have much ink in them.
Oh, right. It's a new wave pens.
I know.
God, that was the hard drives. Do you know the hard drives are actually not hard, Detective? They're not actually drives. You can't drive them. Did you know that, Detective?
Thank you, Detective.
Yes, sir.
And you're on that exhibit.
Mhm.
God, that last bit of it was just obnoxious. Besides, I thought you guys wanted to play hangman with me, so I don't actually hang myself.
May it please the court, counsel. Mr. Proctor, do you have a copy of Alan Hamilton's statement?
I do not, sir.
Okay.
Counsel does.
I got it.
Defense exhibit, I think, number 20. Sit in the back. Defense exhibit number 20. Yeah, number 21.
For the record, it's defense exhibit number 21. May I approach the witness?
You may.
Detective Proctor, I'm going to ask that you look at that statement, not only look at it, but I'm going to ask you to read it to yourself and see if anywhere in that written statement, Mr. Hamilton stated that it was dark in the theater. And the second thing I'm going to ask you to do is see if he ever uses the word silhouette in his written statement.
If I may.
That's what. I'll just move on.
I'm sorry, but there's no mention of silhouette here?
Is there any mention of dark?
No, sir.
Dun dun dun.
Mr. Garcia, I think I need to clarify for the record, obviously that has not been admitted yet.
Yes, ma'am. Now, Mr. Proctor, let's talk about notes. I think you indicated on cross-examination, based on questions from Mr. Escobar, that you take notes when you interviewed Mr. Hamilton and Mrs. Hamilton.
That's,
Right.
That's correct, sir.
And once you have memorialized your police report, you destroy those notes.
I'm going to check.
I do.
Sustained. That was.
Right. You took notes, right?
Yes, sir.
Did you write a police report in this case
Yes, sir, I did.
in reference to your interview with Mr. Hamilton and Mrs. Hamilton?
That's correct.
Did you document in that report what they had told you?
Yes, sir, I did.
Did your notes comport with the report?
Yes, sir, they did.
After the report was written, did you then destroy the notes?
Yes, sir, I did.
Was there anything different in the notes as compared to the report?
No, sir, there was.
All right. Now, on cross-examination, Mr. Escobar went to great lengths asking you, well, did you ask Mr. Reeves about his disabilities? Did you go into this? Did you go into that? Remember that?
Yes, sir, I did.
On the second interview, did you ask Mr. Reeves, is there anything else you want to tell me?
Yes, sir, I did.
Now, let's talk about on cross-examination. Mr. Escobar asked you, Mr. Proctor, did you go into the theater and did you ask him to put the manager to put the lights on and the previews on and so on and so forth, right?
Yes, sir.
Now, as you're sitting here today, Mr. Proctor, is there any way that you could have gone back in time and done everything in that theater exactly the way it occurred on January 13, 2014? And by that, I mean, have the defendant sitting in the same seat, his wife there, obviously all the other witnesses that were in that theater, right?
Yes, sir.
With the previews playing at the volume with the correct lighting at that time.
That's
No.
also speculation as to whether he could have done it or not. I mean, we'd have to bring the witnesses in.
Judge?
Oliver.
And that's how you defeat
Right.
all the nonsense.
There's no way you can recreate it.
Okay. Mr. Escobar went into great lengths about you going in there and you sitting and seeing this, right?
Yes, sir.
Does it matter what you saw or you? It doesn't matter, right?
No.
Judge, I'm gonna object. Move to strike. Leading.
Sustained.
Move to strike.
Rephrase.
Mr. Proctor, what's important is what the defendant saw through his own eyes.
That's correct.
What he saw, what he heard, not you.
That's correct, sir.
You have a moment, Judge.
You may.
Because I don't have any further questions.
Can we approach real quickly?
Yes.
See, that whole thing he just brought up about, well, did you fully recreate the scene? And the detective mentioned that's impossible. That's how you get around all those, well, did you check this? Did you check that? Did you ask him to turn the lights on? Did you ask him to run the sound? That's an acceptable way to get through all of that, fluff the defense put out. And I'll call it fluff because it really is. So that was a good job they addressed it. I can only imagine what the defense wants to ask now, but I hope they don't. Like I said, I'm getting a little tired. I mean, if this keeps going on, I'll just take a nap and let you guys watch the trial because I think I can catch up in about 2 seconds each time. But why did my stream put me back on top chat? I don't know. So do you guys have any questions so far? I know I will say, for those of you guys who are thinking, oh boy, it'd be so great to be on a trial. This might be the trial you're on. So be careful what you wish for. Miss Judge looks like she's hating her life right now.
You're probably going to be on standby. Standby. All right, Mr. Proctor, you're free to go, but if you do get called back, you have to go. Okay? If you do get called back, you have to come back.
Yes, ma'am.
But-
I'm out of this area. Can you give me a day's notice?
Ooh.
All right,
Thank you.
you'll get a day's notice.
Thank you, Your Honor. It's good seeing you.
You too.
Give me a day's notice. Notify me by
Yes.
carrier pigeon or dispatch rider, and I shall return.
State,
State would call Mark Turner.
Oh God, how bad's this one gonna be? Kill. Take me now, Jesus. Take me now.
Do you solemnly swear or affirm the testimony you shall give in this call to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Matthew,
Go ahead, Mr.
Thank you.
Rosenwasser.
Good morning, sir.
I'll get to that. I'll
Can you
get to
please
that.
state your name and spell your first and last name for the court reporter?
Mark Turner, MarkTurner.
And you don't have to tell us exactly where you live, but what city do you currently live in?
Brandon,
All right. And back January 13th of 2014, what city were you living in?
Wesley Chapel.
Are you currently employed?
I'm retired.
All right. What did you do before you were retired?
26 years in the Air Force and 10 years in the aviation industry.
Okay. And just very, very briefly, we don't need an entire history,
The
but
aviation
very briefly,
industry.
what did you do in the Air Force?
I began as an enlisted man and then went to officer training school, aviation school, and spent most of my time in the intelligence arena.
Back on January 13th of 2014, did you go to the Cobb Theater to see the movie Lone Survivor?
I did.
And who'd you go there with?
My wife.
All right. Is there a particular part of the theater that you sit in when you go to the movie theater?
I usually try to find an aisle seat up high.
And were you able to do it on that particular day?
Yes, sir.
When
Good morning,
you
Mark.
went to the Cobb Theater, so you
Thanks for
walk up
joining
correct
us.
to
If
the
you
beginning,
like,
is that correct?
That's
leave me a
correct.
like
Right,
and
then you
subscribe.
gotta
I'd
turn around
appreciate
to
it.
your left or right, depending on what side of the theater you're on. And
Yes.
you look back at the seats, correct?
Yes, sir.
All right. When you walked in, do you recall whether or not the previews were playing at that time?
They were
Do you recall what the lighting conditions were like?
dimmed, but you could see your way through pretty clearly.
All right. And we're obviously going to be talking about a shooting. The lighting conditions that you're going to describe now, were they the same lighting conditions at the time of the shooting?
Yes.
All right. So let's tell the members of the jury about that. Was it dark like when the actual movie is playing?
No,
All right. So there's lights on at this point.
that's correct.
Right? Not the full house lights, but I guess as you indicated, dim.
Yes.
All right. So when you're looking at the entire theater, can you see the rows?
Yes.
Can you clearly see them?
Yes.
Can you see people sitting in the rows?
Yes.
How about the aisles? Clear enough to see the aisles?
Yes.
Clear enough to see the steps?
Yes.
Did you have any concern for your safety? And I don't mean like in a super dangerous way, but walking up to go find seats.
No.
All right. Did you need a flashlight from your phone or anything like that?
No, sir.
Could you see 5-10 seats away from you?
You could.
All right. So you make your way up to where? Is it the back row?
Back row. I sat in the first seat on the aisle. My wife sat inward.
Okay. So if the screen's behind me and you're facing the theater, were you on the left side of the theater or the right side of the theater?
On the right side.
Okay. Well, that'd be facing the screen. You're on the right side.
That's correct.
All right. So if you're sitting, you're all the way to the right of the theater in the back row.
That's correct.
All right. Now, when you sat down, you indicated the lighting conditions were the same as you described it.
Yes.
All right. You could recall what the volume was like?
It was elevated, but you could still converse.
Okay. And when you say elevated, that's coming from whatever's coming from the movie theater screen.
Right.
All right. And did you have any difficulty hearing your wife, the person you came with?
Not at all.
Did you have any difficulty hearing anyone else around you at that point?
Not so much. No.
All right. Could you hear, the chattering in the movie theater?
Yes.
Could you specifically hear what people were saying? Or maybe the better way is, were you listening to other people's conversations?
No.
All right. So you couldn't hear the conversation because you weren't paying attention to it,
Correct.
but you could hear that people were talking.
Yes.
I'm going to object. It's like 10
Last-
leading questions.
I understand.
Last two. Sustain.
Based on the level of the volume in the theater, did you have any difficulty hearing anyone else?
No.
All right, we're going to be talking about the shooting incident. First of all, did you know any of the people involved?
Thanks for
in the
subbing,
shooting?
Mark. I
I did
appreciate
not.
it.
Did you later learn the name of the person that did the shooting?
Yes.
And what was that person's name?
Curtis Reeves.
All right. Did you later learn the name of the person that was shot?
I did.
And what was his name?
Chad Olson.
All right. And we're just doing that just so it's easier to describe to the members of the jury who everyone is. When you first sat down in the theater, was the defendant Curtis Reeves there?
He was not.
Right. Did you see him at some point in time?
I caught him just as he was approaching my aisle, coming back from wherever he had been.
All right. Did you have an opportunity to watch him come up?
Briefly, yes.
All right. Is there anything about what you saw of him that led you to believe that he had difficulty walking?
Not that I noticed.
Okay. He didn't have a cane or a wheelchair or anything like
No.
that? Did he go by you?
He did.
All right. And did you watch him as he went down the row?
Only in the sense that I turned in that direction to move my knees out of the way so that he could get by. And of course, he was in my field of vision. I saw him go back to his seat.
Okay. Did you see him lean forward or do anything like that when he got to his seat?
Not really. I saw him take his seat. I didn't pay much attention at that time. I was just really kind of scanning the room.
Okay. And based on the lighting conditions, did you have any difficulty seeing him?
No.
All right. At some point in time after he returned to his seat, did you see any contact between him and Chad Olson?
I did.
Okay. And what did you see at this point?
Just Mr. Reeves leaned forward. There was apparently an exchange.
Okay. And when you say exchange, could you hear exactly what was being said at that point in time during that exchange?
I could not.
Okay. You just know there was an exchange.
Right.
Is that correct?
Yes, that's correct.
At this point, did you notice whether or not Chad Olson was standing or sitting?
He was standing.
While Chad Olson was standing, did you hear him say anything?
I did, yes.
And what did you hear him say?
He said, do you mind? I got a message or a text from my babysitter. I'm checking on my daughter.
Somebody at the door, guys. I got to take care of this.
Did you hear
Think it might be the Amazon
say
guy.
anything in response to that?
I could not.
After that, what was the next thing you saw happen?
Well, something, I guess something was said. I saw a reaction from Chad Olson where he reached across and grabbed popcorn from Mr. Reeves and flipped it back in his face.
Okay. And when you saw that happening, do you know where, let me ask you this, do you know if anyone was with Chad Olson at the time?
His wife, he was with his wife.
Okay. When Mr. Olson reached over and grabbed the popcorn,
Yes.
did you see what his wife was doing?
I did not, before the incident, all that I had seen was her hand go up to his chest as if to coax him to sit down.
Okay. And do you recall if she was standing, sitting?
My recollection is that she was sitting.
And do you know how it was that she positioned her hand? Do you recall which way it was facing?
It was her left hand and on his left side of his chest.
Okay. And do you recall, let's say that if she was wearing a wedding ring, was the wedding ring facing Mr. Olson or facing Mr. Reeves?
It would have been Mr. Reeves.
Okay. So her hand, I'm just using myself as a demonstrative aid, would be just this way facing.
Yes.
Okay. Now prior, well, let me skip ahead just for a moment. After you saw Mr. Olson, you said, how did he throw the popcorn?
He reached across, grabbed the popcorn, and just kind of brought it back and then flipped it kind of with the flip of the wrist back into the face of Mr. Reeves.
What happened right after that?
Well, I saw Mr. Reeves' arm come up from his side, extend. I saw a muzzle flash and heard the gunshot, and Mr. Olson was shot.
Was that fairly quickly after the popcorn toss?
Very, very quickly.
At any point in time, in this entire time that you're watching, do you ever see Mr. Olson climbing over his row into the defendant's row?
No, sir.
Okay. And are you sitting in the defendant's row?
I'm in the defendant's row. That's correct.
Okay. And where is Mr. Olson in relation to the defendant?
One row below.
Okay. And at any time did you see Mr. Olson climbing into the defendant's row?
No, sir.
At any point in time, did you see, other than the popcorn flick, Mr. Olson throw anything at the defendant?
I did not.
At any time, did you see Mr. Olson punch the defendant?
No, sir.
At any time, did you see Mr. Olson in a position where he's leaning over the chair as if to punch the defendant?
No, sir.
At any time, did you hear the defendant exclaiming or yelling anything that would give you the impression he was being attacked?
I did not.
Okay. Did you get the impression from anything that the defendant was doing physically or saying that gave you the impression that he was in a life or death struggle?
No, sir.
So you're telling this jury the only thing you saw was Mr. Olson flick popcorn?
Yes, that's correct.
At any time, did you see the defendant grab his head as if he was injured or hurt in any manner?
No, sir, I did.
And that would be before the popcorn.
Correct. No, I didn't see anything.
And at any time, did you see him act as though he had been injured?
No, sir.
Did you ever hear Mr. Olson threatening the defendant?
I did not.
Did you ever see Mrs. Olson standing in front of Chad Olson trying to hold him back as if this raging guy was trying to get into the defendant's row?
No, sir.
After the shot, did you hear the defendant say anything?
Yes.
Okay, and what was it that you heard the defendant say?
Throw popcorn in my face.
After the shooting, did you see what the defendant did with the firearm?
He brought it back and appeared to lay it in his lap.
Did someone come up to him at some point in time and take the firearm from him?
Yes.
After Mr. Olson was shot, did you see what happened to him?
He said, "I can't believe this." And he turned toward his row and took a step or step and a half and collapsed.
Okay. At some point in time, did you see Mrs. Olson?
Yes.
Okay. And what was she doing when you saw her?
Well, she was hysterical, of course, and had began running up and down the aisle to where I was at. And my wife was behind me. She had been shot in the finger, and we tried to help her with that. We had some napkins and wrapped her finger up. And
Okay, so when you saw Miss Olson, you saw her finger.
yes,
And what did it look like?
it looked like it was hanging on by the skin.
So you helped her at that point.
Tried to, yes.
All right. At some point in time, did deputies from the sheriff's office come to the theater?
Yes.
All right. Did you stay in the theater the entire time, meaning from the time of the shooting until the time deputies came into the theater, or did you do something else?
Well, I had, in an effort to help Mrs. Olson, I had asked her if there was someone that I could call, and trying to catch up with her, we wound up down at the exit by the screen and stepped outside, and I asked her if I could call someone to help her if she wanted to check on her children or whatever. And she said yes and gave me her cell phone and told me who to call.
Okay. Did deputies eventually get to the theater?
Yes.
All right. At some point in time, were you given a form, sometimes referred to as a written statement, to fill out?
Yes. I had to go find it, but there was a gentleman in the in the room that people kind of migrated to get the form. It was pretty disorganized at that point.
Okay. Did anyone give you any instructions about how to fill it out? How much, how little, anything like that?
No, sir.
All right. So you just put in there the details you thought would be important.
Yes.
All right. Did you assume at some point you'd be interviewed by someone in law enforcement?
Yes,
Were you in fact interviewed by someone in law enforcement?
I was.
At any point in time, did you discuss all the details of what you saw with people that were in the theater that you did not know?
No,
Everything you're testifying to, is that what you personally heard
that's correct.
and personally what you observed?
Yes, sir.
May I have a moment, Your Honor?
You may.
I don't have any further questions. Thank you.
Thank you. Cross? Yeah.
Okay, this is something I've noticed in all the witnesses. All these people in the movie theater, they got together. I mean, they were able to talk to each other, and that's a big fuck up by the police. I mean, these witnesses were talking to each other. I'll put me in timeout. Can you repeat that? But no, all these witnesses sound the same. Their stories are the same. That's a big problem. They should be different, but
Lunch
they.
now, and we'll take an hour for lunch. I'll ask you to be back at about 1:45, and we'll resume at that point.
Okay, Judge
All
Busey,
right?
thank you.
Remember my instructions during the recess.
All right, we're in recess for 1 hour for lunch.
So, yeah, they all have the same. Oh, he's got his cane. He's a crippled old man. I know you're kidding, Ole Miss. I'm just screwing around too. But yeah, all these witnesses sound the same after a while, and that's not good. There should be difference in their stories. I mean, unless it's clearly a guy did the exact same type of movement, but
I believe
it's
so,
matching
yes,
up,
sir.
and I don't.
Okay, and so he was gonna.
Uh-oh. What? Whoa. Whoa. All right, so we're gonna take a break. So yeah, guys, so far, thanks for sticking around, and remember, like, share, subscribe. I mean, we got to catch up to Viva Fry. Only 87,000 more views to go. So, is this just related to lesbian girlfriend in the Halderson trial? Maybe, might be. You never know. Sometimes they all look the same. No, all these witnesses sound the same, and I have a problem with that because there wasn't any control to keep them apart. And that's an issue because if they all say the same thing, are they now giving you an accurate representation, or is their testimony the amalgamation of what they think they each saw? Who knows? So I think there's some credibility issues with these people. I do have some concerns about that. Well, Lil Miss, sometimes there can be statements that can be exactly the same, but when everybody's matching up to the T is where there's a problem. And that's my issue. Stories match your hoodie. So yeah, I don't I mean, I'm still not convinced this is beyond reasonable doubt yet. So he's still not guilty. That doesn't mean I agree with what he did, but I'm just still not convinced. Thankfully, though, if you notice, this guy went a lot smoother. We didn't have 55,000 sidebars. Yeah, Little Miss, I forget which ones there are, but yeah, there's some hijinks there. But um, yeah, I'm just still not convinced this is crime yet. That doesn't mean it wasn't. I'm just, they got to meet that burden, and they haven't met it yet. Matthew, you asked a question a while back on one of my videos, and it was about how do pretrials work. And I thought about doing a video, but I also thought it'd be better to use it as filler here. Um, the way pretrial works, uh, pretrial can really be anything. Sometimes I've had pretrials that are like 2 seconds. You walk up to the judge, hey, we're still working on it, and the judge says, cool, have a good one. Sometimes the pretrials are the judge saying, okay, what's this going to look like for trial? How many days is it going to take? How many witnesses are there? Do we need anything special? Are there any serious issues we need to talk about now? There are some judges who will hold 15,000 pretrials over the course of a case. There are some judges where you have a first pretrial, a final pretrial, and then your trial. They don't screw around. It can be anything in between. Now, as far as like testimony at a pretrial, a typical one would be a suppression hearing. So, for example, if I was trying to suppress evidence of drugs or guns found during a traffic stop, that officer has to go up on the stand and talk about what he saw. Well, he's giving testimony. That testimony is evidentiary. Um, that testimony can be used later at trial. For example, if he says something completely different. That's typically the type of testimony you're going to have. The defendant's never getting up on the stand early. But other types of testimony might be like if there's a pretrial and your client's on a GPS monitor and there's allegations he broke the rules or he interacted with a victim or he tested positive for drugs at a pretrial hearing. You can have testimony for those things. So, for example, if it's the person in charge of GPS monitoring will have to come in and testify saying, yeah, here's where he did, here's how he went, here's how I know that. If the victim might testify to a tangential issue such as, yes, he called me, here's the number he called, he should not have contacted me. Might not be related to the case, but it's a separate matter she's talking about. Or if you test positive for drugs, the person in pretrial services might come up and say, hey, here's the drug test he gave, here's the sample inside here, and we shook it up and we dipped the stick in and it tested positive for, pot. So that's the type of things that might happen testimony wise. Really, anytime you're on the stand is testimony. So it could be any number of things, but usually pretrials don't involve testimony. It's usually counsel talking with the judge about what's going to happen. I hope that makes some sense. Now, trying to go back on some things some people actually had questions about. Yeah, does it matter at this point? Would I want to defend the dad or the son first or the Millers? Based on the evidence so far that I have access to, I don't think it matters. Really, because there might be more evidence that would swing me one way or another. But did the dad have a reasonable belief that he had the right to use force? Was the force justified? I think he did when the guy came at him with the bat and he shot. And then for the son, did he have the right to believe that his dad was in reasonable fear of death or bodily harm? And then he shot once the bat was thrown. I don't think either one's. You could try either one. It doesn't affect the other if that's what your concern was. Like, do you have to get the dad acquitted and then that means the son will get acquitted? No, because he's still judged under the same metric, but he has to be judged independently. I hope that answers your question. If it doesn't, let me know. So what else are you guys talking about today? Anything else? I tried to go shill over on Law and Crime, but I think they kept deleting me. Gabby, as far as getting shot, I try to explain it like this: when you're shooting somebody, you are. So, Gabby, I guess I'll explain it like this: when you're in a situation and you think somebody's trying to kill you or hurt you, you're not just going to take like one shot and go like, bang, and you're going to like, oh, are you okay? Or like, did it work? No, generally speaking, you're going to go bang, 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 bang. You're going to make sure they're not getting back up. I mean, you're going to make sure that it's done. So it's not necessarily overkill. And I mean, how many shots is overkill? If the guy is not stopped, is it one shot? Is it 2 shots? 3 shots? 4 shots? If the guy doesn't fall down right away, how many shots? I mean, and also if you're shooting quick, bang, bang. Okay, well, if it's too fast for you to react, do I have a video on the mattress guy? Yeah, we can show that. And I want to bring up though this point you were talking about, this shooting too much. So here we go. Just it's the point of people don't go down. And I'm not necessarily encouraging you to look up videos of police shootings or videotape of what's going on in Syria or Iraq, but people just sometimes people don't die. They don't stop. You have to keep going until that person stops. And also, it's a very highly charged situation. So, yeah, things might get a little out of control. Yeah, so here we go. I mean, this is a great example, I think. All right, here, let's see if I can put this up. Share. Stop screen. Share. Don't show this tip again. The Chrome tab. Yes. Here we go. So we're gonna watch this one. I want you guys to watch it. It doesn't I mean, if you have some training, you shouldn't be shooting to slow someone down, Gabby. If you're shooting people, you're stopping them because they're a threat to you. You're not going to try to shoot them in the leg, slow them down. If you're going to pull out your gun and put it down on somebody, you'd better be trying to stop them fully. And by stop them, I mean kill them. Also, if you guys have never seen somebody get shot up close and personal, it's going to be a little different than what you expect. But once again, this is the world of criminal law and criminal defense.
It's smoked. Man, shoot his ass. Man, shoot his ass.
So
shoot his ass.
This is just shoot an example. People don't go down sometimes.
Man, shoot his ass. Man, shoot his ass. Shoot his ass. Damn.
All right. If you don't want to go down and your body can sustain it, you won't go down. So that's how it goes. Now, yeah, we'll go to the Dumpster Bros real quick, see if I can find that. Let's see here. Um, let's see here. Trying to find one that's not got a ton of commentary on it. I just want us to watch it. And I don't see it. Hold on. Let's see here. Yeah, I'm trying to find it, guys. It's not going well here. Uh, yeah, hold on, guys. I'm trying to look for it. It's I don't know. It's tough when I've had it up before and I've looked at it and I had it ready for a video I'm working on, but it just you don't have it right away when you need it, and it just drives me crazy. So let's see here. Yeah, I can't find it right now. I apologize. Yeah, they don't start till August, which will be fun. One of them will start. Gabby, that wasn't meant for you, but it's meant for the other people watching as well. Um, yeah, it's not good. Oh, Loomis, you put a link up. Let me see. Uh, what about the link you put up? I didn't see your link. Uh, yeah. Um, so if the defense lawyer's asking if the defense plays the audio portion of the interview following shooting, does that take the place of putting him on stand? It does. It does. It's a great way to limit things. Try to, you can only do so much. You can only you can't cross examine a video. So, oh no, yeah, Rennie, I know that. I just didn't know if she had clicked and put it in there somewhere as a link I could copy and paste and play with. But yeah, it takes the place of things. It limits it, and it's also just a great way to get it in that you don't have a problem. So, uh, yeah, that's it. I'm a speed reader. But yeah, it's aside from this going slow, this is what defense work is. Um, I'd say the Audrey Cole and this are examples really of how things are usually likely to go in the world. It's not as flashy and dashy as Chandler Halderson or Kyle Rittenhouse, but this is a little more towards the normal side of trials that you'll have somewhere in the country. How bad was Cross first thing this morning? It was rough. It was plotting. They were poking a million little holes in every little thing. Yeah, detective, you misspelled this word, didn't you? Do you not know how to spell? You forgot the comma here instead of a semicolon. It wasn't effective. I don't think ultimately. It did show that the police didn't do everything that they probably should have done, but it's not enough there that you can just walk out of the courtroom and say, we slayed the dragon. So let's see here. Sorry, I also got to read some emails too. I think some stuff just came in. We're done. Sorry. Actually got an email for the trial we're starting next week. We're done in a day. Okay. All right. Sorry about that. Kind of have to answer that crap as it rolls in the door. Some people can't act right. Yeah, but that's a common thing. Oh, yeah. Somebody mentioned Discord. I got to work on that too. Jeez. There's so much. I mean, this is fun to do, but gosh, there's a lot of work involved in this crap. Holy cow. I'm not saying that in a bad way. I'm just like, wow, I keep forgetting all this stuff. I have a list of things I want to do for this, and it feels like it's not going away. Um, uh, hmm. All right. Yeah, sorry guys. A little bit of dead air here. Good morning. We are experiencing an internet outage. Yeah, yeah, we've had that problem too. It's funny how that's going around. That's it, guys. I think the weather's died down here. We believe in your time management skills. Yeah, you shouldn't. Um, you really shouldn't. Or ability to go without sleep. Yeah, I had to do that a couple of times in law school, but I worked nights, so there are a couple days where like I went to work and had to go straight to school. Yeah, those weren't fun. I try not to do that stuff anymore because that's pretty brutal. Uh, oh, the firearm. Okay, yeah, I'll take a look at that one real quick, see if I can see what's there. All right. Yeah, I think we'll put that one up and see what we can do here. Share, stop screen, share. God, this StreamYard thing is 100 times better than Streamlabs. I'm not fighting it, and I'm not giving you guys black screens the whole time. So, yeah, this is good. Good news. I think we'll keep working this way. Hopefully you guys like it. Well, actually, if you don't, I'm not exactly too upset if you don't care. So he was like, yeah, let's watch the Dumpster Bros.
If you come closer to me, I'm gonna kill you. Hey, did you hear him say he's gonna kill me?
Yes.
I'm at the dumpster. Put the gun up and go inside.
Okay, yeah, he gave you a conditional threat. If you come closer, I'm going to kill you. If you come closer, I'm going to call the police. He hasn't said I'm going to kill you right now. So that's not a threat. Although the guy's holding a gun, so that's a little bit different. But once again, there's also the legal axiom of because Texas. So I don't think this is illegal yet. But listen to the male Karen with his voice all screeched out, and I don't know, maybe he smoked a lot of cigarettes too, but listen to who sounds crazy right now and who doesn't.
You pulled a gun in front of our children. In front of my kids.
Does he need his life to prompt him? Because that wasn't an issue. He just said he didn't bring it up until his wife brought it up. But let's just keep going.
I'm standing my ground. I will kill you dead. I promise you, you're both dead.
It is an alley.
You are in an alley. I'm gonna kill you. I doubt it. Bet.
Okay.
Oh, if you're going to show this video to the cops, you might want to stop yelling.
Oh no! I don't give a back off. You pull that.
The kid brings up a great point. Yes, you should be running around threatening to kill people. Also, if somebody has a gun, and I think I mentioned this before, just walk away. But telling somebody who has a gun when you don't have a gun, I'm going to kill you, just not a good idea. Just not a good idea.
That gun one more time before I'll take it up with a bullet through your head. No, you bet. Point it at me. Swing. Point it at me. Go ahead. Point it at me. Make you swing. Point it at me. Back off. Point it at me again. Back off. Point it at me again. Back off. You're a dead man. I doubt it. If you come within 3 foot of me, I'm going to kill you. Okay.
You're not going to shoot my husband.
Come on.
Okay. Yes, and this is the other thing. Telling that guy with the gun when you don't have a gun, oh, you're not going to do it. I dare you to do it. You don't have the balls to shoot me. Yeah, that's never never a good idea. Why don't they take you up on that? And also, I don't know what Karen's idea was, walking up to everybody and getting in the middle. Like, you're not going to do that. It's like, they pulled out guns over a fucking box spring in the back of an alley in the middle of fucking Texas. Do you really think they're scared of you waving a cell phone in their face saying, you're not going to shoot him? Yeah, no, they're not. Karen should have stayed out of the way. It's a good thing she didn't get shot in this.
Shoot me. You're dead. Point it. Point it.
Okay.
So I just received the tobacco captain from Thursday Boots.
Okay, so at that point, there's the shooting. And it sounds like at that point he had grabbed the bat or made an aggressive act. So I gotta pause it.
If you come within 3 foot of me, I'm gonna kill you. Okay.
You're not going to shoot my husband.
Come on.
Hold on here. I want to get
Shoot me.
paused.
You're dead. Point it. Point it.
So he shot. Okay, why did she act like an idiot? Because of Texas? Okay. Yes, this is the Texas dumpster shooting. This is an oldie too. This is from a couple of years ago. Just like what happened with that, this is a very common, this is an older shooting that's gone on for a while. I remember when this came out. Yeah, Chaya, why are they fighting? Well, the angry mean guy kept on throwing a box spring out, and in Texas, I guess in this town, they have the town has dumpsters and it's just basically a bigger garbage can. You can throw crap in, and they'll come take it away, and it's not part of your normal trash, I guess, or is part of it. I don't know. Well, this guy kept on throwing a box spring out there, and The father and son were like, you can't do that. It's going to, cause everybody problems. And they kept on throwing it back on his property. Well, angry guy kept bringing it back out, and eventually there's confrontation. I'm betting the guy who was bigger and acting like a dickhead threatened to hurt him or, towered over him and caused him an issue. So they came back at him and they brought their guns. Bigger guy didn't like the fact somebody was kind of not backing down from him, so he lost his mind. Yeah, bulk trash gabbing, maybe. I'm not really. It's in Texas. I don't know. They call it armadillo disposal. Who knows? Am I the only one seeing a bra made of chest hair? No. You are seeing that as well. Well, Gabby, did he bring? He didn't bring a fist to a gunfight. He brought a baseball bat because as we hit play, we'll see what happens. Yeah, if you see that and you hear that noise, that's a bat being thrown and hitting the ground. And then once his dad gets hit, his dad looks like he's in the middle of the fight and can't defend himself.
It is.
There comes Junior with the gauge, with the street howitzer, with the street sweeper. He's got that thing on him. And he comes in and lays down some hate, which, if my dad was getting attacked and I had a shotgun in my hands, I'd probably come up and start laying down some hate too. So I think his is actually a little more justified. I mean, it's I don't know if a jury's going to convict. Part of the thing that helps you be a credible victim is you don't look like a complete dickhead. And, the father and son may have looked like, a little bit of an asshole there, but who was the one screaming and ranting and raving and saying he was going to kill people and just acting like a complete lunatic? Was not the guy shooting guns. So, obviously the prosecution disagrees. I do agree that that was an unnecessary shooting over something completely stupid. Do I think it is self-defense necessarily? No, but I easily can see a jury supporting these guys. Once again, because Texas. Gabby, you want to rewind a little bit? Hold on, I got to get back to it. Hold on. We'll watch it all the way through just to have it done, because that's, I think, part of the issue. All right, hold on here. Share screen. God, I'm getting good at this.
It is an alley. You're in an alley. I'm gonna kill you. I doubt it.
First of all, if you're going to show this video to the cops, you might want to stop yelling.
We'll just watch from the beginning.
I'll give it. You pull that gun one more time, before I'm taking it up with a bullet through your head. No, you bet. Point it at me. Swing. Point it at me. Go ahead. Point it at me. Make you swing. Point it at me. Back off. Point it at me again. Back
yes,
off.
Gabby, he did swing a batter stick.
Off. You're a dead man. I doubt it. If you come within 3 foot of me,
yeah, Rennie, you're right. And like I said, this has been an ongoing dispute.
My husband. Come on. Shoot me. You're dead. Point it. Point it. It is clear that each man had a right.
So that's the yeah, you can hear the bat and you can see it hit him. I don't know if he swung the bat at Dad or came towards him with it, but after he gets shot by Dad, the dude throws the bat, and then son immediately starts shooting with the shotgun. So, because you can hear him throwing the bat at the guy. So, okay. Oh, you emailed it to me. All right, I'll take a look at that. Give me 1 second. Gmail. Gmail. They have Hayes. What? Video of the mattress shooting. Oh, you've got it unedited without other stuff in the way. I like that better. Oh, behind a paywall. Boo. Hold on here. I wonder if I can open that up in an incognito tab. Yeah. Oh, goddamn paywalls. How dare people make me pay for their work? What is this? Capitalism? Of course. Uh, so no, I have it saved somewhere because I downloaded it because I was going to do a video over it. But yeah, that's coming up. That's an interesting one that's going to be there. Do you recognize the person? Could he take off his shirt so I can be sure? Yes. Sir, do you recognize the man's areolas? Yes. Thank you. Do you recognize the pattern of his chest hair? Can you describe it to us? Is it wavy? Does it look coarse? Do you think it's soft enough you can nuzzle up to it and it would feel comfortable? Your Honor, would the record reflect that the witnesses identified the defendant, or at least his nipples? Jesus. Oh, oof, oof, oof. Well, in other news, it looks like the Canadian truckers have not been Tiananmen Squared yet. And I understand people may feel one way or another about that, but as I'll talk about tonight, the suspension of civil liberties for this, like they didn't invoke this law on 9/11 when, they could have been under attack as well. Like the World Trade Center falls and hits the ground and they don't invoke this law. So this is now a more serious and scarier thing than 9/11. Yeah, just the idea that if you voice disapproval against the government and they determine, well, you're a terrorist, well, they can freeze your bank account. Well, how do you unfreeze it? Do I just say, hey, government, I went home? Is that going to be good enough? Who knows? We don't know what the rules are. So it's not who it's being used against, but it's what's being used. And if you can't tell, I'm not exactly a fan of the government, especially not a fan of the state security apparatus, regardless of where you are. Our group, okay. Yeah, the Canada blockade. It's actually not the first time it's happened. It happened back in the 70s. The Canadians did this. And it's starting to happen in other places too. Like I guess there's a group of them in Austria going towards Vienna. That said, though, I'm not sure a bunch of German-speaking people using mechanized equipment in a mass formation kind of gives me vibes something bad might happen. Because, we've had experience with that before, but hopefully, war doesn't start. That is what the. Okay, hold on here. Whoa. What are we? The care. Okay. What is the bigger question up there is, how do I undo it? No one can give them a straight end. You're gonna. I'm confused. Okay. Apparently, I'm really lost in shit right now. So, sorry. Oh, the Canada bank account freeze. Yeah. How would you undo that? What happens? Let's say, okay, that makes sense now. Yeah, what happens there? And such as their attorney general saying, oh, if you've donated and you have ties to certain groups, we're going to come after you. Well, how's that going to work? Because you can't freeze my bank accounts. My bank's not a bank that's recognized in Canada. So, yeah, how would you get through that? And also, if you happen to be a person, I'm not a person on the political left, but it's something to think about. I know people on the political left talk about the idea of striking and workers' rights, but also the idea of a general strike where everybody goes on strike to get something done, which, that actually would, if you wanted to get your voice heard and things to change, yeah, that would probably be really effective. But it's that's the dangerous part with strike. It's a prisoner's dilemma. there's an incentive for somebody to flip. But if there's a general strike, do you think the Canadian government's going to let that happen now? Even with Justin Trudeau, who holds himself out as being the liberal and being on the left? No. And even the further left party in Canada, the NDP, I think that's what they're called, the Orange Party. Well, yeah, they're going to crush a general strike too if it hurts and causes enough economic damage. So, it's when this gets used, it never goes back in the box. And once one side uses it, you may not like the fact that the other side uses it against you, but you've established that's the rules of the game now. So, I think there's a lot of problems in Canada. In addition, the government using force should be direct and brutal. I know a lot of you are older people, but there's a guy on YouTube. His name's Vosh. He's a libertarian socialist, for whatever that's worth. And he talked about it, and he's correct. You want the government's power to be used in a brutal and open way. You don't want it to be used in the dark of night under a trench coat. You want it to be overt and not covert, because if it's overt, you can identify it and you can fight it, and you might be able to change it. But at least you know what you're dealing with. When it's some bureaucrat sitting in an office somewhere who's making decisions, how do you fight that? Who's the guy in charge of freezing bank accounts? How do we get to him? Is he held accountable by somebody? Who holds account over him? Is it the politicians, or is it a guy who works in an agency somewhere? Well, you can't control that guy. You can't get him to do what you want. You can't sue him. So there's something to be said about the government acting out in the open. I'd rather they not do that, period, but at least you can fight that. Yeah, okay, yeah, sorry, yeah, and that's, and Joe, I appreciate that. But yeah, that's the thing. If, for example, if you want to go on a strike now and you're in Canada, I guess you have to hope you're not in a economically critical area of the economy, or the government's going to crush you. They've already demonstrated that they will, we have to protect international investment. You don't want to do that. Thoughts on the prosecutor seeking a 7-year sentence? At the end of the day, I don't think she should have been prosecuted. I mean, because if she had used a gun instead and intentionally meant to shoot him, cops will shoot you if you start trying to drag them down the street in a car. So, yeah, I don't know. I think they were improper jury instructions there. But, I mean, given the alternative, 7 is a hell of a lot better than 15, 20, 100 years in prison. She can't get 100. But you get my point. It's better than the most. But, yeah, that's a bit stiff. But, that's the risk you take when you interact in life. And, Joe, I appreciate that we can talk because, in 2022, the internet is serious business and you can't have a disagreement. I don't know if you guys have covered this, but it came out last night. Have you guys heard about the guy on TikTok who claims he was the hacker who was hacking in all kinds of crap, like Give Send Go, and doing all he hacked Parler, hacked Gab, whatnot. I'm probably going to cover that as an add-on tonight. If you have any other ideas for things you want me to cover, feel free to throw them up here or throw them in the comments for that post I made. Maybe we get to it or not. But I mean, in reality, is 7, a couple of years for manslaughter. If in Ohio you kill someone and it's a manslaughter case, yeah, 7 years is probably within the sentencing range. I don't think the judge is going to nuke her if that's what you're thinking. Like, are they going to ask for 7 and the defense asks for less, and the judge says, well, screw that, 15? Yeah, that's not going to happen. I could see her getting less though. I think she probably does get less. I hope she gets less. I hope she gets as little as possible. Can't we all just get along? Yeah. Why can't we be friends? Yeah, I'll stop singing. I know I'm bad. There's a reason why I'm in law school. There's a reason why I went to law school and not Juilliard. Oh, hi, Wendy. Thanks for joining. If you listen to me for a little bit and you don't think I suck at this, I'd appreciate a like and a subscribe. I hope she wins on an appeal. Yeah, here's the problem, Matthew. And I think you're from England or Wales or Scotland or Northern Ireland, or you're somewhere over there. Gibraltar, I'm not sure, wherever. Appeals, you're already in a bad spot because you've lost. I'm working on an appeal right now for a guy who got convicted of manslaughter. There's a lot of things that you can bring up during a case that don't go right and that they're wrong. But I would encourage you, and I'll talk about this because I'm in the process of writing this appeal. I'll cover it, is harmless error. And basically, an appeals court is going to, and you could disagree with this, I certainly do. Appeals courts in America are generally loath to overturn a lower court if they can avoid it. Why? Well, because if they overturn everything, it causes a ton of problems. Number one. Number two, especially if it's a jury trial, there's a big idea that we respect juries. You want to keep that somewhat sacrosanct here. So that's kind of important. I think Andrew Branca said it best. Appeals are for losers. You've already started with the presumption you lost. Now you have to convince the court, hey, I didn't actually lose, and here's why. And the court's going to say, yeah, you know what? The court messed up here, but the evidence was overwhelming. Or this piece of evidence shouldn't have been in, but even if we got rid of it, there's a pile of evidence behind you that you can't get through. Oof, that was a little bad. It looked like I was looking for Kyle for a second. A little bit of a joke there. But yeah, it's tough. And I've had cases where I'm like, oh my God, this is massive. I think I can get the case overturned. The appeals court says, nope, don't give a fuck. And even when you do get things overturned, generally speaking, it's generally like at a sentencing or the person gets resentenced. You're not going all the way back to a new trial. I do have one appeal I won where it completely got thrown out. It was on a speeding ticket. Yes, I completely won and got a case dismissed on speeding. And it wasn't something cool like somebody going like 150 miles an hour down the highway. She was going like 50 and a 35. And it was about the fact that the officer using the radar gun hadn't been trained on it yet. That was it. Okay, so I like to tell you, I got some guy's wrongful murder conviction or questionable murder conviction overturned, but nope, just a fucking speeding ticket. $150 fine. That's all I got fixed. Was it with his feet? Who did what with his feet? Oh, I can't. We're not talking about that guy. If you're talking about the person, I think. Rennie is referring to. I have a story I might tell at some point involving my time as a public defender when I got on the news. Been on the news for quite a bit. We'll talk about that at some point. Oh, the feet thing. Oh, the murder case and the feet thing. Oh, yeah. Okay, that's separate. Yeah. That's a different thing too. I think she's guilty in a civil case, but not criminally first degree guilty. Yeah, like I said, she could be liable for screwing up, but Yeah, I don't think criminally she could be. And Matthew, even if she was liable criminally, I mean civilly, if you sued her, she probably has qualified immunity because it wasn't. I think it's an accident. Besides, you wouldn't sue her because she doesn't have any resources. You sue the city. You sue the taser manufacturer. Why? Because they got checkbooks and they'll settle. Andrea, yes, laws are very much constructed to achieve a certain goal and a certain objective. Usually, it's not meant to protect the populace and give them the benefit of the doubt, or the accused the benefit of the doubt. Let's see what else. What else has somebody asked while I was rambling like a moron? Uh oh, you're from Wales and you live in England. Oh, okay, cool. Yeah, my heart is really in that case. Hmm. It's just how things go, Andrina. It's always a gamble in a trial. You can have the best evidence in the world and still lose. All the facts on your hand side and still lose because it's all about sales. Who's the jury? Which story is the jury going to buy? And I don't, some of you are thinking, well, it shouldn't be considered a sale, but it is. It's a popularity contest. Which story do you like more? Nope, I should probably refresh this to make sure we don't get bushwhacked. Sheriff Grady Judd. Okay, tell me, does this guy not look like Bob Saget to you? Because he does to me.
Also jack up the price. It all has to be right now. We can do it right now.
Does he look like Bob Saget to you guys? A little bit to me, at least.
Selling when they rip you off.
We now know where he went. He didn't actually die. He ran off
and
and started a new life.
To repair for $5,000, he went to another.
Yeah, Matthew, you can have the best evidence in the world and hire those guys, but they probably would be fine. But it doesn't matter sometimes. The jury is, what they're going to decide what they want. You can't force them to come to a conclusion. So make yourself a salad. Well, enjoy your salad. Well, it's 1, 2, 3, 4 p.m. I always like when I can see that on the clock. Also, I'm going to see if we're getting crushed by a storm again. Oh, nope, just rain again. Let's see here. Okay. So did everybody have a good Valentine's Day, or for some people, a Singles Awareness Day? Oh, I think I got another email. Oh, no, I'm not buying junk. Sorry. Did you hear about Bob's family blocking the autopsy results? Yeah, and I don't think there's probably any sort of conspiracy there. They, you know, I guess you have to think about it this way. I mean, autopsy results are generally public knowledge, but if one of your family members keels over tomorrow, and God forbid, I hope that never happens. But is somebody in Ohio going to give two craps about what happens to this guy? No. But he's Bob Saget, so yeah, he's famous and people want to know. And for a lot of America in the '90s, he was America's dad. Um, if only they realized all the jokes he would tell when he did stand up, myself included. But yeah, I could see why they want to block those and keep it private. I mean, it's not going to be the coroner saying like, "Oh my God, he was clearly murdered." It was Colonel Custard with the pipe. It's just they probably want to be private about it, and I don't blame them. But should that happen? No, I don't think that's a. I'm going to take these off because I don't need to. God, I feel like I am a fucking idiot. I don't need these on right now, and I had them on, and that was stupid. Jesus. And I think you guys actually think I have a valuable opinion on stuff. But yeah, I don't blame them for wanting to protect it, but should they be able to protect it? No. So, yeah, like I said, we shall see. I don't think it should be legal. The meth case and manslaughter case are separate cases. Yes. The trial I have on Tuesday is a guy for possession of meth, and the appeal I'm working on is for a guy in a manslaughter case. So they are two separate things. Well, Wendy, Bob Saget's stand-up was a trip after it, but I'm 36, so I remember when Thomas the Tank Engine, his show was narrated by George Carlin. And then once I got to high school and I heard a George Carlin album, that was a massive surprise when you hear George Carlin do stand-up. On a scale of 1 week to O.J. Simpson hauling with his trial take, they'll give O.J. Simpson a run for its money. No, I think it'll be over next week, but good Lord, this is a lot longer than it should be. Most people don't realize, though, OJ took forever. The other thing, too, with OJ, he was in jail the entire time. He was in jail the entire time. Mm-hmm. Yeah, I don't know if I've heard that one, but I've heard a bunch of his stuff since then. So maybe I've heard him at the Fox in Atlanta. Shouldn't have lost his straw, but could have just eat the bag. You guys are something else. All right. So what else? Yes, the Simpson jury was sequestered, and as much as I don't like Jeffrey, as much as you want to make fun of Jeffrey Toobin for what he's done since in most recent memory, the book he wrote, The People versus O.J. Simpson, on which you can read, but I will tell you that the TV series, the American Crime Story series done about it, I thought was very well done. It was pretty cool. And yeah, the jurors revolted after a while because they were basically, you get a newspaper with half of it cut apart, and you were only allowed to watch like certain TV shows that had been taped for them. It turned into a big mess. Yeah, so the jury was sequestered the entire time. It was a disaster. OJ really transformed how a lot of courts handle things. You know, they realize sequestration is bad. You got to be very careful about it. Learning how to handle the media, which, you know, Judge Ito ultimately didn't do that bad of a job at things. I know people like to give him some shit, and yeah, he didn't do some things right, but overall, he did a pretty good job, and I think he set the standard. Well, Sandy, I liked the kid show a lot. I liked Thomas as a little kid. Wasn't as catchy as the song they have now for him, but then again, though, I also thought like Sir Topham Hatt, now that I'm older, was like the crime boss of the island of Sodor. You know, just because he was able to get the trains to do whatever he wanted, like the Don Corleone of it. Remember the chase live on TV? Yeah, that's. I would have been like 9 years old, so or actually 8 years old. I don't remember the chase. So, what else here? Making sure I didn't miss anybody's questions. Yes, Wendy, we were watching the Curtis Reeves trial, the popcorn murder. Um, yeah, they're at lunch. They should be coming back and oh shoot, mentioning that it should be. I should get off my ass and you guys are here to listen to me, but also should get the trial all set. I shouldn't be screwing around completely. Oh, not ready yet. Not ready yet, but I should be ready to handle that for you guys. Yeah, I was just keeping track. Just opened up Viva Fry. Apparently, nothing bad's happening in Canada stand yet, except a bunch of people saying sorry. Um, if you have to defend yourself, do you have to take P test? Really don't know. Are you saying? Hold on. Are you asking retired road dog if you defend yourself? Do you need to? Well, can they make you take a urine test? Yes, Matthew. They'll start in a sidebar. Now, I mean, road dog. If that's what you're asking, like, could they make you take a urine test? It's not the same as like and for those of you not in America, if you get accused of driving drunk and they can make you take a breathalyzer test, or they can get a warrant for a blood test, or they can make you pee in a cup and they can test your urine. If you are involved in a shooting, no, they can't force you to take a pee test. They could ask you. Now, you would have to probably be displaying symptoms of impairment. Are you acting drunk? Do you smell like alcohol? Has somebody said you've been drinking? If they think you're on drugs and you're displaying symptoms of being on drugs, I could see that happening. But in those situations, they might send you to the hospital, and the hospital, if they think you're drunk or on drugs, they'll probably do a blood draw, and then if they do a blood draw, well, the police can get a warrant and get the blood results. So it's not a mandatory thing, but for a police officer, yeah, if you use deadly force, really any force for the most part, where you got to send supervisors out, yeah, they're going to go make you do a drug test, but that's different. And that's only for your condition of employment, meaning you could refuse it. They'll fire you for violating, police department policy, but they couldn't use that against you in court. Yeah, Sandy, I'm sorry to hear that about your brother. But yeah, if the person's mentally incompetent, there's not a whole lot they can do, really, unless he gets restored and comes back to sanity. So I hope that answers your question. Let's see here. Yeah, that's it. Where are we at right now? Also, I should mention this is in Pasco County, Florida. It's just to the north of Tampa Bay in the St. Petersburg area. It's a little less populated than the counties like Hillsborough and whatnot, where Tampa is. Actually, how many people live there? And I believe Pasco County is one of the counties where Live PD used to do their thing at. Yeah, it's Newport Richey, Florida. Population is 464,697. Who is that? Is that the garbage truck? Why are they sending the vacuum truck down our street? Okay, sorry. Just seeing what the hell's going on outside my window. If we miss after last break in the trial, should we view? Yeah, Wendy, they stopped making live shows. They kind of self-canceled themselves during all the unpleasantness during 2020. I don't know if they're back yet, but I knew they said they were going to try to come back. You can only imagine myself as an attorney. I can't stand watching it because all I do is scream at the TV, quit letting them search your shit. Don't talk to them. And that doesn't happen. So, and I also think some of the tactics the police use are unethical, but, c'est la vie. Let's see. What is going on in the world right now? Oh my God, I need to take a picture of this and send it to my HOA because I don't know if they know this is going on right now. You're thinking, oh wow, he's an attorney and he lives in an HOA. It's how it goes in life, guys. It's how it goes. Okay, let's see here. No, they're still doing yeah, nothing new yet. Screen TV is not the best part. No, it's not. When I watch videos of dash cams as part of like Discovery, I do that enough. So I don't need to do it anymore. Yeah, Matthew, that's correct. There have been a lot of sidebars. There haven't been any absolute, bombshells this morning. The detective finished up his testimony this morning. That took forever and a day. And then this guy's up testifying. It's coming back. It's not showing up for me on the Fox feed. Huh. God, if I don't want to use long crime. You guys are dickheads. Oh, sorry. My dryer just made an introduction into the chat. Yeah, I don't want to use them just because they're dickheads. I think what they were trying to do to Nick Rekieta is unethical, and I can't wait for them to get crushed. If he goes after them, and then whatever. So Long Crime can they can fuck themselves. What the heck is going on? Oh, you're killing me. Yeah, so we're just going to keep waiting because I don't want to use Long Crime. I don't want to give them that satisfaction. So, Critter, it's a neat part. They're not always late. The only person, the judge is always on time. So. Let's see here. Yeah, it's not started. It's just showing the. Oh, yeah. Ooh. I guess it's time, sports fans. Yeah, we're gonna have to switch over because I don't see the news getting this unfucked right now. And I apologize for swearing, but I have to mind my manners so much while I'm working. It's hard not to. I don't give a fuck about the guy in the asphalt scams. Fine. Long Crime. Here we go. Hope I get a letter from Dan Abrams. You guys will sure as shit know what I'm gonna do. You'll love my reaction. Probably photocopy a picture of my balls off a scanner and give it to them. Some of you are thinking, wow, Sean, would you really do that? Oh, yeah, I contemplate sending them my yam bag. I enjoy swearing. I'm a Canadian, though. Yeah, well, good. Then I don't have to tell you sorry. Or is it sorry? Or do I have to say that in French? Pardon. Yeah, sorry. I see construction equipment down my street, so I'll just leave that alone. Miss Sassy Pants was on a roll this morning. Figured she was blocking people. I hope that you're talking about in like Long Crime or something, because we don't block people here. We're kind of like Somalia when it comes to stuff. Okay, let's see here. I do not like this. I do not like this. Yeah, wow. Fox is just pissing away their chance to get, revenue. All right, fine. I guess we have to give these fuckers some attention. Yeah, did you hear that, Dan Abrams? I said that.
Yes. Jurors enter the courtroom, Your Honor.
Oh, Gabby, I gotta switch over to my YouTube side this because I'm just running off StreamYard. I think we had talked about this before, but I think you wrench you up, girlfriend.
Thank you, Deputy. Ladies and gentlemen, thanks for coming back. Were you all able to abide by my instructions during the recess?
No, Judge, we went out and did whatever the hell we wanted.
Started directly. You want to call Mr. Turner back in? All right, Mr. Turner, I'll remind you that you're still under oath. Okay, still under oath. Thank you. Go ahead. Oh.
Oh my god, we had another sidebar about the sidebar. So I don't know. Can you guys tell me, am I showing up in the long crime chat when I try to shill myself over there? I just thought it'd be kind of funny. Okay.
Okay, I'm putting the, yes, off the record.
Like what the oh my god, what are we doing? Oh, Jesus Christ. If we keep doing sidebars, I'm just going to take a nap and then catch up. Do 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 do. Do 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 do. Do 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 do. Do 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 do. Do 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 do. Do 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 do.
Very good. Thank you again. Just did a little practice run there and make sure you were all awake after lunch. So, all right, we're ready to begin again. And I would remind Mr. Turner that he's still under oath. Mr. Escobar?
May it please the court, counsel. Good afternoon, Mr. Turner.
Good afternoon.
Mr. Turner, you're retired?
I am.
And how old were you back in January of 2014?
59.
59. Okay. You went with your wife to the Cobb Theater, is that correct?
Yes, sir.
Okay. And I believe you indicated on direct examination that when you first went in, the previews were already playing.
Yes, sir.
Is that correct?
That's correct.
Okay. And so you walked up the stairs with your wife and you all took a seat at the very top row, which I'm just going to call it row A for identification purposes. Okay.
Yes, sir.
Is that correct?
That's correct.
And so if this is the, I'm going to use this as a screen. So if this is the screen, you were all the way to the right on row A. You were at the very.
Thanks, Road
you were
Dog.
seated at the
I
very
appreciate it.
last seat
Correct.
of row A.
Facing the screen.
Facing the screen.
On the
Just think
right.
that's a theater screen right there.
Yes, sir.
And your wife would be to your left.
That's correct.
Is that correct?
Yes, sir.
Okay. And You normally like to sit, obviously, at the end. Is that correct?
Yes, sir.
So that you can go to the bathroom whenever you need to.
It's more to be able to stretch my legs, but yes.
Okay, I know that you've had some, I guess, problems with your legs in the past. Is that the issue?
Yes, sir.
And were you using a cane back then or not?
Intermittently, I did.
I know you had fallen quite a few times.
Yes, sir.
And sometimes you were in need of a cane and,
Yes, sir.
and sometimes not. Is that correct?
That's correct.
Okay. And so you just don't recall whether that day you had a cane?
I'm pretty sure I did not.
Okay. Now, when you went into the previews, since
Did
they
you have
were
your
already
life alert
playing,
on?
they were loud.
Yes.
And when we say loud, that's the word that you've always been using in your testimony, correct?
As I recall, yes.
You haven't been using historically the word dim. You've been using loud, right? Or low. You've always said loud.
For the vocal, yes.
For the vocal.
Yes.
For the previews being loud.
Yes.
And you've always used the word dark in reference to the lighting.
No, sir, I don't believe that's correct.
Yeah, apparently I'm not a big enough threat. They won't block me. That's almost an insult at this point, sadly.
You want a 2486?
I'll be right back. I know I'm not going to miss much.
You can also do 24/7 reading lines, 18 through 22.
Yep, we're going to talk about all that here. Now, you would agree that you've used the word darker, right?
I've used dark, I've used dim, darker, yes, sir.
Okay, and so let's talk a little bit about what that means. This is not the first time you've been to a theater, correct?
Correct.
Okay, and there's a reason why the theater turns down the lights, correct?
Yes.
It's for the experience, right?
Sure.
Okay, so one of the reasons why in previews they're loud for the experience, right?
Well, that and for commercials, they're trying to get your attention. even
Forget about the
further.
commercial. I'm talking about the previews,
Right.
the previews of the movies.
Right.
They're loud because they want to get your attention to go see RoboCop and Terminator and those types of things, correct?
Okay, yes.
And you remember that on that particular day, that's exactly what the previews were. RoboCop, Terminator, they were action-packed, shoot 'em up type of previews.
Right.
And they were loud.
Yes.
Now, when you first sit down, your wife is to your left.
Correct.
She's seated, you're seated. And the first thing that you notice is that you notice that there's a man standing up, correct?
Yes.
And Mr. Reeves is not in his seat, correct?
Correct.
And you notice this man standing up with a phone in his hand, correct?
Yes, sir.
And he's kind of seated, where Mr. Reeves would be seated, but one row below. He's standing up,
Yes.
right? And not only is he standing up, but this tall man, right?
He was tall.
It was a guy that you later came to know as Mr. Olson. That's your recollection, right?
Yes, sir.
And he was actually facing you.
Yes.
So he would have been facing you, right? You were right. So you got a good look at his face, your recollection is.
Yes, sir.
Okay. And he was just standing up in the middle of the theater while the previews were going. You found that a little bit odd.
Yes, sir.
Because you certainly wouldn't have been standing up in the middle of the theater with people behind you while the previews were going, right?
I would not have.
Well, did you see who was behind Mr. Olson as he was just standing up in the middle of the theater?
You asked me, did I see?
Yeah, did you see who was behind Mr. Olson?
In my row?
Yes.
Yes. At that time, no one.
No one. So those seats were all empty.
No. I thought you behind him, that seat was empty. The rest in the row, of course, was occupied, if that's what you're.
So the one seat right behind him was empty, but what about the seat, if I'm in that back row, right? And he is here, in the lower row. Was there an empty seat here? You know where Mr. Reeves was sitting, right?
No.
Was there someone sitting here?
Yes,
Boom.
his wife.
So he would have been standing up in front of his wife when you first came in. Mr. Olson facing you with a phone in his hand.
Yes, sir.
And that's what you saw and that's what you recollect.
Yes, sir.
And Mr. Reeves was nowhere near there yet.
No, sir.
And so you're seated and you're seeing Mr. Olson standing up, presumably in front of Mr. Reeves' wife.
Yes, sir.
And he's just standing there playing with his phone.
I don't know what he was doing with his phone, but he had his phone in his hand.
And he's facing in your direction.
Yes, sir.
And according to your recollection, he is there for quite some time
Yes, sir.
while the previews are playing.
Yes, sir.
And then after some time passes, your recollection is that you see Mr. Reeves walking up the stairs. Correct?
Correct.
And they're the stairs that actually lead right to your seat,
That's correct.
right at the far right.
Yes, sir.
Is that correct?
Yes, sir.
You also had noticed by that point in time that you thought that there was about 70 to 75 people in the theater, correct?
That was a guesstimate. Yes.
And you noticed that Mr. Olson had this phone that was dark in color, black.
Yes, sir.
And so as Mr. Reeves comes up to you, you're seeing him, right? Pretty close to you, he's walking up.
Yes, sir.
You see Mr. Reeves and you see him walking, and he's wearing, according to your recollection, a loose London Fog waist-high jacket, light colored tan.
I think I said a light waist jacket, similar to what a London Fog would be, or an old members only jacket or something of that nature, but it was
Long sleeves, jacket, kind of a tan area, right?
light colored, I
Yeah,
think I said.
and so you saw, well, I think you said tan, right?
I think I said light colored or tan.
Or tan, okay. And so that's what you see Mr. Reeves actually walking up the stairs wearing.
Well, to be more clear, I saw him as he approached my aisle.
Mhm.
So it wasn't as if I was looking at him as he was walking up. He was pretty much in my face.
So
at
even
that
better,
point.
you
Well,
even got a better view of the London Fog type jacket.
well, I wouldn't say that. I would say because he was so close, I was staring basically at his midsection. So I wasn't, it wasn't as if I was seeing him in full stature.
Well, you saw the long sleeves, right?
I saw the waist jacket or the waist.
So you mean to tell me he was right in front of you and you didn't see anything but his waist?
I saw a cross section of his midsection as he was coming up.
Well, didn't you see him as he was walking up?
Once he approached me,
Okay. And what he told you at that point in time, as he approached you, is he said, "Sir, excuse me, I'm going to try to get
well, he said, "Excuse me."
polite," right?
Yeah, politely.
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 Okay. It certainly didn't appear to you to be grumpy.
No.
And as he's scooting by, you're able to see more of his person, right?
No, not really.
Oh, really? So he's walking down the aisle, and you're not able to see his person. You're not able to see his back. You're not able to see his sleeves. You're not able to see any of that.
No, what I'm telling you is when he approached, said, "Excuse me," I turned away from him, facing away. He walked by me.
Yeah, let's stop there for a second. I thought you just told the jury during direct examination that you turned in the direction of his seat. to
That's
let
what
him by.
that's what I just said.
Okay, and so then
Okay,
he's passing by.
I turned
Now, this is the pedantic nonsense I was telling you about.
Walk past. and
This
walk
isn't
up
scoring
to the
points.
seat,
So if you're
Passing on
turning,
my right,
so if you're turned in that direction, you're seeing him as he goes to his seat, right?
yes.
And you're able to see his full body, right?
At that point, I could see most of it, yes.
And you saw that London fog type jacket with long sleeves.
Actually, I don't recall that I ever said he had long sleeves, but I did say it was a waist type of jacket or, yeah, I think I said a waist type.
Okay. Now, you see him actually walk to his seat, grab the bag of popcorn from his wife and sit down.
Yes.
And certainly you wouldn't think that someone that's going to his seat to grab a bag of popcorn is ready to get into a fight with anybody, right?
Speculation, or just speculation.
Sustained.
And while all this is happening, you're saying that Mr. Olson is still standing up. He's still standing up right there in the theater. Nobody else is standing up, right?
Correct.
He's the only one in the theater, according to your recollection, that's standing up.
Correct.
Objection, ask for the answer.
Sustained.
And as Mr. Reeves is getting close to his seat, that's when you first hear Mr. Olson speak, correct?
He had already sat down. And there was a communication between them. And that's when I heard Mr. Olson say, well, what he said.
You remember having a hearing here, Mr. Turner, and it was back in 2017. And you remember the following question and answer. It's on page 2494, lines 1 through 6. Remember the following question. Is it at this moment, somewhere around this moment, after Mr. Reeves had gotten close to his seat, that you first hear a voice, correct? You said yes. A voice, one voice? You said Mr. Olson's voice. Question, and the previews were on? Yes. And the previews were loud? Yes. So before that Mr. Reeves got to his seat and sat down, as he got close, you heard Mr. Olson speak, correct?
I don't know that it was before he sat down.
Well, you would agree that your recollection would be much better in 2017 than it is in 2022, correct?
Well, perhaps, but I guess I would ask the question is.
Well, we can't have witnesses can't ask questions. I'm sorry, Mr. Turner, but
Unfortunately.
you can certainly give me many answers, okay? And I'll try to follow up with you with some of those, okay? So you would agree, would you not? Okay, that your recollection would be better in 2017 than it is in 22, especially since you were under oath in 2017.
I appreciate that, but I'm not sure how.
You took it seriously in 2017.
As
did you not?
I do now.
Okay, and so would your recollection be better in 2017 than 2022 or not?
Well, it most likely would.
Okay, that's all I wanted to know. Now, you're still looking around, right? You're still seeing, you have your focus on Mr. Olson, who's still standing up, correct?
Correct.
And this is when Mr. Olson starts to exchange his loud voices towards Mr. Reeves, correct?
I'm sorry, say that again.
That's when he starts yelling at Mr. Reeves, Mr. Olson.
I didn't hear him yelling at Mr. Reeves.
Well, let me ask you a question. Back in 2014, January, and I don't mean this with any disrespect, were you hard of hearing back then?
No, I wasn't hard of hearing.
Okay, the previews were loud, correct?
They were the same level as they were in 2015 or 2017.
Yeah, they don't change.
Right.
The loudness it was there, right?
Yes.
Okay, and it was an action-packed type of preview, as
Yes.
we've talked before.
Your Honor, ask the answer.
Sustained.
Now, you say, because Mr. Olson was looking at you, right? and you say that now Mr. Olson squares up. Now he's looking straight at Mr. Reeves, right?
He turns to his right. Yes,
He turns towards Mr. Reeves.
that's correct.
He squares off to Mr. Reeves's chair.
Okay,
That's your recollection, correct?
yes,
And you would agree at that point in time, Mr. Olson was pissed.
yes, he was agitated, he was pissed, he was
Well, let's-
frustrated.
Let's
I mean,
focus on,
well,
first of all, the word of pissed. That's what the word you used, right?
Yes, I've used all of those words.
However, your definition of pissed is not anger. That's what you're telling the ladies and gentlemen of the jury here, that if someone is pissed, they're not angry. Is that your understanding?
It can be, it can be frustration, it can be irritation, it can be a lot of things, but
And it can be anger, right?
well, your body language is trying to suggest something, what I would perceive to be way beyond.
Well, we're gonna
Yes.
get to body language because that's coming up next.
Okay.
Okay, but it could be anger, right?
Yes.
Is that hard to say?
Objection, Your Honor.
You know, if this is going to be about you and I, then it's, you know, I'm not sure how that's helpful.
Well, let me ask you, after you're seeing Mr. Olson pissed, you decide, I'm gonna get up. You're gonna stand up, right? You decide to get up out of your seat, correct? You felt the need at that point in time to get out of your seat. Am I right?
Yes, I got out of my seat.
And you stay standing, right?
Yes.
And as Mr. Olson is making his statement while pissed, he's moving closer to Mr. Reeves. Correct?
Him back talking like that is making this.
Closer to Mr.
They need to
Reeves.
stop questioning him.
Is that correct?
He turned toward Mr. Reeves. That's correct.
Is he getting closer to Mr. Reeves?
This is not good. Not very good at all, guys. Hi, Peter. Welcome. If you're liking the stream, please subscribe. But yeah, guys, this is not good. The way he's fighting back is looking bad. He needs to
5
soften his tone.
through 11. Question. Same hearing, 2017. Remember being placed under oath? Do you remember being placed under oath?
Yes.
Okay. Question. You realize that after Mr. Olson is making that statement, he's moving closer to Mr. Reeves, correct? Answer, yes. So now not only is his voice elevated, he is now moving closer to Mr. Reeves. Your answer. Yeah, he's leaning towards Mr. Reeves, perhaps a 10 to 15 degree angle.
That's correct.
Question, you don't know whether his seat, meaning Mr. Olson's seat, bottom, is up or down. You said, I don't. So you would agree here today, he's getting closer. And there's an angle now in the getting closer, meaning that Mr. Olson's body is now moving in an angle towards Mr. Reeves.
Yes.
In other words, leaning towards Mr. Reeves.
The difference between what I'm saying and the way you're couching it is I've taken it in segments. He made the turn. Once he made the turn, he leaned forward. I had expected that you were going to come back with that part and ask, and I would say, yes, he
Well, you
leaned
just
forward.
got it out for us. He leaned forward, right?
Right. That's
Okay. And you're thinking that Mr. Reeves is going to get punched.
no, sir.
24.99. that same hearing in 2017?
I remember the entire exchange.
Remember the following questions and answer. Question. So in your mind, for the first time, you're thinking Mr. Reeves could get punched. Answer. Yeah, I'm thinking that did cross my mind.
Well,
let me ask you a question.
Your Honor, I had asked the
well,
witness to be permitted to finish his answer.
he is. I'm going to let him, but I got to make sure that that's what he said. That's what you said, right?
I don't believe that that's all that I said.
Oh, no,
I think
we're
there's
going to.
context there.
Okay, well, would you like to read the other couple of sentences after?
Well, Your Honor, I think instead of doing that, maybe the witness can explain what his answer is.
What is your answer, sir?
Ask me the question again, please.
Okay, that you thought at that moment that Mr. Reeves could possibly get punched.
I think I testified that I was paying closer attention because I thought that this could develop into something further. Initially, I didn't.
So you never said what I
Let him
just.
finish his answer, please.
Initially, I didn't know if the exchange between them was because they knew each other. I didn't know if they were together. I didn't know. It was only at the point where it appeared to get more heightened that I thought something could happen here. I never expected what happened to have been actually what happened, but I certainly paid attention because there was obvious tension between the two.
Well, you hadn't heard Mr. Reeves say a peep. Up until that point, you had not heard Mr. Reeves say a peep. Isn't that correct?
That's correct.
So how could Mr. Reeves be guilty of anything if he hasn't said a peep?
I wasn't judging either person.
The only one that you heard was Mr. Olson, correct?
That's correct.
And the only one that was leaning towards Mr. Reeves was Mr. Olson.
Yes.
And Mr. Reeves was there quietly, not saying a peep.
Well, I didn't say that either. I said I didn't hear him say anything.
Okay.
So he could have said a lot, but I didn't hear it.
You didn't hear it. But you certainly heard Mr. Olson. That was not a problem.
I heard Mr. Olson.
But you do see Mr. Reeves doing something important here, right? You saw Mr. Reeves trying to create some distance from Mr. Olson as he was leaning sideways. That you saw.
I don't recall that.
2,500, 7 through 13.
Is it 2,500, 7 through 13?
Yeah, it's going to the next page.
I don't see that. We look at the same thing.
Yeah. Let me phrase it this way. At that moment, you're seeing now Mr. Olson's hands reaching towards Mr. Reeves, correct?
Yes.
Okay, and so tell me how Mr. Reeves's body is positioned as Mr. Olson is reaching now into Mr. Reeves's face. You would agree with that?
Yes, sir.
Okay, so tell me how Mr. Reeves was positioned, his body.
He was sitting back in his chair.
Okay, meaning, those chairs have some mobility, right? Not much in that back
Not
row
much
because
in
you
the-
have a wall, right?
Correct.
But it has a tiny bit, right?
Right.
So you can pull back a tiny bit,
Right.
correct? And that's what you saw.
Well, I don't know that I saw that. It's possible, but I don't know that I saw it because the chairs go back a couple of inches. I don't know that I could determine.
But clearly at that point in time, Mr. Olson, as he's reaching over, is into Mr. Reeves's space,
Yes, sir.
correct?
That's correct.
And the theater's still dark, correct?
The theater was dimmed and dark. It
And
was-
the previews are still playing loud.
Yes,
And as you see those arms of Mr. Olson's coming towards Mr. Reeves, that's when you hear the gun go off, right?
no, sir.
You didn't,
His arm came across and grabbed the popcorn.
right?
He pulls the popcorn back and then flicks it.
Okay.
That's,
So other than that movement, going with his arm towards Mr. Reeves
yes,
and then grabbing the popcorn, you're telling this jury you didn't see Mr. Olson previous to that, maybe 8-10 seconds beforehand, trying to go over the seat, the back of the seat. You didn't see him leaning over the back of the seat then. I'm talking about 8 to 10 seconds before. You didn't see that.
I didn't see that. The leaning over of Mr. Olson was everything to do with him leaning forward to grab the popcorn.
So the gun goes off. Is that correct?
Yes, sir.
Okay. You're still standing.
Yes, sir.
And by this time, Mr. Olson, according to your recollection, must have been standing for quite some time. Because he never sat down, right? He was up there standing up,
Correct.
right before Mr. Reeves came, while Mr. Reeves was going down the aisle, the whole bit.
Objection, this has been asked and answered several times.
Sustained.
You indicated to the members of the jury that you saw Mrs. Olson's hand on her husband's chest, correct?
Yes, sir.
And you believe that Mr. Olson's hands were down at his side when he was shot? Yes or no?
No.
Guys, I think this witness had the jury on his side at first, but then when he tried to get cute with not wanting to admit the attorney was right on something, that's going to make him look bad. Oh, the feed switch. I'm going to tell Law and Order to crime to fuck themselves.
So tell me exactly where you believe Mr. Olson's hands were at the time that Mrs. Olson had her hand on his chest.
What I recall was when he threw the popcorn, his hands came back to here.
Sorry, guys, we're fixing this.
So his hands fall after.
That's correct.
You didn't see anything in his hands, right?
No, not at that point.
In either hand, because you had a view of both hands.
Well, initially he had a cell phone in his left hand.
That was when he was standing up,
Right.
right?
That's correct.
Okay. And so,
Thank you very much,
so now
Andrea.
his hands are down to his sides, right?
They fell to his side.
Okay. And I think you've already testified that at that point in time, Mr. Olson made that statement and then collapsed, correct?
Yes, sir.
Okay. Now, I think you also testified that you had some contact with Mrs. Olson. Is that correct?
Yes, sir.
In assisting her on various aspects, correct?
Yes, sir.
Okay. Now, you then decide to go, I believe you testified on direct that you went into the theater, to a section of the theater where there were people milling around. And you think maybe as many as 40, 50, 60 people in that area of the theater.
Yes.
And you went to that area, and in that particular area, people were talking about what happened.
People were talking. Yes, I can't say specifically. Some probably were, but I don't recall. If you asked me what they were saying, I couldn't tell you.
You can't tell me today in 2022.
I probably couldn't have told you in 2015 or 17.
Well, while you were there with those 50, 60 people, did you have any police officer that you remember coming up to you all as a group and saying, do not talk to anybody about what you saw?
I do not recall that.
Do you recall any police officer coming forward and saying, hey, all of these 60, we're going to separate and we're going to put you in a row and you're going to have 4 empty seats in between all of you and don't talk.
No, sir.
And so you were there for quite a long time, right?
Yes, sir.
And you were concerned because things seemed very disorganized in that theater as far as law enforcement was concerned.
That was a personal opinion, yes.
In fact, they hadn't even given you the voluntary statement forms. You had to go find some officer to go hunt something down so that you could write and the others could write a statement, right?
Well, there was this officer there that apparently had brought some forms in, but he didn't pass them out, and people were having to go to him to ask for the forms so they could write them up.
Okay. And so you do that.
I do that.
And then you go to a concession area, which is outside of Theater 10, correct?
Yes.
And there's a bunch of people there at that concession area, right? And tables and what have you. And those people were talking about amongst themselves, correct?
There was talk. Again, I couldn't tell you what the subject of the.
Well, they were
conversation
talking about what had occurred, correct?
I couldn't say that.
At least that was your assumption.
I'd object.
I'm not sure.
Assumption. You shouldn't be talking about assumptions.
Now, how many people would you say were there in that concession area?
Honestly, I don't recall.
Quite a few.
Quite a few.
Okay, and you were in that group.
That's true.
And so you were there for some time, right?
We weren't there, I'm going to say 5 or 10 minutes.
Okay, and then you're taken to another room, is that correct?
That's correct.
And in that particular room, again, people are talking about what just happened.
Again, I couldn't say that definitively.
But you think so?
No, I think it's possible. I don't know what I don't know.
And you were in there for quite a long time.
Yes.
With how many people would you say?
I don't know, 30, 40 maybe. I don't recall.
And it wasn't a real big room.
Right.
And there was no police officer that went into that room to tell you all, do not speak about this case amongst each other.
Not that I recall.
And there was no police officer that moved you into different corners of the room.
That's a big
so that
deal.
you all would not have access to.
Like I said, it's a big deal.
Not that I recall.
I may have 1 second, Joe.
Gabby, he's not using him to ask him whether or not he knows. He's using him as a vehicle to show the police to not keep these witnesses separate. So he's just a vehicle to get to the destination.
You believed that day, while Mr. Reeves was seated in his seat and Mr. Olson was yelling and moving in his direction, you believed that Mr. Reeves was in the most vulnerable position, correct?
Well, just to be clear, I didn't hear any yelling, but I recall this question from previously when you asked me, and it led to him being in a vulnerable position because he was seated.
Yeah.
Yes, if you're having someone over you, then yes, that's a vulnerable position.
I don't have any further questions.
Can you redirect?
Yes, sir. Thank you.
Gabby, I'm talking about when all the witnesses were together in that room and they
On
weren't
several
separated.
different occasions,
Their stories can mold and
the
meld
defense kept going back to
properly.
a single word description, and the single word description was dark, and the single word description was loud. So instead of focusing on the single word, every time that you were referred to dark, dim, dimmer, darkest, whatever the adjective was the lighting condition sufficient enough for you to see in that theater?
Yes.
When we hear loud, okay, was it so loud that everything was deafening inside of this theater?
No.
And just for the sake of argument, we're hearing about different movies playing. So is there a break between different previews where it's not loud at all, actually?
Yes.
And you are asked to assume, and we probably both agree it's not a good idea to assume in court. Would that be a fair statement?
I would hope so.
Okay. And so you don't know for a fact that people were in fact discussing anything about what they may or may not have seen inside the theater.
I do not.
And you were asked about how many people were in the area. Did you hear people generally just talking?
I heard some talking, yes.
Okay, but you can't say specifically what they were talking about.
Just chatter.
I'm gonna object this.
Could you hear what they were specifically talking about?
No.
Did you see or hear anyone get together and compare notes about what they observed in the theater?
No, sir.
Did you see or hear any people getting together to conspire to make up a story against the defendant here?
No, sir.
May I have a moment, Your Honor?
You may.
Nothing else. Thank you.
Just two questions.
All right, we're not going to do that every time. State calls them, they get the last word.
So since you could see so well in there, the one thing that you can tell this jury that you're 100% certain of is that Mr. Olson was standing the entire time.
Your Honor, I object. We probably done this 5 or 6
It's
times.
sustained.
In fact, I stipulate that it was true based on the 5 or 6 times you said it.
No further questions.
May this witness be released?
We'll keep him on standby. Your Honor.
All right, Mr. Turner, you're free to go, but if you get a phone call asking you to come back, you'll have to come back, okay?
Thank you, ma'am.
Thank you. Who's next?
You're on a statement called Derek Friedhoff.
Do you solemnly swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
I did. Okay, thank you.
Go ahead, Mr. Rosenwasser.
All right, good afternoon.
Hi, good afternoon.
Can you please state your name and spell your first and last name for the court reporter?
Yes, my name is Derek Friedhoff. My first name is Derek, and last name is Friedhoff, Friedhoff.
All right, and can you turn to the members of the jury and tell them what you do for a living?
Hi, I'm a registered nurse. I work with Advent Health.
And back on January 13th of 2014, were you a registered nurse?
I'm lieutenant as
I
well.
was.
And were you working at the same location or different location?
At that time, it was a different location.
All right. On that particular date, did you go to see the movie Lone Survivor at the Cop Theater?
I did.
And do you recall just approximately what time it was that was starting?
I believe it started approximately around 1:20.
Okay. And who did you go to the theater with?
My girlfriend at the time.
All right. When you arrived at the theater, did you purchase tickets?
Say that again?
Did you purchase tickets?
Yes, we did.
Do you remember if you went to the concession area or not?
We did not go to the concession. We went straight to the movie theater.
All right. Do you recall where it was that you sat in the movie theater?
Yes.
At the time that you were sitting down, do you recall what the lighting conditions were like?
It was dim, but you can still see where you were walking or where you were going.
Did you have any concern when you walked into the theater that you could not see where your seat would be?
No concern.
Did you have any concern that you would trip and stumble and fall on people because it was too dark?
Nothing of that sort.
When you walked into the theater, could you see the rows clearly?
Yes.
Could you see people in the seats?
Yes.
Could you see the aisles?
Yes.
Was it dark like it is when the movie starts playing?
No.
right. Did there come a point in time when you became aware that there was a shooting in the theater?
Yes,
And did you later learn the name of the person that did the shooting?
I did.
And what was that person's name?
The name of the shooter was Curtis Reeves.
All right. Did you learn the name of the person that was shot?
Yes,
And what was the name of that person?
Chad Olson.
All right. Did you know either of them?
I did not.
All right. So we'll just refer to them by name. So when we talk about it in the positioning of the theater, it'd be easier. Let me ask you this. Do you remember what row it was that the defendant Curtis Reeves was sitting in?
Yes, I believe he was sitting in the farthest row, the very far back one.
Okay, so the last row.
Yes,
Where was Mr. Olson sitting in relation to where the defendant was sitting?
he was sitting in the row in front of him.
Okay, where were you seated with respect to Mr. Olson?
In respect to Mr. Olson, I was one row ahead to the left. So if I'm Mr. Olson sitting in this chair, I'd be one row ahead towards the left.
Okay, and then said another way, I know it's going to sound silly, is that if you looked over your back right shoulder, you would be seeing the Olsons.
That's correct.
All right, was Chad Olson with somebody?
He was.
Okay, do you know who that person was?
Yes.
Who was that?
Nicole Olson.
And you learned about her later on, meaning you learned her name later on?
That's correct.
You didn't know her prior to
I
that.
had no idea until afterwards.
With respect to the time that you sat down, do you remember if the Olsons were there first?
I didn't notice them or anyone till later on.
All right. Did there come a point in time when your attention was focused somewhere in the theater?
Yes.
All right. So let's talk about the lighting at that time. Is the lighting the same as what you were describing before?
Yes.
All right. And what about the volume in the theater at that time?
It varied. It depended on what was either on the previews or if there was no previews at the time. Like if it was in transition, there was nothing come out of speakers. So it varied depending on what was on the screen.
Okay. Did you have any difficulty hearing the person you were with?
The person I was with, no.
Could you hear other chatter within the theater even though the previews were playing?
Yes.
Could you specifically hear what other people were saying?
Unless I focused on it, not really.
All right. So the reason you couldn't hear it was because you weren't paying attention to them because you really had no reason.
Right.
Sustained.
What was the reason? What was the reason that you couldn't specifically hear what people were saying?
I wasn't interested.
All right. What first brought your attention to someplace in the theater?
I heard some bickering coming from behind me on my right side.
Okay. And would that be the area where the Olsons were?
Yes.
Okay. And would that be the same general area where the defendant was?
Yes.
Right. When you say bickering, how many voices did you hear?
I heard two.
Once you heard that bickering, what did you do next?
I just kept my focus on that area because it just seemed out of the norm. And then until it went away, I went back looking at the screen.
Okay. So when you looked over, tell the jury what it is that you saw.
So when I initially looked over, I saw, is it okay if I visually show?
Sure.
I saw Chad Olson. His body was facing the screen, or he had a cell phone out. I saw the screen illuminated, and it looked like he was talking to someone behind him.
Okay. So the way your position was his body at that time, other than his head, facing the screen?
Right.
Could you hear what was being said?
I could hear them talking, but I couldn't hear exactly what was being said.
After you heard the talking, what's the next thing that you remember seeing?
So the next thing I saw was someone leaving from the top row, going down the staircase towards somewhere. And then once I saw that, the bickering stopped, and then I just started watching the previews again.
Okay. So once you saw someone leave.
Oh, we haven't even gotten that far yet. Not even to the
Did you see
shooting.
that person come back?
Still in the
I did not.
foreplay.
Did something bring your attention to that area again?
Yes.
And what was that?
It was the bickering resumed. It
All right.
continued again.
And did it sound like the same voices from before?
Yes.
Did it sound like the voice of one person or two people?
Two people.
Could you tell if they were male or female?
I could tell they were male.
Both of them?
Yes.
And prior to that, when one person had left, it was quiet.
That's correct.
When you heard this bickering again, what did you do?
So it caught my attention. So I continued to look over in that area again where the bickering was coming from.
Okay, and what'd you see?
So at that point, I saw the outline of a person stand up and then say something along the lines of texting my daughter. There were some other words I really couldn't understand what was said, but it was like an annoyed voice, like texting my daughter.
Okay, and who was that person?
That was Chad Olson.
And were you looking over in that area then at that time?
I was.
And then what'd you see happen next?
So almost immediately after that, I heard something. It's like something being crumpled, and then I saw like movement of something being like something. Can I act that I was okay?
Sure.
I saw someone stand up, say something, text my daughter, and then like they reached to grab something and then thrown.
Okay.
So it was something being crumpled. I didn't know what it was at the time.
Okay, and then what happened right after that?
Immediately after that, I heard someone say something along the lines like it's like it was mumbled, like they were mumbling. It said something like "show you," followed by like throw popcorn at my face. It was like more like declaratory, like out of anger.
Okay, and was it the same voice that mumbled and said throw popcorn?
Yes,
All right, so it was the mumbled part was from the same person that said throw popcorn in my face.
that's correct.
At any time prior to the movement that you indicated, and you heard the crumbling,
Correct.
did you hear anything that sounded like a life or death struggle happening?
I did not.
Did you hear anything that would lead you to believe that the defendant here was being violently attacked?
I did not.
Did you hear anything from anyone yelling words? And it's going to sound silly, like, ow, oh my God, this is terrible. Anything that would give you the impression that something is going on.
I did not hear anything of that sort.
Did you hear anything physical, like if someone were to try to jump over a seat in a theater and the seats would pop up? Did you hear anything like that going on?
Nothing of that sort.
Did you ever get the impression prior to the the crumpled sound that you heard that there was a struggle happening?
Other than that, no.
Did you ever see Mr. Olson throwing an object, a cell phone, anything at all prior?
Nothing. I only saw that one movement of something being thrown, the initial.
Okay. And that was the crumpling?
The crumpling, yes, sir.
Did you hear the sound of the gunshot?
I did.
All right. And what did you see after that?
So once I saw the actual gunshot, I saw the muzzle flash and I heard the gunshot. My initial was focused on that area. And then I looked away to see like where the exits were in case there was a continuous shooting. So I looked away, see where the exits were at, looked over, and then I saw someone collapse.
Okay. What did you do when you saw that?
I waited a couple more seconds because I wasn't for sure if someone was going to continue firing. And then once I felt like it was safe to go, I went to go assess whoever was shot.
Okay. And then who did it end up being that you were assessing?
Chad Olson.
So tell the members of the jury what it is that you saw when you walked over there.
So my initial reaction was, of course, I want to make sure it was safe before I went over to check on Chad. So once I saw that there was no more shooting and that there was no more any type of violence occurring, I went to Chad's side. It was still a little bit dim. I saw blood coming from his shirt, and then at that point, I called 911.
Did you lift up his shirt or look at him?
I did, yes. So I initially looked for an exit wound. I didn't see one. I just saw the initial entry wound. And then once I saw blood starting to pool, I lifted the shirt up, took my shirt off to apply pressure.
Okay. Did you do anything else to try to help Mr. Olson at that time?
At that point, I was on the phone with 911, speaking with the operator, and I was trying to assess Chad's condition while at the same time speak with the 911 operator.
Okay. And what were you seeing from Chad?
So at that particular moment, Chad was still breathing. He had some like involuntary movement, and it sounded like he was trying to breathe. And at that point, I was just trying to keep an eye on him, make sure he, wouldn't go into either shock or get worse. So we're just holding pressure while I'm on phone with 911. And as the 911 call progressed, I noticed that Chad's pulse started to decline, and I could no longer feel a palpable pulse on his wrist. So where I was at, I wasn't in a spot where I could do CPR properly. So there was someone at, I believe, at his feet, and I asked if anyone could do chest compressions while I was on the phone with 911.
So there are other people that were helping you?
There are other people that were helping me, yes.
Was there a point in time when deputies from the Pasco County Sheriff's Office arrived at the scene?
Yeah, about 15 or so minutes later.
Okay. And were you still in the theater when they came in?
Yes.
Was there a point in time when you were given a piece of paper that some people call a written statement to fill out?
Yes.
Did they give you any instructions about how to fill that out?
They just said just fill it out. There was no clear, concise way to fill it out. They just said just fill out what you saw, and that was pretty much it.
And did you assume that at some point you talked to a detective or a
Yes.
deputy? Did you in fact talk to a detective or a deputy?
I did, yes.
When you were in the theater, did you talk to anyone other than law enforcement about what you observed?
No, I did not.
Did you get together with anyone to conspire to make up a story?
No, I did not.
Are you testifying to what you personally observed
Yes.
and what you personally heard?
Yes.
Did you ever hear anyone yelling, no, 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 or whoa, whoa, whoa?
Nothing of that sort, no.
May I have a moment, Your Honor? When you were in the theater, was the only thing that you heard Mr. Olson say was something about texting his daughter?
That's correct. That's the only audible thing that I heard.
Okay.
Like I said, he was talking prior, but I could not understand what was said.
Okay. So you didn't hear any loud threats towards anybody else?
I did not.
I don't have any further questions.
Go ahead, Mr. Michaels.
Jeff Bezos now gets ready to cross-examine the witness.
All right, at the time.
Nice pocket
January
square, though.
2014, January 13th, you were a registered nurse
That's correct.
and you worked in trauma at the time, right?
That particular time, no, I was doing neurology and orthopedics.
You worked trauma previously.
Previously, yes, that's correct.
And you're pretty exact because you actually purchased your ticket at 1:16 p.m. that day, right?
That's correct.
And you actually entered the theater, you remember, at 1:19 p.m., right?
Yes, because I looked at my cell phone prior to getting to the movie theater.
And so what happens is when you get in there, you describe where you sat, and your then girlfriend, Jenny Monero, was sitting next to you,
That's correct.
and she was to your right.
I believe she was to my right.
And so when you're looking back at where Mr. Olson and Mr. Reeves are, and Mrs. Reeves and Mrs. Olson, you have to lean back in your seat, right?
Yes, the seat reclines a little bit at the movie theater, so I was able to look past behind her head and see what was going on behind me.
All right. So you answered my question. I was going to ask if you have to look behind your girlfriend's head to look back up, right?
That's correct.
Now, what you heard that was audible to you was loud enough to be concerning to you, correct?
It caught my attention.
And it was concerning to you.
It seemed out of the norm, so it caught my attention.
So are you telling me that I'm mischaracterizing what you thought? You don't think it was concerning at the time?
It caught my attention. Like it just sounded like two people like bickering and arguing. Like it just seemed like out of place.
I'm asking you a direct question.
Objection, asked and answered.
Okay, page 2477, line 23. I'm sorry, 2427. Lines 20. Looks like line 23. Okay. This was a hearing back in 2017 that you were present for and testified in. Remember that?
I recall being here at some point in the past. I don't
Okay,
remember
the same
exact date.
courtroom,
Okay.
right?
I don't know if it's the same courtroom. I really don't know which, if it was A, B, C, or D.
You remember testifying?
I remember
regarding this
testifying
case?
at some point in the past.
Okay. You remember it 2017?
I remember the year. I don't remember what date I was here.
Okay, that's fine. So you remember in 2017.
Okay.
There's a court hearing like this where you face the clerk and raise your hand and tell the truth. You remember that?
I'm probably sure I had to.
Okay, well, you remembered that you walked into the movie theater at 1:16 that day. Well,
I didn't walk in the movie theater at 1:16.
I'll overrule.
you bought your ticket at 1:16.
I bought the ticket at 1:16.
And so that's even more accurate. So is there a reason why you remember when you bought your ticket, but you don't remember whether you faced the clerk and swore to tell the truth in 2017 in this courtroom?
Because I still had the movie stub, the movie ticket stub.
How do you remember that you walked to the theater at 1:19? Does
Because
that somehow indicate on the movie stub?
I looked at my phone prior to going to the movie theater. I wanted to make sure that we didn't miss the previews.
Did you look at your calendar before the hearing in 2017 and know what date it was?
No,
And so you're saying that you don't remember whether you took an oath to tell the truth or not that day?
I said I recall. I just don't remember what the date of taking the oath was.
So now, because I asked you before, so let me just ask you the question again. Do you remember facing the clerk, raising your hand and swearing to tell the truth?
Yes.
Okay. The context is, I'll start at line 1. Question, when you first heard the bickering, could you hear what was being said? Answer, line 3, most of it was inaudible, but at one point,
Your Honor, I reject. I'm going beyond what the question was. I think your question was 20 to 23 or 20 to 25.
I'll be happy to go to that section. If I'm asked to put it in context, then I'll do that, Your Honor. It's not a problem. Page 2427, line 20, question, and that's at the hearing. And you indicated that you were kind of leaning back in your chair and looking to your right. Answer, that's correct. It was loud enough to raise to be concerning to me. Right, so you were concerned.
Concern. I would agree.
And that's when you saw the light of the cell phone.
Correct.
that right?
Yes,
And you showed the prosecutor, you kind of gave an example where you were holding, you showed in your right hand a cell phone.
that's correct.
So do you know whether it was in Mr. Olson's right hand or you just,
So when I saw the cell phone,
Right.
it was kind of like just hovering. So I just saw like just a cell phone illumination, and I just saw Chad talking to someone behind him.
the question is, you held up your right hand because you wanted to do a physical demonstration for the court or whomever. You held up your right hand. So is your testimony it was in his right hand or do you not know for
I
certain?
believe it was in his right hand because I saw the cell phone screen. So it'd be kind of hard if it was in his left hand for me to see that illumination.
Okay. Did you see it in his hand physically?
I saw his cell phone. It's not going to float magically, so someone would have to be holding it.
Okay. So did you see my
I
question
saw
is
the cell
again,
phone.
Mr. Friedhoff, listen, we need to be able to allow me, number one, to finish asking my question
Okay.
before you answer. This lady here takes down every word on that machine. She cannot take it down if we're both talking, okay?
Okay.
Thank you. And so my question is, did you physically see it in his hand?
Yes.
Okay. And did you physically see it in his right hand?
Yes.
Okay. And that's your sworn testimony.
That's my sworn testimony.
Now, during the second preview is when you heard that second part of the bickering with the texting my daughter sort of thing, right?
That's correct.
The second preview was, I think, sabotage. Do you recall that?
That's correct.
All right. And that's when you described this whole, you heard the crumpling of something, right?
At some point, I heard the crumpling, yes, but it may not have been during that exact preview. I just
Okay.
remember the second bickering occurred during the second preview. It didn't last the entire, or it wasn't like from the start to the beginning of the second preview. It occurred during the second preview.
Okay. My question was to you, did that occur during the second preview?
I want to say it was towards the end of it.
The question, listen closely to the question. I'm not asking you when or in what part of the preview. I'm asking you, did that crumpling that you described happen during the preview?
I believe it was after the preview. The bickering occurred during the preview.
The crumpling that you heard, I'm talking about the
The
crumpling,
crumpling itself, okay.
happened during the preview.
It happened after the preview.
After the first preview,
After the second preview.
the second preview is over, right?
Correct.
Then you heard the crumpling.
That's correct.
My apologies.
Now, when you look back in the row, what you see is you can't actually make out Mr. Olson, but you see a silhouette, right?
I see a person standing, but I can't make out what they were wearing.
It appears to be a silhouette to you.
More of a silhouette. That's correct. An outline.
And then what you see is you see somebody going forward with full momentum.
They were reaching for something. It looked like they went to go grab something, and then I saw the motion of something being thrown back.
And when it gets thrown back, you see the person at full momentum.
They were just not. When I say full, I say their arm at full momentum. I don't see their full body at full momentum. I just see something being thrown.
The arm is at full momentum.
Yes, they were throwing something.
Okay, let me ask you the question again.
Well, Your Honor, I object. He answered exactly what he was being asked.
The question is, it's a yes or no question.
Well, I object. If the witness needs to explain, I ask you to have the ability to explain.
Sustained, move on.
Your Honor, the cross-examination, I can call for a yes or no answer. I disagree with the prosecutor.
I would object.
So describe then how you saw the popcorn being thrown.
I saw the person standing, looked like they reached over to grab something. I heard something being crumpled, and then it was this forward motion of something being thrown back at them.
And do you have any other description of how that was done?
As far as they stood up, I heard texting my daughter. And at that point, I saw someone reach over, heard something being crumpled, and then saw movement of something being thrown back at them.
Okay. Page 2451, line 20. Same hearing. Question. Then the third thing that you observed is a movement or a motion of something being thrown. Answer, your answer. Full forward momentum.
Okay.
Well,
That's your answer?
well, here's my objection. I would ask that you read.
Your Honor, if he's gonna do a speaking objection, we're gonna have,
Okay.
I don't know what the legal objection is at this point.
Rule of completeness, read the entire sentence.
You want to come up?
I want to make sure I read your entire answer, okay? So let me ask the question again. I'll read you the question. You're under oath. You're in sworn testimony during a hearing. Question. Then the third thing that you observed is a movement or a motion of something being thrown. Answer. Full forward momentum. I couldn't see what was thrown, but I saw movement of something of like an arm reaching out and then heard something impact, right? So the full forward momentum that you're talking about, right, is when the arm is going back.
I didn't see a pitch.
So what's full forward momentum?
Full forward momentum is you just see something moving forward.
Well, why is it full forward momentum?
Because it was full. It wasn't like it was done. It would look like someone reached over, grabbed, parted back, and then thrown. That's forward, like it had intent to throw something.
Okay. And so full meaning what? Like, let's say it was slow, no momentum, half momentum?
But maybe
full
no momentum would be like that. This was grabbed, brought back, thrown.
All right. So not a flick, in other words.
Not a flick.
All right. Now let's talk about some of the things that happened afterwards. Now, before the shot rings out, you hear throw popcorn at me or something to that effect before the shot.
Something along the lines of sounds like it was mumbled. So mumble it was hard to understand, but it sounded like show you, throw popcorn at me. And the throw popcorn at me was more out of like, it was a raised voice. And it sounded like it was out of like anger,
Okay.
and annoyance.
And then the shot.
I believe the shot came as he was saying that.
Okay. So Mr. Olson throws with full momentum. In this case, we know it's popcorn. We didn't know what it was then. Into Mr. Reeves' face, right?
I didn't know where it landed on Mr. Reeves' face.
Okay. Towards Mr. Reeves. Teach you to throw popcorn at me, then bang, right?
I heard show you, throw popcorn at me, and I believe he shot while he was saying that.
Okay.
So I heard show you, gunshot, then after that, throw popcorn at me.
All right, let me ask you this question. Is it, again, I need to know exact. This is a court of law.
Okay.
Testifying as a witness. You've sworn to tell the truth. It's a truthful answer if you don't know the answer, or if you're not sure of the answer. You're telling me you're sure of the answer, so I want to know what the answer is.
Okay.
Did you hear the statement regarding I'll show you or to throw popcorn at me before the shot or not?
It was at the same time.
So it wasn't before the shot.
It was maybe a second difference. One, it was so close in time as far as when it was said and when the act occurred. It's really hard to recall exactly. It was maybe a half a second or a second within each other.
Okay, I'm concerned because I'm a lawyer, and so I don't want it to seem like I'm picking on you.
Okay.
But my concern is I'm asking you a question and I'm not getting an answer. I want to know.
He gave the best answer he possibly could.
Okay, bond hearing. Page 38, lines lines 16 through 23. I'm sorry, that's 383, lines 16 through 23. That's one of them. Let's start at 383. That's fine. 383, lines 16 through 23. You remember the bond hearing? That was February, about a month after you were at the theater that day. You remember coming to court then, soon after that?
That was at the office upstairs, correct?
No, that was a bond hearing, again in court,
Okay.
right after that,
Uh,
within weeks.
okay. I don't really recall exact the time, but I remember coming in for something along those lines. Yes.
Well, do you remember having a court hearing with a judge and everything?
Is this the same? Is this the same one before as the one you described? Like coming in to do, like to testify? Is that the,
Yes, yes, approach.
I think they're confusing the shit out of this kid. I kind of feel bad for him. Also, do you know you're under oath? You're under oath. Did you know you're under oath? Do you need me to repeat that? Yes, may I come in? I have popcorn and a weapon. Yeah.
Here's another question and answer under oath at any rate, okay? All right. Question. The one statement that you attribute to Mr. Reeves that you indicated it was something like throw popcorn on my face was after the shot or before the shot? Answer, before the shot. Question, so before the shot, you hear him say, throw popcorn in my face and then the shot, that's correct, right? You remember saying that?
I remember saying something along those lines. That's correct.
Those exact words.
If that's what the statement says, that's probably what I said.
All right, let's talk a little bit about what happened in the theater that day. Now, after, first of all, after the shot rings out, you eventually make your way towards where Mr. Olson is.
That's correct.
When you get there, there's already a gentleman that's applying compression to Mr. Olson's chest, right?
It was dim as far as I couldn't exactly see what he was doing, but there was someone at his side.
Okay.
I think he was applying pressure over his shirt, but I don't, because his shirt wasn't up.
Okay, well, you don't remember exactly what was happening, right?
I just remember someone being at his side.
Pardon me?
I just remember someone being at Mr. Olson's side.
Did you see somebody actually putting their hands on Mr. Olson's chest?
I can't recall.
All right. If I show you something, would it help you refresh your recollection?
Sure.
Okay, deposition, page 60, line 25.
It's about to the point where I am with this trial. This is so slow.
May I approach?
You may.
All right. All right, Mr. Friedhoff, if you would, maybe this will help you refresh your recollection. You can sit down, please.
Okay.
Start at line 18 and work your way through the next page, please, okay?
Just
Okay,
read
read the whole page or?
To yourself.
To yourself.
Okay.
Let me know when you're ready.
Okay.
All right?
Yeah.
So now you're able to look at that deposition. You remember now there was somebody else there attending to Mr. Olson, right?
Yes, after reading that, I agree with that.
A gentleman in his 30s.
I think maybe 30s, 40s. He was older than me.
Okay. And at the time you were 20 something?
I was 23 or 24.
All right. And that gentleman, did you know that that was Matthew Reeves, Curtis Reeves' son?
I did not.
At any rate, you took over from him. Is that right?
That's correct. The chest compressions that he was doing, they didn't seem adequate.
All right. And so what happens next after you're finished with that, at some point, police take you to a room and swab you for DNA and kind of process you a little bit and have you clean up, right?
Yes, I believe it was the like activities room near the concession stand.
Okay. And I know you talked to the prosecutor about giving a statement, but what happens in between is that you are actually taken with a group of other people, or at least directed to an area down by the front of the theater where the movie screen is.
Yes, I recall I don't know if it was a detective or a police officer. They told us to wait in an area here and don't talk. I remember they said, don't talk about what you saw, but you can like just hang out in this area.
Okay, and they may have said that, but the truth is that you actually heard people talking to each other about this, about what happened.
I heard someone say out loud said something like they were brave about the people who went in to help. But other than that, I can't recall anything that was said other than that.
Okay, let's talk about that. So when you got there, they were talking to you and your girlfriend, Jenny Monero, at the time, and they were saying, you're brave, you're a hero.
We were away from the group. I remember seeing maybe about 6 people in the group. And then there were other couples that were kind of like to themselves away.
Okay, and so your testimony today is that you don't remember whether other people were talking or exchanging views about what happened.
I can't recall what they were saying.
The question again, we'll get to that second part. The question is, do you recall people as you were in that group waiting for police to interview you? Do you recall people exchanging views of what happened?
No, I do not.
Let me show you your deposition. Maybe that will refresh your recollection. You think that sworn testimony would help you?
Sure, visually would help.
Okay. Page 71, I'm going to direct you to lines 9 through 13.
So 9 through 13?
Yes, sir. 9 through 13. Let me know when you finish reading it.
Okay.
So you will agree with me that people in that group were exchanging views about what had happened, right?
What I heard from the group initially was they said that the nurses were brave about what happened, and that was it. I don't know anything else other than that. I didn't hear what else was said.
Okay. You read your own testimony.
I did.
So now you remember?
I saw what I said, but I don't know what else was said other than that. So
And what?
Other than those
I
nurses
might start
were brave.
drinking early, guys. This is
So
going to be
when
rough
you
tonight.
You say that they were exchanging their views about what happened. You were talking there about nurses being brave, right?
That's correct.
Okay. And nothing else.
I can't recall anything else that was said other than that.
All right. If you can't recall, let me try to refresh your recollection again. Same deposition, page 71. This time go to lines 1 through 5.
I mean, this is starting to seem like a good option right now, but I don't want to get too drunk for tonight. Matthew, the answer to that question is sometimes. Sometimes. It depends. But that does happen,
Okay.
and I'm surprised it hasn't happened in this case, given the time span.
So now you remember that you heard people talking about what they observed, right?
I recall, other than that the paper that you provided for me, the only thing I recall was talking about the nurses being brave.
Okay.
I don't recall that part of the conversation, but if it's documented, it's documented.
All right. You deny it?
I'm not denying it.
So you agree that what you
Wow,
said
that was a lot.
that,
A little bit more anticipated.
okay. And you, Judge, I'm asking, we're talking about what he said.
Oh, go ahead.
What you said is that the people were talking and what they said was, I think it was over popcorn, something like that, right?
Okay.
Did you say that?
If that's what's written down, it's what I said. I don't recall saying that. I mean, I can't remember saying that, but if it's written down, it's written down. I must have said it
You remember walking into the theater 119?
because I looked at my phone.
Sustained.
You don't remember giving that sworn statement because it's different?
I didn't say it. I just don't recall exactly everything that I said.
So then to say that the only thing people talked about was that you were a hero is not true. You don't recall everything,
That's
right?
right. That's from today's perspective. The only thing that I recall, what you asked, is about the nurses being brave. That's all I remember.
And then now that you see your statement, now you can see there were other things as well.
Sustained.
All right, let's talk about something else. Now, once you're there in that group, people are obviously talking about what happens. You hear the word popcorn, you give a statement to police after that, right?
Okay.
Right?
It didn't. Whatever was said, it didn't change my views because I heard and I saw what I experienced.
You gave a statement after that. That's the question.
Yes.
And then when you're walking out of the theater, you and Miss Monero, one of the detectives introduces you to Sheriff Naco. Right?
Okay, I believe so.
Well, you remember that.
I remember meeting police officers. I don't know. I can't recall what Sheriff Knocker looks like.
You remember shaking his hand and introducing himself?
I honestly, I've met several police officers that day. I really don't recall.
Okay, so you don't recall whether is what you're telling us. You don't.
Yes, I don't. I spoke with several police, law enforcement. I can't recall who I saw and spoke with.
All right. Do you recall this then? Sometime after that, you get a communication from the sheriff's office. They want you to come to receive a plaque for heroism.
Okay, I remember that.
Do you remember that?
Yes.
And you received the plaque, right?
Okay.
Well, did you receive the plaque?
I did.
And the plaque says something to the effect of, for your brave, quick thinking in aid of another person in the event of a life-threatening situation, right?
I believe that's what the plaque says.
And I imagine when you made the acceptance speech, you said, I don't deserve this. There was somebody there before me. Did you tell them that?
I don't recall saying that there was someone there before me. I was just saying that I was just doing my job.
Did you tell anybody that there was somebody there before you helping this man?
I can't recall that.
And so now you receive a plaque from the sheriff's office. So really you're kind of beholding to the sheriff's office, the state attorney's office, aren't you?
Can you rephrase that, please?
Do you not understand the question?
No, I'm just trying to say what you're trying to get at.
I don't have any other questions, Judge.
Thank you. Redirect.
Yes. When Mr. Olson fell to the ground, or let me rephrase that. Where were you working on Mr. Olson?
So when I initially went over to Mr. Olson, I was at his head side. Sorry, I was at the top near his head.
Okay, and where was that located? Where was Mr. Olson's head?
Mr. Olson, if the aisle or the stairway is to the right, his head was towards the middle, like pointed towards the middle part of the aisle.
Was he on the ground?
He was on the ground,
Completely on the ground?
completely on the ground.
Because during cross, you mentioned that it was dim. Was that because he was on the ground?
I just think it was just the lighting conditions.
Because he was on the ground?
He was on the ground, yes. Because at that time, I don't think the full house lights were up yet.
I think you answered this on cross, but when you made the statement either before or simultaneously with the shot about throwing popcorn on the face, are you, because I think this might have been the question on cross, are you making that up because you received the plaque for helping save Chad Olson's life?
No.
Well, that was what the implied. Were you making up about the popcorn
I did not
because
make
you
that
saved
up.
Chad Olson's life?
I did not make that up.
Or trying to?
I heard those exact words. Throw popcorn at me.
And then you were asked whether or not you were aware that someone else was doing CPR. Do you remember that question?
Yes, because I remember when I was on call with 911, someone was doing. I asked someone to do chest compressions.
Okay, here's what I'm asking you. Was it important to you to look around and see how many people are helping you and maybe get their name? Or was it more important to help save Chad Olson's
It was
life?
more important to save Chad Olson's life.
I don't have any further questions.
Thank you. May this witness be released?
I'll be keeping my standby.
Okay. Mr. Friedhoff, you're free to go, but if you get a call and they want you back, you'll have to come back, okay?
Okay, thank you.
Thank you.
Thank you.
Okay, thank you. Thank you.
Oh my gosh. I don't know if I can not
Stay.
keep drinking. This is going to be rough, guys.
You may.
And I'm going to feel that swig I just took in a minute, probably. So you might get some entertainment at your breaks. Oh, God. Oh. Poor
We'll
guy's
be
Patrick.
taking a break
Hey,
before
you
we
gotta
get
get
into
you gotta get in what
anything
you gotta
lengthy,
get in
so don't
somehow. So
worry.
you know it's nothing personal. Am I okay? Whoa, what's wrong? I'm just. This is awful to watch. This is so difficult. These people are making this trial is 100 times harder than it needs to be. Rusty, well, there was an appeal in the middle of this. It sounds like the defendant broke his hip. Then also throw COVID in, and enough time. Oh, excuse me. We'll get you to 8 years pretty quickly. But I mean, you could be like, think about Travis Ranking. That was how many years? Like 4 years to do. So it's not that outlandish. It does take a couple of years the bigger a case gets. Oh, jeez, it's almost nap time.
At this time, stay with rest.
All right. Thank
Oh,
you,
wow.
Mr. Rosenwald, sir.
Ooh.
Ladies and actually.
Let's take a
okay.
break, but ooh.
I was going to let you go take a recess, but I think we'll.
Oh, don't do this, Judge.
The attorneys and myself will have some work to do following the rest by the state. So good time to let you go, correct? For the day? That's what we talked
You
about?
need a bowl,
Okay.
yeah.
All right. So I know it's early for you guys, but really is the best use of your time to just let you go on your own time? Because the lawyer, like I said, the lawyers and myself have some stuff.
They got to admit
It's going to
exhibits.
take a while that we have to talk about, and no sense having you hang around for that. So let's be back at 8:30 tomorrow morning. Tomorrow is Friday. Whew. All right. Just be back at 8:30. Remember my instructions during the recess. And thank you for your
Sorry.
patience this week thus far, and we'll see you in the
Yes,
morning.
they're done for the
Enjoy
day,
a little bit
Gabby.
of afternoon off. Any questions?
They're going to have to go through
Okay.
admitting
Thank you.
exhibits
I
at
think
this
the
point.
weather's
That's going
nice
to take
out
a
there.
while. There also might be some
do
evidentiary
they-
issues coming up.
You
I
guys,
don't know.
I guess I keep forgetting, come a little early to do your stuff with the clerk. Thanks.
Just told him when to come. That's a very dominating judge. Very dominating. There's Curtis. Would you like to buy a used car, sir? Yep, they're going to make
Throw
that motion
popcorn
now.
at me before the shot or not?
Oh,
It was
Oh.
at the same time.
what?
So it wasn't before the
Oh,
shot.
don't do
It
this to
was,
me.
maybe a second difference. One, it was so close.
Guess we're going to long crime. Okay, so we're going back to long crime since those other guys bailed on us. Okay, so I guess we got to go back to him. Matthew, you're 100% correct. It's probably not going to work. There's enough here to show that they've at least met the burden of probable cause, and that a jury can decide whether or not it's happened, and that murder was committed. You always ask it. What? Who cares about these stupid games and their ads? All right. So, yeah, they're going to ask for that motion dismissed. It will get denied, and then they're going to go in admitting all the exhibits. So every piece of evidence from the defense and the state is going to get scrutinized, and they're going to determine what's getting admitted that the jury would eventually get, and we'll go from there. Right now, everybody's just hanging tight and going to the bathroom. Maybe throw a nap in here too, because geez, I am tired. He just wanted to keep it going so we can get to the end. Yeah, although at this rate, I don't know if we want that. So, yeah, you guys got any questions about today? I mean, that's really where we are with stuff. Still I'm at this point. I'm not convinced beyond a reasonable doubt that he's guilty, so it's not guilty. That doesn't mean I don't think he did it, but just this isn't enough for me. Tasha, I hope you got my email. I sent you an email back, Tasha. How do I think the prosecution did? Like a C. They say C's get degrees, so it works. It works. It doesn't change much. It kind of gets you where you're going. Yes, turtle pace. Yes, turtle pace. Cheryl, the state rested their case. They are fully done. So they got to get through admitting evidence and admitting exhibits, and I assume there's going to be some evidentiary issues or things they have to discuss to prepare for tomorrow. So let the Elaine defense present their case. I just want to tell you guys I will not be available tomorrow. I've got a full day of meeting clients and getting stuff done and trial prep. So I'm not going to be on. I'll just be I'll be on maybe Long Crime or TV10 or whatever. If I'm on Long Crime, I'm on a different account that, like my personal account. I don't know if you guys know it exists, but I'm usually doing that. So, Lori, it hurts, but I don't know if that's going to be enough to convince a jury to say, is this beyond a reasonable doubt? I think they're going to convict them. I think they are. I think this narrative of, it was just a popcorn fight has been kind of baked into the cake already. So I think it's going to hurt them. This stuff I don't think is going to help them too much. I think it would help a truly impartial juror, but I don't know if you've got them. I mean, if you guys go back to listening to the jury selection, that was God, take these damn things off. That was multiple jurors said at the beginning, they thought this whole thing was bullshit and that this guy got murdered for no good reason. So, yeah, I don't think that's something good. Cheryl, it's not that I think there's doubt. I just don't think they've proven it. Yes, Eric, they're going to come back. What they're going to do is all the exhibits have to be actually admitted onto the record as accepted exhibits. So that all has to happen. You don't do that in front of the jury. No, Reeves shouldn't testify. I think they said they thought he would, but I don't see the point. I don't think it's a good idea. I don't think it's a good idea at all. Yeah, and Trina, everybody's got catching up to do on this trial. Most of them are catching up to do with their sanity or sleep from watching this trial. Oh, I'm not going to lie. On Monday when they were doing their opening arguments, guys, or what were they doing on Monday? I forget. I don't know. I was watching it. I was eating lunch in my office. I fell asleep. The secretary came in and woke me up because I was sawing logs. That's how boring this was. Yeah, Tasha, I don't know if he did or not. It's just he is not a sympathetic defendant is part of the issue here. And I just think that's part of it. But like I said, it's not that I think he's not guilty. It's just the state has not done a good enough job. It's not through, I have said it before, there's multiple ways you can look at the burden of proof. And beyond a reasonable doubt's like hitting a home run. And the prosecutor's playing home run derby right now, and he hit it, and it just didn't clear the fence. Either did or didn't. So, Matthew, once you're at that point where you're already in jury selection, it's really hard to get a change of venue. You would not get a change of venue to a different state. You could in the federal system probably get a change of venue like that, but in your state, no, because you're going to be in your state. I mean, the only place I could see that ever being an issue is like Rhode Island, maybe, because it's like, half the, size of my sidewalk. But no, you aren't allowed to go to different states in America. You're kind of stuck where you are. But Florida is a very big state. I don't know if you know this, Matthew, but from the southern tip of Florida all the way to the northern tip of Florida, or the northern edge of Florida by the state of Georgia, that's like 5.5, 6 hours. Florida is a massive state. And then if you want to go west along the panhandle, that's a bunch more hours. It is a very long drive there. So there's a lot of places you can go in Florida to get away from the publicity, but so Matthew, I would seriously go onto like Google Maps and check out how far it is from like the northern tip of Florida to the southern tip of Florida or to Miami. Driving down the coast is very long. Well, Joe, it's not necessarily that's long, but most people don't realize how big Florida is. Florida's a lot bigger than you give it credit for. So I think that's the bigger issue for a lot of people. They don't realize how big Florida is because a lot of people just fly into Miami or fly into Orlando, and that's their Florida experience. Um, Now, like it depends. Like you may live up in parts of like Beaver Fall. Yeah, going across Texas is massive, but I also mean driving across the Dakotas is horrible. So is driving across Montana. Yeah, you probably would you move to like Northwest Territory or something? Well, yes, Lori, going from Miami to the top to the bottom of the Florida Keys is hours too. But I'm just talking about the peninsula itself, the mainland. Yeah, Florida's big if you drive the whole panhandle too. Yeah, okay. I'll resend you the email I sent you then, Tasha. Oh. Oh, Robin, you're asking, can she purple ice? That actually is not a you can't the fact other people are around, who says they're gonna help? I mean, also, how do you know they're not gonna jump in and kick your ass too? You don't know who they are. You don't know if they're friends or whatever. They might be enemies. Those people have no obligation to jump in and break up a fight. So I'd be very careful about that. You can't rely on other people to get involved. Um, can she testify sitting in the courtroom? No, she should be being separated as a witness if she's testifying, and I don't think she is. Um, the victim's wife, Olson's wife, well, under Marcy's law and victims' rights laws, she can kind of have the right to be there, but after she testifies, she has the full right to sit there. But yeah, I don't think Reeves' wife is going to testify. That just seems really risky. Um, yeah, I just think that's super risky for what it is. So, I got to work on something real quick, guys. Give me 1 minute here. All right, I'm back. Hi, Linda. Thanks for joining us. If you're new here, thank you for joining. I appreciate it. If you guys like it, I do this whenever I can, working it in my schedule as an attorney. So, leave a like and subscribe. I appreciate it. Eventually, I can start shilling for Raid Shadow Legends at some point if I get enough subscriptions. Yeah, Linda, if you have questions, be happy to answer them. Wow. Okay, that's interesting. Hi, Facey McGee. I sorry, my friend told me to look this up, and I gotta show it to you guys because I think it's kind of hilarious. Um, so that is a Jesus, Guns, and Babies, regardless of your political stance. I mean, I'm glad there's stars there because otherwise you're like Jesus, guns, babies. I mean, does that mean babies have guns? I'm not sure about the. As long as it's in a list, I think that helps. But I'd be worried about the babies with guns. I would say Jesus too. But yeah, now we're just waiting. We're just waiting. Hey, you know what? Politics is cringe regardless. People do dumb shit all the time. I know Matthew may have seen this, but there was a TV show in the UK called The Thick of It, which just showed you how ridiculous politics was. It's kind of like The Office, except it's about political people. It's actually really funny, and unlike The Office, it's very funny. And yes, I just said The Office wasn't very funny. I will fight you on that every day of the week. Hello. Hi. You gonna lick the crumbs off the floor? Go for it. Come on. There you go. Yes, Malcolm Tucker is a great. Yes, he learned a lot of words from him. Now, the UK office is funnier, but that's not a high bar because the American office is horrible. And the puppy's gone. Sorry. Oh, Critter, I have no problem fighting you. I have no problem. The Office is an awful show. Like, I get it. Ha ha ha. The guy spilled the pot of chili. Excuse me. Yeah, Facey, I agree. Well, lavender latte sounds pretty good. Well, lavender makes you sleepy. At least it does to me. Yeah, welcome back, everybody. Yeah, I'm not sure what's happening, but well, lavender itself doesn't specifically have a taste, depending on how it's being served. But like lavender oil, that stuff I've had that used before, that puts me out. Groups coming in. Like, how big a group? How do I think the case is going? I'm not impressed. So I think he's not guilty because the state has not proven the case. Not that I don't think he was justified. I'm not sure he was justified. I lean towards he wasn't, but they gotta make it happen. So, Linda, you don't understand the stand your ground position. The way stand your ground works is in Florida. Think about it like in the sense of Kyle Rittenhouse. If you're 100% justified, you can say, Judge, I want you to look at the case now and make a preliminary ruling with a bunch of the evidence to look at. So it gets all laid out there. And the judge could say, you know what? This is clear self-defense. We're not going to do it. You have the right to stand your ground. End of story. Boom, done. If they say no, then the case goes on to normal. You have the right to claim self-defense. Now, in some states, the idea of standing your ground kind of gets bastardized and morphed into this idea you have no duty to retreat. So that's the issue. It kind of gets misused in some situations. Yeah, hi, Puppy. Puppy is being ridiculous. So, Linda, as far as the case dragging out, and we touched on this, but yeah, the case was going to drag on. There was an appeal that takes time. He got hurt. That takes time. There was COVID as well. That adds up after a while. Yeah, stand your ground does work at times for people. So I don't know why the hell they've been down for this long. Jeez. Oh, here we go.
All right. State having rested, are there any motions?
We would make under Rule of Criminal Procedure 3.3 a motion for judgment of acquittal in this matter. If I may argue from the seated position.
You may.
It'll be a little easier for me.
Go ahead.
Your Honor, we've got a case of Morgan v. State, which cites many cases in a forced proposition. It's a 5th District case. It's located at 127 Southern 3rd, 708. It's a 2013 case. And so this is why this case is unusual. To be honest with you, I was quite surprised that they were going to introduce Mr. Reeves' statement in this case, because normally, and I agree, this is
Cheryl, no, I am not, but I'll be talking about that tonight because the whole
because that first comes up when the defense does the presentation. What I was quite surprised that they did is that they put Mr. Reeves' statement in their case in chief. And that creates, I think, a problem for them. And this is why it creates a problem for them. That statement of Mr. Reeves has not been refuted by any single piece of evidence in this particular case. period. Let's look at what justifiable use of force is. Under the law, under both 776.
I like where this guy's going.
And 776, as the court recalls, it refers us also to 776.013. And so I'm going to read those again because I think it's important for us to keep this in mind. A person is justified in the use of deadly force and does not have a duty to retreat if he or she reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or to herself or another, or to prevent the imminent commission of a forcible felony. And so that's 776.012. As we know, there's a second section, which is B, which it says, under those circumstances also permitted under 776.013. So I'm going to read that. A person who is not engaged in an unlawful activity and who is attacked in any other place where he or she has the right to be, has no duty to retreat, and has the right to stand his or her ground and be forced with force, including deadly force, if he or she reasonably believes that it is necessary to do so to prevent death or great bodily harm to himself or herself or another, or to prevent the commission of a forcible felony. And we know that the law is clear that the danger does not have to be actual. So let's make that abundantly clear. I don't think the prosecution is going to disagree with this. The danger that Mr. Reeves perceived does not have to be actual. The only thing it has to be is that Mr. Reeves reasonably believed that he was in imminent danger from that observation. That is it.
It's very
And
true.
So when you take his particular statement, it was two statements as the court recalled. There was the first statement that was about 30 minutes. There was a second statement that was much shorter. He laid out the groundwork that this was a self-defense case and that, he was scared, and the reason that he was scared and that why he had to use his pistol and the fact that the phone was thrown at him, and the fact that, those particular hands were coming in his direction. So let's talk about the phone, because clearly the phone is a deadly weapon. Hey, their lead detective testified. The phone can be a deadly weapon, hands can be a deadly weapon, and both of those can kill. There's absolutely no doubt that there's evidence here that a phone was in between Mr. Reeves's legs immediately after he fired the shot that resulted in the death of Chad Olson.
Prosecutor, better get ready. It's not looking good.
Came quickly over to Mr. Reeves' side, looked down, and there it was. It has not been refuted. It has not been refuted in this particular case that Mr. Reeves says, I think that phone hit me in the head. That is an aggravated battery under any circumstance. You don't have to have serious bodily injury. You don't have to have any of that if you're throwing a deadly weapon to an individual and it strikes that individual. So we've got clearly an aggravated battery that has not been refuted under any circumstances. We also have a regular battery. We have a felony.
What about a car battery?
On a person 65 years of age or older on two occasions. One occasion, obviously, is the throwing of the phone. The second occasion is when they grabbed the popcorn and threw that popcorn at Mr. Reeves. That's a felony battery. To be honest with you, I'm sitting here and arguing this, but that's the law. I wish the law was a bit clearer, in differentiating, that particular, but it's a battery. If it's an unwanted touching, it's a battery. You know what else it is? And again, I almost feel a little silly arguing this, but it's a robbery. Because if you're threatening someone and in the act
It is
of
robbery
threatening someone,
by definition.
you grab that popcorn and you pull it and you throw it back at the individual's face. That is a robbery. Now, you don't even have to go there. You don't have to go to the robbery. In my opinion, you don't have to go anywhere because we have clearly a phone being thrown that Mr. Reeves says hit him in the head, and it's been not refuted. If the prosecution tries to argue that it was refuted because nobody saw it, that's not refuting. That's not refuting that particular fact. So, I think, Your Honor, and I'll be honest with you, I think the prosecution put themselves in a very bad position in placing that particular statement of Mr. Reeves, in trial in their case in chief. Because otherwise, we would be sitting here saying, okay, well, what do we have? at the end of the day. We have a bunch of their witnesses saying this happened. No witness talking about self-defense. This is very unusual, and we were, frankly, yesterday very, very pleased that they did what they did, because I think now it's clear, even in the light most favorable to the government, it is crystal clear that none of their evidence has refuted what Mr. Reeves said in that tape statement. So I would ask the court to grant us our judgment of acquittal. And by the way, on Nicole Olson, whatever intent Mr. Reeves had in defending himself against Chad Olson transfers to Nicole Olson. So he can't be, at this point in time, guilty of the aggravated battery of Nicole Olson either. And so it hasn't been refuted, Your Honor. I know that it's a tough decision for the court to make any time that the court is rendering a decision on a judgment of acquittal. But this record is crystal clear.
Thank you.
I have to agree with Mr. Escobar that this record is crystal clear. Unfortunately, I have to say it's crystal clear in the opposite direction. In taking the evidence in the light most favorable to the state, which of course is the burden at a judgment of acquittal argument, the state has put forth sufficient evidence to go forward to the jury on murder in the second degree as well as aggravated battery. I think Mr. Martin's going to handle the aggravated battery.
No relation.
It's kind of tied in just a tad with murder in the second degree. All the elements of murder in the second degree have in fact been proven. We have that Chad Olson was dead. It was done by a criminal act of the defendant, and it was done through an act that was imminently dangerous to another, evidencing a depraved mind with ill will, hatred, spite, or evil intent. I have some case law if the court wants to read it just about those other elements, but I don't think based on the arguments it's necessary. Really what the defense is indicating is that the state has to somehow rebut the defendant's allegation of self-defense, and because every single eyewitness indicated it didn't happen, somehow we have to accept the defendant's word. And I'm having a hard time wrapping my head around that. The evidence in this case is that every single witness that we called said the defendant's version of events simply didn't happen. There's a video and evidence that the court has reviewed and has seen in the past, and it's been played again during this trial, that absolutely with 100% certainty contradicts the defendant's story. There is a case that I can cite, and I can also present a copy to the court. It's Leisure. And I will, may I approach?
Yes.
It's a copy for defense counsel. It's Leisure 105, Southern 3rd, 5. It's the second DCA 2012. And basically what this case states is that the jury can outright reject any claim by a defendant. And we've put forth sufficient evidence, especially at this juncture, just that we're arguing about a judgment of acquittal, to rebut the defendant's allegations. There's some, I guess the defendant, according to the defense's argument, was definitively struck by a cell phone. The court would recall there has been no testimony or evidence of that whatsoever. In fact, the defendant himself doesn't know if he was hit by a phone. He says it might be possible, and the reason I think it might be possible is because, well, something happened, and I looked down at my feet, there's a cell phone, I'm putting two to two together, I guess it was a cell phone. Looking at it logically, and there's no secret in this case about this, had the defendant been struck with a cell phone, I think it'd be reasonable, and especially for an argument of JOA, that there would be some form of injury. Now, this some form of injury certainly isn't this left corner of the eye or eyelid injury, especially if it's being used as a deadly weapon. The definition of a deadly weapon is as follows, I'm sure the court knows this. A weapon is considered a deadly weapon if it's used in a way, I'm going to try to slow down. I get going, I get fast.
The fact the guy fucks up using the weapon doesn't make it less deadly. It's his intent.
It's the manner in which it was used. If he were to toss a cell phone, that wouldn't be an aggravated battery. That would be a battery because it touched or struck him against his will. Because he was over 65, it would be a felony battery, which is going to be my other argument. So if the court needs a copy, I can give the court a copy. I'm sure the court's aware of this. There's different standards within the self-defense instruction. there is an applicable forcible felony section, but there's just another section that only talks about the generic felony. Okay? In that section that talks about just the generic felony, I'm going to read it because I don't want to misquote it. It says, the use of deadly force is justifiable if the defendant reasonably believed. Let me stop there just for the JOA argument. There is no evidence at all that would support the defendant's contention that he reasonably believed at the time of the shooting he was going to die. I mean, that's basically what the instruction states, imminent death. So there is absolutely no evidence that at the time he fired that shot, he could reasonably believe he was about to die or suffer great bodily harm. At the time the shot's fired, there is no way in the world, based on the evidence presented through the witnesses in the video, he reasonably believes he was about to suffer great bodily harm. That's what the instruction states. So the use of deadly force is justifiable if the defendant reasonably believed. I submit all the evidence so far shows he certainly did not reasonably believe it. But anyway, going on, believe the force was necessary to prevent imminent death or great bodily harm while resisting. He's not resisting anything. And then it talks about an attempt to commit a felony upon him. So let's say the felony that's being suggested, which was what Mr. Escobar was arguing, is battery on someone over 65. It was over. He's not resisting anything. What happened was, his popcorn was tossed on him. That was done. Mr. Olson's hand was coming back. The act was complete. There's nothing he's resisting. It was done. And he decided, based on the evidence, that he was going to shoot and kill him at that point. So he wasn't resisting anything at that point. The robbery conversation, or I guess argument that Mr. Escobar made, the defendant himself states in his own tape statement, when Mr. Olson jumped up, the popcorn went by the wayside immediately. I don't know if it fell out of my hand or if he knocked it down. I don't know. There is no robbery. There was no force, violence, assault, creating fear that he was aware of. So that certainly wouldn't apply. And that's going to end up being my argument later on when we get the jury instructions. In the case that I presented to the court, it states, and I already alluded to it, and this case is even better for us than the argument I'm advancing, because in that case, the Leisure case, it states, even when there are no other witnesses to the event beside the defendant, because a lot of times there's a homicide and the only witness is the person who has passed away, a jury is not required to accept the defendant's testimony to support his or her self-defense theory as true. It must consider the probability or improbability of the defendant's credibility in light of the circumstances established by other evidence. Leisure's numerous inconsistent statements cast significant doubt on her assertions. And that's exactly what we have here, except for the fact that we have multiple witnesses who are saying what the defendant's stating took place didn't happen. And even if you discount all of those witnesses, the video indicates that it never happened. So there is no justifiable use of deadly force here, because at the time of the applicable battery, he wasn't resisting anything. But even if that argument was to be made, he could not, based on the facts and circumstances introduced in the evidence so far, reasonably believe that killing Mr. Olson was necessary to prevent his own death or great bodily harm occurring to himself. The facts, just real briefly, for just other elements, is that there has been a period of time within which that the defendant could develop animosity towards Mr. Olson. It was about 4 minutes between the initial encounter and the time of the shooting. And again, there's absolutely no evidence whatsoever that this was a lawful use of deadly force. And therefore, I would argue that the defendant's motions for judgment of acquittal should absolutely be denied.
Judge, if I may just have a couple of points here. Again, I think that, their problem, they're talking about this video. This video supports us. It doesn't support them. If you look at the video, you'll see it in about 8 to 10 seconds before the actual grabbing of the popcorn and throwing it back. You actually see Mr. Olson actually coming over the seat with a hand. It is at that time that Mr. Reeves in his statement is saying, hey, listen, I see him coming over. You can see it on the video. Take a look at it if you like. we've got it in circles that our expert has actually circled that
Go
particular
on.
area.
Go.
It was at that point in time that Mr. Reeves says, hey, listen, I believe that he hit me either with a phone or with a fist or something, but it hit me on my face. It knocked my glasses askew, and I was a little bit dazed at that point in time. That is an aggravated battery that has not been refuted. Guess what? There's not a single witness that they presented in this trial that refutes that. But then there's a second. Then what happens is about 8 to 10 seconds thereafter is when the hands start coming through. And I want you to look at the fractions of a second that it takes for the shot to take place. It's fractions of a second. It is an absolute impossibility for Mr. Reeves to have shot Mr. Olson because of popcorn. It's a human impossibility. But it doesn't matter because of the fact that nobody has refuted what Mr. Reeves said in that tape. Frankly, when we went home we were shocked that they had put those audios in because they were good for us. We were going to sit here on a judgment of acquittal and say, okay, well, Judge, we have a judgment of acquittal, and that's my argument. But when they put that in, I thought that they had made a huge mistake, and they have. Think of the witnesses.
I agree they did.
Presented before this court. Nicole Olson didn't see anything. Okay? Nothing whatsoever. Mr. Cummings doesn't refute what Mr. Reeves says in his statement. Certainly Mr. Hamilton doesn't because he's only seeing silhouettes. Okay? And certainly the lead detective doesn't.
We're done for now.
There is not a single witness that they've presented that refutes Mr. Reeves' statement in that oral tape, in that recorded tape. Nothing. And so what does that do? If you look at the Leisure case that they're talking about, I think Leisure, that motion of a judgment of acquittal that they're talking about happened at the end of both the state and the defense case. We're talking, and the case that I'm citing here, and we'll give a copy, they have a copy too. Some of the language is not good because normally in situations like this, may I approach? No. And you get one to the state. Normally, Your Honor, in these situations, if you look at Morgan starting on page 8, I'm going to read what the court says. The question of whether the defendant acted in justifiable self-defense is generally a question for the jury. I agree with that. It's a Supreme Court case that they're citing, Rimmel versus State, located at 532 Southern 2nd, 16. However, look what it says at the very bottom. However, a motion for judgment of acquittal based upon self-defense should not be granted unless the evidence is such that no view which the jury may lawfully take of it favorable to the opposing party can be sustained under the law. And the law, again, is the danger doesn't have to be real. It only has to be reasonably perceived by Mr. Reeves. They have not one scintilla of testimony that refutes his.
Guys, I'm sorry. I'm listening to this argument. I really want to hear
so
it, so I apologize for
they're
not
stuck
commenting.
with that particular tape. They put it on. They didn't put anything on to specifically refute his perception. And therefore, the court has to take that perception what it is because it hasn't been refuted. And this jury can't do anything with it because there's no evidence to contradict it. So I would ask the court, again, to look at 776.012, 776.013, and understand this. The law does not punish one that reasonably believes that they need to use that force to protect themselves against great bodily harm or death. They don't have to be right. They just have to reasonably believe. There's a big difference. That's the beauty of this law, because you can make a mistake in that whole process, and the law still is not going to punish you as long as you reasonably believed at that time. And we've got Mr. Reeves talking about his law enforcement career, talking about what he has done in that particular area that, again, was never refuted. And they didn't bring in any police officers to say, hey, Mr. Reeves wasn't
He's yelling because
a
he's
police
fired
officer.
up
He
and
didn't know
he's
anything about use of
going
force.
for the kill.
He was not commander.
He's just being
He
excited.
didn't know it. Just the opposite. They were silent on that. And so, Your Honor, I
Trust me, this is not yelling
We're
mode.
looking at every single witness here. They haven't refuted this, and they're stuck with that recording.
Thank you.
He thinks he's got this, and I don't blame him for pushing. He's got a good fucking argument right now.
All right, as far as the statement played of the interview of Mr. Reeves, I found that there was a great deal of evidence that refuted some of his statements. For instance, the whoa, 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 oh, no, no, no. Pretty much every witness that claims to have heard or seen something said they didn't hear that. And I know you've said several times now since the beginning of the trial about the 10 seconds prior in the video. It's clear to see that the defendant came over the decedent came over the chair and, was taking a swing or something at Mr. Reeves. I didn't see that. I looked hard as I could look, and I did not see that in the evidence that's before me at this point of the trial. So I think that evidence refutes the claim that there was the first attack that it's been called, and the lack of any marks that somewhat, but I agree with defense that wouldn't be enough on its own to refute that. But even in Mr. Reeves' own statement, he says in the second part that he's not sure. He's not sure if he got hit. He's second guessing himself. And I think with all of the evidence that's been presented, the state has overcome the motion for judgment of acquittal.
I don't know about that. I disagree.
All right.
But
What else
it's
do we need
reasonable
to
enough.
talk about today?
Judge, the only judgment of acquittal I heard was for second degree murder.
Oh, sorry. Yeah.
We argued for both.
Yeah, yeah. And this thing, you correctly identified the fact that with transferred intent, if you prevailed on the judgment of acquittal as to the second degree murder, I think that would apply to the aggravated battery. And you probably disagree, but
No.
Okay.
It doesn't.
Right, okay. I don't. I think, okay. Okay.
Do you need any further argument then I'll count?
No, I'll deny the motion in its entirety as to both counts. All right, do we have any other smaller motions that are still outstanding?
We're going to try to make them smaller later.
Okay, the main ones regarding the experts. Okay, I thought that was all we really had outstanding.
Yeah. We'll do the heavy lifting.
Okay.
I'll try to forward and see if we can narrow it down for the market.
All right. There's a lot of case law, on these issues, so hopefully you can do that.
Well, it's not going to be much more than that 100-page doubt motion I filed in part of case law. So if you read that, you know what the case law is as far as the state's concerned. That's what the state will be relying on.
Okay.
And Judge, I think we've got, I think 5 witnesses who will be here tomorrow.
Okay.
So I think that should hopefully, Smith is gonna be long.
Yeah,
you
I
know, and so
figured.
I'm thinking 5.
Uh-huh.
The defense starts tomorrow, Linda.
Okay.
We'll see if maybe there's we'll get you a list, absolutely. We will see.
It's a big courtroom.
Squeeze in a 6 if we find someone that's available.
Okay.
We normally were supposed to give them a day ahead notice.
Right.
So
They
we-
appreciate that.
We got 5, for
Okay.
sure.
If they're local and, retired or can get off work or whatever, but
There seems to be a lot of retired people in this class.
fortunately so. All right, so how are we looking then
little
for
sister.
time? realistically?
Chris Farley's
I
little
think it's gonna
sister.
take us next week.
Do you think you can be done by Thursday?
We will try our best. I can tell you more tomorrow. We'll talk about it.
Okay.
You know, we'll
Yeah,
see
see
what the
how
lineup is
tomorrow
gonna be
goes.
for
How the hell can it not be done by next Thursday? Jeez.
Monday and Tuesday,
Mm-hmm.
and see if we can get our list of witnesses. I'd like to try to, put as many witnesses, quickly. The problem that we have is we have Dr. Foley, who is a practicing radiologist, so we're gonna have to fit him in somewhere. And we've got our Jacksonville expert that.
Is that
coming from
Dr.
Jacksonville.
Cohen
That's a Knox.
or Knox? Okay.
And there's still an
Coding is
issue,
easy.
there's still an issue with Mr. Knox because of those, my Daubert motions haven't occurred on it.
Okay.
So, and
Right.
It wanted to be during trial, so.
Right. I know. So yeah, that's.
The transcripts. You got the transcripts.
I do.
Right, and you have, I think both sides have thoroughly briefed the issue.
Yes, you have.
So.
Yeah. So
if
hopefully.
The court has read and absorbed that, then the court's decision.
Yeah.
With the testimony should.
What else what else?
Hopefully
Come on,
we can
guys.
get that with minimal
Guys should be done by Monday.
delay. But yeah, that certainly will help. The fact that you've briefed thoroughly and I've read the transcripts. So. Okay.
Yes, Matthew. So that leaves a lot of people in Pasco County,
right.
Florida, to call. 400,000
Our
of them.
fingers crossed. All right. Well, I guess we'll have an early day today then. I'm sure none of us mind that.
No, I don't
telling
mind it
you,
either.
And I just want to take the opportunity. Thank you all. So far, so good. Everybody's been doing a great job.
That's different, puppy.
It's a tiresome job on you guys' part, but you've all done really well. So I appreciate that. Thanks. All right. We'll see you at 8:30 in the morning then. Thanks, everybody.
Okay. I disagree. I think they had a good argument. I think it was Linda. You may have brought this up, and if it wasn't you, I apologize. The issue about the injuries not being present. I mean, think about it this way. If I attack you with a dull sword and I start chopping at you, but it turns out the sword was dull, I mean, that doesn't mean it was like, it's not for a lack of trying. Or if I start trying to punch you, but the punches aren't, really scoring hits, it's not for a lack of trying that I'm trying to strike you and cause you injury. So that's why the lack of an injury doesn't defeat a claim of self-defense. It just makes it, a credibility issue. I don't think the defense did a good job of bringing up, well, all these witnesses are telling the same story. We have a concern about it. They let that go, and I think they should have brought that up. But yeah, we'll talk about this more tonight, guys. I got to take care of some errands in the meantime, and I will see you guys tonight at 9:30. And yeah, we'll go from there. Paul, we'll cover tonight. We'll cover tonight what's going on. Yeah, guys, so I don't want to talk too much, so I'll kind of ruin my thunder for tonight. So, guys, I will see you in a couple hours.